ಆಯಿತು. ಓಕೆ, ಚೆಕ್ ಮಾಡ್ಕೊತೀನಿ.
ಅಯ್ಯೋ ಕಡಿಮೆ ಒಂದಿನ ಅದು ಬಂದ್ಬಿಡುತ್ತೇನೆ ಅವಾಗ ಏನಾಗುತ್ತೆ ಬಂದು ಲೇಬರ್ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಜಾಸ್ತಿ ಬರ್ಬೇಕು ಬಂದ್ಮೇಲೆ ಕೊಡಿ
RSA for admission, my lord. On admission matter tomorrow, my lord.
Final hearing matter, not posted for hearing. The last date was in January 25. Say, matter where all the parties are serious citizens. Final hearing, I am requesting.
Serial number 18, you are.
Your Lordship, one small submission. There's a fresh. Lordships of fresh.
It's only in the
Urgency, Your Lordship. Fresh matter urgency is there. The construction has been commenced by the respondent. Much of it.
My lord, it's a fresh matter. It's an RSA matter. Warrant has been issued for the parties to evict the property, my lords. Kindly posted for today at 3 o'clock, my lord. Tomorrow. Much obliged.
mentioning from page number 8, 25 to 30, 31 to 40.
Lord, 24, my lord.
Serial
34, my lord. Serial number 34. Not keeping too well today. Any date may be fixed, my lord. Next week, my lord. Kindly.
Serial number
30.
serial of party, my lord. Serial of party, my lord. Our senior is not keeping well, my lord.
Sayyid Akbar Pasha.
Senior not keeping well, Mantesh was. He is not keeping well. I had admitted in hospital.
Forty-one to 46,
Lord, serial number 45. It may be taken up tomorrow, my lord, along with other connected matters. Nenne is Nenne. Much of.
47 to 53.
I mentioned serial number 47, my lord. And for the respondent in 47, my lord, I seek for a week's accommodation. I've informed the appellant counsel. 47, my lord. My lord, serial number 47 could I mention, my lord? My lord, 47, my lord, could it be adjourned by a week, my lord? And for the 47, I'm for the respondent, my lord, I've informed the appellant. I have informed the appellant, my lord, I am for the respondent. I seek for a week's accommodation, my lord. Please, my lord. My lord, the counsel on record, my lord, has some medical inconvenience today, my lord. That's the reason I'm asking for an adjournment.
Order serial number 1, CM Nagabhushan.
For the respondents, matter, my lord. The Supreme Court has stayed this matter. Supreme Court has stayed this matter. Happy finish. Disposal ಆಗಿತ್ತು. Matter has been remanded back to trial court. Stay ಮಾಡಿದ್ರು. ಅಲ್ಲಿ ಹಾಕಿದೀವಿ ಸರ್ ನಾನು ಮತ್ತೆ ಬಂದಿದೆ ಯಾಕೆ ಬಂದಿದ್ದೆ ಗೊತ್ತಿಲ್ಲ ಸರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಯಾಕೆ ಅವತ್ತೇ ಹಾಕ್ಬಿಡಿ ಸೆಪ್ಟೆಂಬರ್ 1ಗೆ ಹಾಕಿದ್ದೀನಿ ನಾನು ಆಗಸ್ಟ್ ಸೆಪ್ಟೆಂಬರ್ಗೆ ಹಾಕಿದ್ದೀನಿ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀವಿ ಅದು ಯಾಕೆ ಬಂತು ಗೊತ್ತಿಲ್ಲ 26/8 26 ಓಕೆ ಅದೇ
that matter already stayed with the apex court. And that's question of extension of time doesn't arise.
ಹೋಗಿದೆ
and the trial court is directed to proceed subsequent to the disposal of the appeal filed before the apex court.
serial number 2, Balagangadhara G.
Please, 2 weeks time granted, my lord.
R5.
Please, 2 weeks time granted, my lord. Please, connected matter the same, my lord. Same, respondent private. Please. ಅದು ನೋಡ್ತೀವಿ ಸರ್ ಮೇಲೆ ನೋಡ್ತೀವಿ ಅದು ನೋಡ್ತೀವಿ ಸರ್ ಆಯ್ತು ಇಲ್ಲ ಅಲ್ಲ
ಫಸ್ಟ್ ನೀವು ಡಿಲೀಟ್ ಮಾಡಿ ಆರ್ಡರ್ 21/7/22ನೇ ಆರ್ಡರ್
ಇಲ್ಲ ಆಫೀಸಲ್ಲಿ ಅದೇ ವೆರಿಫೈ ಮಾಡ್ತೀನಿ ಸರ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನಾನು ಒಂದು ಡೇಟ್ ಕೊಡಿ ಸರ್ ನಾನು
3,
Sole respondent, right? I prefer 2 weeks time to file necessary application to bring the LRs of us also.
Opponent counsel seeks time to bring the LRs of respondent. The next this matter on
30 10.
Till then, interim order to continue. Please.
Serial number 4.
This case appear for, pray for 1 week. Pray for 1 week.
No, I have more than minimum.
Not known ಅಂತ postal share ಬಂದಿದೆ ಸರ್. ಇನ್ನೊಂದು ಸತಿ ಕೊಡ್ಬೇಕು. PF ಕೊಡ್ಬೇಕು.
I have more than
For
minimum.
he has moved.
Respondents.
Respondent has moved.
Please.
Apparent counsel seeks weeks time na?
Please.
Weeks time to take steps against start to discuss matter on other date.
25.
25
Please.
Much
Serial number 5. Shivashankar K.
The R1 already expired and LRs are already on record. Minutes are 15 to 8 to 15 and 20 to 22. Minutes the notice may be dispensed because they are not represented before the trial court. I'll file a memo.
Apparent counsel files memo. Dispense the notice against RA
15 and 20 to 22. Minutes.
8 to 15 and 20.
20 to 22. 20 to
Then notice against on the ground that
Both the-
represented before the trial court.
both the courts. Minutes. Both the courts.
Happy for respondent, LRs of R2.
Yes.
But in 5 and 6 is such a
They are same. Minutes. They are the LRs of plaintiff. They are represented before.
They are
the-
dead. ಅವ್ರು LRs ತರಬೇಕು ನೀವು ಅವರು
Already on record.
5 ವಾರಕ್ಕೆ 5 ವಾರ they are dead. ಹೌದು.
Then you have to report. Minutes.
ಅಲ್ಲ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ನನಗೆ ಗೊತ್ತಿರೋದು ಇವಾಗ ನೀವು ಇದು ಮಾಡಬೇಕು.
ನಿಮ್ಗೆ ಗೊತ್ತಿದ್ದೇ ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲಲ್ಲ ಈಗ ನನಗೆ ಗೊತ್ತಾಗಿದೆ. ಉಳಿದರೆ
ಎಲ್ಲರೂ R1 LRs. Minutes. They are the plaintiffs before the trial court.
Counsel for R2 A to C, 3, 4 and 7 submit that R5 and 6 are also no more. But hence, apparent counsel is directed to verify and bring the LRs of R5 and 6. And let us within 2 weeks. This is matter treated. R1 is just, R1 is about.
R1 already.
R1
expired and LRs are already on.
already on record.
She is the mother of the.
Counsel says that R1 is no more and ಅದಕ್ಕೆ memo ಹಾಕಿದ್ದೀರಾ?
Okay, minutes. 20th April 2023.
R1
24, 23 ರಿಪೋರ್ಟ್ ಮಾಡಿ. Memo has been filed.
2 to 7 are the LRs.
that goes R1 already, R1 is no more and already his LRs are already a government question of taking of steps. Doesn't arise.
Serial number 6. PF Kumbat.
I appear for the appellant
Sir,
in
Mr.
respect of
Parikh,
25A and B.
Mr. Parikh, Kumbat.
And B,
25,
A.
respondent number 25A, Lakshmi Devamma. 25B, Geeta B.
26.
Respondent number 26B,
B to D.
Rekha R. 26C, Lata R. 26D, Arun Kumar R. 26E, Lakshmi R.
B, C and D. E is already served.
counsel for the appellant files memo along with paper publication. And the respective respondents were part of the report and their absent. And then said sufficient against the respective respondents.
Sir, ಅವಾಗ
That
ಸರ್, ಅಲ್ಲೂ
applications,
ಆಗ್ಬೇಕಾಗುತ್ತೆ
applications,
ಸರ್. 25ಕ್ಕೆ ಮತ್ತೆ
20, 26.
26 ಪುಸ್ತಕವಾಗಿದೆಯಾ?
That 26B to D, that
ಕನ್ನಡ 124. 3 of 24, layer number 4 of 24 to layer number 6 of 24. These respective applications are filed for meeting the laws of received respondent for 25 and 26. Notices are issued against them and some of them are represented and some of have been held sufficient to paper publication. And none of them have been represented and oppose the application and hence for the reason stated in the accompanying application and of it, yes are allowed. Permitted to bring the LRs on record. Appellant counsel is directed to amend the class title and file amended class title within 2 weeks. Admit agide illa.
no, it is not yet admitted and
Matter for admission on 30th.
oblast.
Serial number 7. Bol Gopala Krishnamurthy.
I'm filing dispensation memo in respect of respondent number 5, my lord. In respect of respondent number 1 and 11, I will take steps, my lord. Please. No, my lord. Why? Because, my lord, he is the person who has sold the suitable property. My lord, we have taken a chance, but my lord, he is avoiding the service of summons. Please. ಇಲ್ಲ ತಗೊಂತೀನಿ ಸರ್ R1 and R11. Please. 2 weeks time can be. Because my lord, they are avoid respondent number 4, my lord, who is representing Caveator, my lord, who is none other than the younger sister of R1 and R11 only. ಅವರು ಅದಕ್ಕೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ. Please. Please. Grateful. Please. This is the R1. Yes, ma'am. Please. Grateful.
Serial number 8. Mahesh
For the appellants. Settle ಆಗಿದೆ. Respondent. Much obliged.
9.
For the appellant, my lord.
Respondent number 3B, Mangalamma.
Swami, so it is under the final decree proceedings. The property is total by 20. 2 properties are there. It is not. ಅಲ್ಲ ಆಗಿದೆ ಅದನ್ನು ಹೇಳಿದಾಗ ಇದನ್ನು ಫಸ್ಟ್ ಲೆಟ್ ಇಟ್ ಬಿ ಸರ್ವಿಸ್ ಆಫ್ notice to complete we will see later, because it is the property has to be put it for auction and distributed 1/5 share to each of the parties. Regarding my lord, kind permission. Regarding my lord, arising out, ಅಲ್ಲ ಬೇಕಾಗಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕೆಂತ not necessary, because the it is arising out of the final decree proceedings. The property is 20/12 and 13/12. So 2 small properties are there. It is not possible for divisible 1/5 share to each of the parties. So it has to be put it for action and the amount has to be distributed. ಅಲ್ಲೆಲ್ಲ ಮಾಡಿದೀವಿ ಸಮೇತ ಆಗ್ತಾ ಇಲ್ಲ, ಅದಕ್ಕೆ ಇಲ್ಲಿ ಬಂದಿತ್ತು. ಇಲ್ಲ ಅಲ್ಲ, this honorable court has to direct them to put it for action and distribute it. ಅಷ್ಟೇ ಸಮ 1/5 share ಅಮೌಂಟ್ ಅನ್ನ ತಗೊಳ್ಳಿ ಅಂದ್ರೆ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಹೌಸ್ ಪ್ರಾಪರ್ಟಿ ಒಂದಿದೆ, ಒಂದು ವೇಕೆಂಟ್ ಸೈಟ್ ಇದೆ, ಒಂದು ಶೆಡ್ ಇದೆ, ಅಷ್ಟೇ ಸರ್. ಅಲ್ಲ ಎಲ್ಲನೂ ಮಾಡ್ಬೋದು ಸರ್, ಯಾಕೆಂದ್ರೆ ಅಲ್ಲ ಆಗ್ಬೋದು ಆಗ್ಬೋದು ಸರ್. ಓಕೆ, much obliged.
10. Chandrasekhara GM.
For the respondent, my lordship will pay the PF, my lord. So the matter is will be settled. Please refer it to the mediation, my lordship.
Mediation.
Yes, please, your lordship.
Petition number 2
ಗೊತ್ತಿಲ್ಲ ಮೇಡಮ್.
ಏನ್ರಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಟ್ಟರು ಮಾತಾಡ್ತಾ ಇದ್ದಾರಲ್ಲ
ಸೀನಿಯರ್
Pakas filed by Gopala Krishna on behalf of petitioner number 2.
I am for the respondent number 1.
Council ಅಂತಂದ್ರೆ ನಮ್ಮ ಇರ್ಬೇಕಲ್ಲ, ನಮ್ಮ ಇರ್ಬೇಕು, ಯಾಕೆ ನೀವೇ ಗೋಪಾಲ ಕೃಷ್ಣನ?
I am for respondent number 1, your lordship.
Petition number 2.
1. How to say?
Yeah, petitioner. ಎರಡು ಒಕ್ಕಲ ಯಾರಿಗದು R2 R5 ಗೋಪಾಲ ಕೃಷ್ಣ ಇದ್ದಾರೆ ಆರ್ ಗೋಪಾಲ ಕೃಷ್ಣ ಅವರು ಆರ್ ಗೋಪಾಲ ಕೃಷ್ಣನ್ the Wakala tried for petition number 2 is not pressed and then dismissed as not pressed. Appellant number 2.
Petition number.
Not pressed on 2 days. Then dismiss. Wakala tried by for the appellant number 2. Petition number 2. Not pressed and then dismissed as not pressed. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ mediation ಇದೆ ರೆಫರ್ ಮಾಡಿ ಏನು ಮಾಡೋದು
That was the one week time may be granted, my lords. Yes. Please, your lordship.
11.
To consent is a mediation is consent. On payment of
Court fees has already been paid, my lord, on 9th June 2025. 9th June 2025. ಇದೆ ಹಾಕಿಲ್ಲ ಹಾಕ್ತೀನಿ ಅದು ನಾನು ಈಗಲೇ ರೆಡಿ ಮಾಡ್ತೀನಿ ಈಗಲೇ ಹಾಕ್ತೀನಿ ಎಸ್ my lord, my lord, on 9th June 2025. 2025.
Hence, the council is directed to produce the receipt in the office regarding the complaints is concerned. And this matter on November 14th.
Yes. Much obliged.
Hearing on IA 12. R. Shashi Kumar.
Recalling application for the recalling order dated 22/24.
My lord, in this matter, my lord, this matter was disposed, my lord, on merit, my lord. Recall application. ಹೌದು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಬರಲಿ ಹೌದು ಸರ್ ಎಸ್ ಮೇಲೆ ಬಂದಿದೆ ಎಕ್ಸ್ಪರ್ಟ್ ಒಪಿನಿಯನ್ಗೆ ರೆಫರ್ ಮಾಡಿ
13.
Appearing for appellant, my lords. Recalling, my lords, now it was dismissed for non-compliance of office objection before the registrar. 2 times the matter was registered, my lord. Yes, my lords. 3rd time it was dismissed. Now the office objections are complied, my lords.
Matter was listed before the court on 29/3/24. 4 weeks time was granted for compliance of office. Again, matter was listed before the court on 22/2/22. Once again, 3 weeks time was granted. The council did not comply with office objections. Again, matter was listed before the on 24/8/22. Once again, order. Place the matter before the court.
My lords, the last date of hearing the matter was listed.
It as provided under 17th earlier. Time was exceeded by the honorable court. Under these circumstances, the subject petitions will be placed before the honorable court. Accordingly, petitions will be placed before the court. 24/8/22 order.
My lords, the matter is
Convert in the open court. Not registering. In spite of time accorded to the appellate petitioner as provided, not been complied as such.
lordship, those earlier orders I can't see.
4 weeks ಒಂದ್ಸರಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಮತ್ತೊಂದ್ಸರಿ 3 weeks ಕೊಟ್ಟಿದ್ದಾರೆ. Why you are not complied with office objections?
Now the office objections are complaint. Now it is complaint, my lords.
comply with the dismissal of
My lords, the last date of hearing matter came before this court. The time was, yes, my lords. Last date of hearing.
consideration of amendment is permitted to comply with office
It is complete. Yes, my lords.
This court made order dated 7/4/25, given time of contact with office on 23. And in view of the said direction, office objections are complained and for the reasons stated in the accompanying application. I-1/23 is allowed and dismissal order dated 6/2/23 is hereby required. Post the matter for admission.
Much obliged. Much obliged, my lords.
14. Sharad Kumar.
Please, Marcel. There is an IA1 for stay 1 of 21 ಹಾಕಿದೀವಿ.
21 legal stay.
IA1 of 24. What execution? Paper book I filed within 4 weeks. Admit ಆಗಿ 14/9/21 ನಲ್ಲಿ 14/9/21.
21 ನಲ್ಲಿ but ಅವಾಗ
14/9/21 ನಲ್ಲಿ.
Please.
ಆಮೇಲೆ ಎಷ್ಟು
ಇಲ್ಲ ಈಗ ಫಸ್ಟ್ ಟೈಮ್
ಅವಾಗ ಪೇಪರ್ ಬುಕ್
ಅದು
ಕೊಡೋದು ಬೇಡ ನಾ ಅಡ್ಮಿಟ್ ಆದ ತಕ್ಷಣ ಪೇಪರ್ ಬುಕ್
ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನಾಯ್ತು ಅಂದ್ರೆ ಬೋತ್ ಪಾರ್ಟೀಸ್ ವರ್ ಹರ್ಡ್. ಆಮೇಲೆ 14/9/91 substantial question was framed and the matter was pending. ಅಲ್ಲಿ execution they have filed execution now stating that admit ಆಗಿರ್ಬೋದು ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಪೇಪರ್ ಬುಕ್ ನಾನು ಹಾಕ್ತೀನಿ ಇದು ಅದರಲ್ಲಿ ಐ ಪ್ರೊಡ್ಯೂಸ್ ಆರ್ಡರ್ ಶೀಟ್ ಆಫ್ ದ ಎಕ್ಸಿಕ್ಯೂಟ್ ಅದೇ ಅದ್ರಲ್ಲಿ ನಾವು ಯಾರು ಪೊಸಿಷನ್ ಆಫ್ ದ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇತ್ತು ಅಂತ ಪ್ಲೀಸ್ ಹೌದು
Next week.
ಪ್ಲೀಸ್ ಮಾಡಿ after 2 weeks 30th ಅಥವಾ
ಒಂದು ವಾರ ನಿಮಗೆ 2 ವಾರ
ಇಲ್ಲ
ನೀವೇ ಅಪೀಲ್ ಹಾಕಿ ಬಂದಿರೋ
ಅದರಲ್ಲಿ ಪ್ಲೀಸ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಪೇಪರ್ಸ್ ಇನ್ನೂ ಬೇಕಾಗಬಹುದು ಪ್ಲೀಸ್ ಮಾಡಿ ಅದರಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಇಟ್ ಹಸ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ದೇ ಪ್ರೊಡ್ಯೂಸ್ ಸಮ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಟು ಶೋ ದಟ್ ಪ್ಲೀಸ್ ಮಾಡಿ ಟು ಶೋ ದ ಪೊಸಿಷನ್ ಪ್ಲೀಸ್ 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 ಬಂದಿದೆ ಪ್ಲೀಸ್ ಇಲ್ಲ ನಾವು ಮಾಡ್ತೀನಿ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದ್ರೆ
ಈಗ 4 ವರ್ಷದ ಮೇಲೆ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್
ಅಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಸ್ಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಪ್ಲೀಸ್
50. ಸುನಿಲ್ ಕುಮಾರ್ H. ಅದು ಒಂದು ಸತ್ತೋಗಿರುತ್ತೆ.
Sorry for the appellant. Your lordship, in this case,
ಹಾಕಿದ್ದಾರೆ ಸರ್ because ಎಲ್ಲಾದ್ರೂ ಫಾರ್ ಬಂತು.
my lordship, in this case, the appellant also expired, my lord, recently. Kindly permit us to file the necessary application. Yes, please.
Chandrasekhar. Order A number 422. Same is right for bringing LRs of cases for respondent. Record. This court has issued notice and they have been arrested to counsel. They are not provided any objections to IA. Reason stated in the accompanying application. Yes, are allowed to bring LRs and amendment of amendment is set aside. And council is directed to amend the cost title and file. Amended cost title within 2 weeks. Amend the appeal number and file amended cost title. Within 2 weeks. Amendment council also says that the amendment is also no more.
Expert. Please, ma'am.
2 weeks time and next 2 weeks time granted to bring the LRs of current. This is matter of procedure. ಅಷ್ಟೊಳಗೆಲ್ಲ amendment ಎಲ್ಲ ಮಾಡ್ಕೊಳ್ಳಿ ರಿಯಾಕ್ಟ್.
Please, ma'am.
16.
Respondent gave it, ma'am.
ಏನು ಡಿಸ್ಮಿಸ್ ಆಗಿಲ್ಲ ಕ್ಲಿಯರ್.
ಹೌದು ಸರ್. They are not taken.
ಎಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ನೀವೆಲ್ಲ
ಇಲ್ಲ gave it up.
ಎಲ್ಲ ಯಾರು ಆಲ್ಬಮ್ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ ನೋಡಿ.
ಹೌದು ಸರ್.
16
The appellants in this matter. Yes, ma'am. The recall, dismiss for non-prosecution.
9-10.
9-10. Yes, ma'am.
Dismiss ಆಗುವಾಗ ಏನ್ ರೀಸನ್ಸ್ ಬಂದಿದೆ? ಆರ್ಡರ್ ಇದೆಯಾ? ಇನ್ಕ್ಲೂಡ್ ಆರ್ಡರ್ dismissal ಆರ್ಡರ್ ಇದೆಯಾ? Both. This court when the matter was listed fifth time for non-compliance of office objection. Order to pay cost of rupees 1,000. Comply with office objection. Also made it clear that if office objections are not complied and cost is not paid, is the matter cost is paid. And the council once again seeks time to comply with office objection, and there is no meaning in once again granting time to comply with office. Dismiss for non-compliance.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅವರು I am sorry, my lord, ಅವ್ರಿಗೆ due to the illness, my lord, the appellant could not come out to Bangalore. Due to the illness, my lord, the appellant could not come out to Bangalore to. Yes, ma'am. I will ready to pay the cost.
ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ, ಕಾಸ್ಟ್ ಕೊಟ್ಟಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು?
ಮಾಡ್ತೀನಿ within a week ಮಾಡ್ತೀನಿ ಸರ್.
Within a week.
Please, ma'am.
ನೋಡಿ, pending consideration of A number 2 of 25 and 1 of 25, cost of rupees 1,000 each. Appellant is given 1 week time comply with office objection since the earlier matter was listed for fifth time for non-compliance. The order also made it clear that it is not complied. Appeal will be dismissed and hence the same is dismissed. This matter on submitted.
Oh, please, ma'am. Please.
Concurrent pending.
In favor of my lord.
Concurrent pending.
I will convince them. I will convince.
Copy, they have not served the copy of the.
Court
Council is also directed to serve the copy of the appeal memo on the council who appears on behalf of the KVTA respondent. KVTA andala ಬೇರೆಯವರು ಇದ್ದಾರಾ?
ಇಲ್ಲ.
The sole
respondent my lord died.
It will cast in favor of my lord.
Cast registry.
Please, ma'am.
17.
Cast is payable at registry.
17 Prakashyam.
For the respondent.
Filing the appeal.
Filing.
Is the matter for admission along with IA on 13th.
18 KV Satish Chandra.
Also same.
19
also same.
19 to the respondent. Copies please.
IA to condemnation of delay.
Apparent counsel is directed to serve a copy of the appeal memo on the council appeals to the respondent. So ಮಾಡಿ ಬನ್ನಿ 30.
20 Krishnamurthy P.
During after filing, after the judgment of the appellate court, he died, my lords, after 20 days. And the LRs are filing the appeal with, for that reason. IA1 ಅದಕ್ಕೆ ಹಾಕಿದ್ದೇನೆ, IA2 for LR application for bringing them. ಎರಡು in type.
Permission is sought to prosecute the appeal on the ground that the
Plaintiff, original plaintiff
passed away
on 1910.
after passing of the judgment by the appellate court.
Yes.
And also A number 2 of 24 is filed for bringing LRs, original plaintiff LRs, and for the reason stated in the accompanying application of permit. Copy serve ಮಾಡಿದ್ರೆ ಅದರ ಸೈಡ್ಗೆ
ಅಲ್ಲ ಸರ್, ಇದು ಇನ್ನು ನೋಟಿಸ್ ಆಗಿಲ್ಲ.
ಯಾರಿದಾರಲ್ಲ ಮೋಹನ್ ವೀಕೆಂಡ್ ಅಪೀಲ್ ಆಗಿಲ್ಲ.
ಮೋಸ್ಟ್ಲಿ ಕೇವೇಟ್ ಹಾಕಿರ್ಬೇಕು.
ಇಲ್ಲ ಸರ್, ಅವರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ ಬಿಫೋರ್ ಆರ್ಡರ್ ಆಫ್ಟರ್ ನೋಟಿಸ್ ಅದಕ್ಕೆ ವಕಾಲತ್ ವಾಲಂಟರಿ.
The permission is sought only on account of death of original plaintiff. That after passing of an order by the appellate court. Hence, IA1 of 24 is allowed given permission to prosecute the appeal and permitted to come on record as a loss, as filed in A number 2 of 24. But team already ಮಾಡಿಬಿಟ್ಟಿದ್ದೀರಿ. ಮತ್ತೆ amendment necessary. You have already quite enough, already arranged them as parties. Next, list this matter for admission on the detail.
Allah, first week, 30, 10. 10th.
10/11,
Ah, please.
21. Withdraw of fee.
Please, Lord.
22. 23.
What is second matter, your lordship?
Yes, yes, my lord.
What is second matter, instead of 30th?
22nd, 30th.
I'm not available. First week.
Now, wait.
First week of.
Give every date. In Irades, number
4/11.
4/11.
23.
Appellant is must. My lord, the appellant is not made the party to the before the trial court, my lord. In fact, the scheduled property was purchased on 3/3/2025. Appellant, my lord, from the different number.
25.
Yes, my lord, 3/3/20. How subsequent to the purchase, the decree has been passed. The collusive decree has been passed, my lord. ಅದರಲ್ಲಿ ನನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ. They have not made the party to the proceedings. My lord, 9/4/2025. 2025. 3/3/2025. ನಾನು ಸೇಲ್ ಮಾಡಿ ಆದ್ಮೇಲೆ they have got the decree, my lord.
The appellant was not made as party in the compromise decree dated 9/4/2025, and he submitted that he had purchased the property on
2025 from the defendant number 4.
25 from
Defendant number 4.
defendant number 4.
Yes.
And suppressing the setback, collusion decree is obtained, and for the reasons stated in the public application document, permitted to prosecute the appeal. For admission.
Started in admission 24. KV Narasimhan. Varadarajan LS.
We got the land surveyed. My lord, the survey sketch, my lord, I have produced as an additional document. My lord, we have spoken, my lord, with the respondent. On a given day, my lord, we'll go to the spot. My lord, 4 acres is the land, my lord, that they have got. My lord, accordingly, my lord, will show their position. Adjacent, ನಾನು ಪೂರ್ವಕ್ಕಿದ್ದೀನಿ, ಅವ್ರು ಪಶ್ಚಿಮಕ್ಕಿದ್ದಾರೆ. ನನಗೂ ಕ್ರಯ ಪತ್ರ ಇದೆ, ಅವ್ರಿಗೂ ಕ್ರಯ ಪತ್ರ ಇದೆ. Now, my client, my lord, promises that their land would be kept intact without any difficulty. Rest, my lord, we'll have the enjoyment. My lord, we'll do it, my lord, a week or my lord 10 days thereafter. Adbittu, we'll do. Probably, yes, ma'am. Yes. ಇನ್ನೊಂದು ವಾರ ಇನ್ನೊಂದು ಸರ್ವೆ ಮಾಡಿಸ್ಬೇಕಾಗತ್ತೆ.
ಇನ್ನೊಂದು ಸರ್ವೆ ಮಾಡಿಸಿ ನಮ್ಗೆ ಅಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ಅದ್ರಲ್ಲಿ ಮಿಸ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ. ನಮ್ಮ 4 ಎಕರೆ ಬಿಟ್ಟು 3 ಎಕರೆ 26 ಗುಂಟೆ ತೋರಿಸಿದ್ದಾರೆ.
ಅದು ಎಷ್ಟು ಶಾರ್ಟ್ ಫಾಲ್ ಇದೆ ನಾವು ಮಾಡ್ಬಿಟ್ಟು ಅದ್ರ ಪ್ರಕಾರ ಸರ್ವೆ ಸ್ಕೆಚ್ ಮಾಡ್ಬಿಟ್ಟು ಇದು ಪ್ರೈವೇಟ್ November 10th, my lord. 10th of November.
Please.
Admission matter 25.
May I please, your lordship? I am not feeling well 10 days accommodation. I don't want to pray for 10 years because for the health reason I am asking.
I prefer R1. ಒಬ್ರು ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ. R3 ಯಾರು ವಕಾಲತ್? Tulsi is a party. Party
name Sir, ಅದು health sufficient ಆಗಿದೆ ಸರ್. R2 and 3 ಗೆ ಇಬ್ರಿಗೂನು. My daughter did.
R2 CS ಅದು ಪಾರ್ಟಿ
ಅವರು ಪಾರ್ಟಿ ತೋರಿಸ್ತಾರೆ.
R1 ಮಾತ್ರ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು.
May I please, your lordship? Section 3 of the Limitation Act, your lordship. Limitation Act reads as follows, your lordship. Subject to the provisions subject to the provisions contained in sections 4 to 24, every suit instituted, appeal preferred, and application made after the prescribed period shall be dismissed, although limitation has not been set up as a defense. In this particular case, Your Lordship, suit has been filed after expiry of limitation period, Your Lordship. These are the list of the dates, Your Lordship. Your Lordship, on 6/5/97 sale deed, nature of suit is, Your Lordship, suit has been filed for declaration that GPA has been fabricated by Mr. Iregonda in OS number 86 of 2000, Your Lordship. The suit was filed on 23/5/2000, Your Lordship. 2000. Sale deed is dated 7/5/97, Your Lordship. So it has been filed after 3 years, 16 days, Your Lordship. So it is barred by limitation, Your Lordship.
The suit is filed after 3 years.
23/5/2000, Your Lordship. Sale date is dated 7/5/65 and 7/5/97, Your Lordship. So it is barred.
GPA has not been executed by him.
That has been proved that it has been executed by him. Has been proved, Your Lordship, that it has been executed by him, Your Lordship. So once it is proved that it has been executed by, the suit would have been decreed, Your Lordship.
But what was the order of the
Order of the trial court was, Your Lordship, as far as a limitation concerned, that ground was not taken, Your Lordship. Number one. Number two, because there was a criminal case filed by Mr. Iregonda, the court was influenced by that criminal case and dismissed the suit, Your Lordship, and decreed the suit filed by the declaration. Dismissed, Your Lordship. Declared suit filed by Iregonda was decreed, Your Lordship. Decreed. Second instance also it is decreed, confirmed, Your Lordship. Concurrent finding, Your Lordship. Then Your Lordship has also passed the order, so I have filed its application. The review petition.
on the ground that
On the ground that it is a limitation is there, that is an error, Your Lordship. Second, Your Lordship, when the GPA has been proved, court could not have held that GPA cannot be looked into. It has been before notary public, as if notary public GPA is illegal. That is not the law of the land, Your Lordship. GPA executed before the illegal notary public also is a valid GPA, Your Lordship. And one of the ground which is taken by the trial court is, Your Lordship, that the GPA should have been registered. There is no law that GPA should be registered, Your Lordship. Only if it is coupled with the possession, question of GPA registering otherwise does not arise, Your Lordship. And the criminal case subsequently they have withdrawn it, Your Lordship. They filed a false criminal case and it has been withdrawn, Your Lordship. Certified copy I will file along with the memo. I have not received it, Your Lordship. 64, 50, 60. Sorry. Yes. Second, Your Lordship, I turn to page number 64 and 65 of the trial court judgment.
Now, what is the ground for review, counsel?
Reviews, Your Lordship. It is contrary to the law, Your Lordship, section 3 and 27 of the Limitation Act number 1, Your Lordship, that is glaring mistake, Your Lordship. Second, Your Lordship, that page number 64, 65 of the trial court judgment. It is here only. Arrested.
Dispose ಮಾಡುವಾಗ
It was there, Your Lordship. It was there, Your Lordship.
Now the issue is only with regard to the limitation.
One limitation and second GPA, Your
That
Lordship.
is the only ground.
No, second is GPA, Your Lordship. Your Lordship, I will read the para 66 of the judgment.
Even finding of the transport is that even though document of GPA is in existence, no sale consideration is passed.
No, Your Lordship.
Even on D2,
No.
are the husband and wife.
I will answer that, Your Lordship. I will answer. Whether sale consideration passed or not, as far as the purchaser of the property is concerned, he can file for the sale consideration suit against the GPA to whom he has given that he or she has not given the money, but he cannot see that the GPA has not been executed, it has been fabricated. So the question of law arises, Your Lordship. RP, yes, sir. Page number 6 of my RP number 360, Your Lordship. 360, page number 6, Your Lordship. Beg your pardon.
Ground sale and individual.
Separately,
Except factual elements.
except factors.
Grounds for review, it is there.
It starts from Para 3 itself, your lordship.
ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಎಲ್ಲಿದೆ ಅಂತ ನೀವು ನೋಟ್ಸ್ ಎಲ್ಲ ಹಾಕಿದಿರಿ. ನೋಟ್ಸ್ ಎಲ್ಲಿದೆ ನೀವು ರಿವ್ಯೂ ಪಿಟಿಷನ್ ಅಲ್ಲಿ?
Para 3, your lordship.
ಎಲ್ಲಿದೆ ಗ್ರೌಂಡ್ ಸೆಟ್?
I have not given the specific title nomenclature as grounds, your lordship. But in para 3.
ಗವರ್ನಮೆಂಟ್ಸ್ ಇದನ್ನೆಲ್ಲ ಹೇಳಿದ್ರು. ರಿವ್ಯೂ ಮಾಡಿ ಕೇಳಬೇಕಾದ್ರೆ ನೀವು ಗ್ರೌಂಡ್ ಸೆಟ್ ಔಟ್ ಮಾಡಬೇಕು. ಎಲ್ಲಿದೆ ಗ್ರೌಂಡ್ ಸೆಟ್ ಔಟ್ ಮಾಡಬೇಕು? ಓವರ್.
Lords, the grounds which are taken is on the ground of limitation.
ನಾನು ಕೇಳ್ತಾರೆ ನೀವು RS dismissal ಆದ್ಮೇಲೆ ಏನು ಮಾಡಿದ್ರಿ? ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿದ್ರಾ ನಿಮ್ಮ ಆರ್ಡರ್ಗಳನ್ನ ಡಿಕ್ರೀನ?
My lords, I'll take instructions on that. I'll take instructions on that.
Why you have kept quiet from 14th day of June 2024?
They may have executed. I'll take instructions on that.
ಏನಾಗಿದೆ? ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿದೆ ಇಲ್ಲ?
I'll verify. Kindly. But I mean, regardless, my lords.
It has not been executed. It has not been executed.
Okay, ಹಾಕಿದ್ದಾರೆ execution.
And I'll verify that, my lords. But regardless, my lords, the
registry is directed to link the file of RSS, connected RSS.
ಹೌದು ಸರ್. RSS 218.
Respondent counsel is directed to verify whether judgment and declare the trial court and Amended court already executed or not. ನೋಡಿ ನಿಮ್ಮ ಯಾವ ರಿವ್ಯೂ ಎರಡು ರಿವ್ಯೂಗಳು ಗ್ರೌಂಡ್ಸ್ ಇಲ್ಲ.
I will amend it because just I have to put the nomenclature yourself. 3.4 itself is a.
Is this matter on 30th?
I will file an amendment application to permit me to. That's all.
Yes.
26. Subhash Chandra Bose.
3010. 3010.
Much of this.
Yes, sir, for the appellant, my lordship.
That did not.
Yes, my lord. Depend number 1, my lord. Yes, my lord.
ಸರ್ ವಿಜಯ ಕೃಷ್ಣ ಅವರು ಹಾಕಿದ್ದಾರೆ ಅವ್ರಿಗೆ
ನೋಡೋಣ ಏನು ನಂಬರ್ 1 of 22 for bringing a lot of disease data. Report has issued notice in the they have been represented to council and not filed any objection. So, for legal statement or something application under public, A1 of 22 is allowed. Appellant council is directed to amending class title and amended class title.
Meanwhile, time kindly be granted, my lord. Amount is.
First convince ಮಾಡಿ ಕೋರ್ಟ್ಗೆ ಫಸ್ಟ್ ಅಮೆಂಡ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದಾರಲ್ಲ ಎಲ್ಲ ರೆಕಾರ್ಡ್ 30
Much of it.
27. CM Nagabhushana. Shivashankar K.
Here for the first response.
divergent pending ಇದೆಲ್ಲ
Yes, my lords.
Finding you.
this reverse 50 null and void.
And your lordship will kindly see the gift deed they claim, survey number. Survey number 23, it is up, they say their donors vendor purchase it. But the plain schedule is 21/3 your lordship. And which measures 1 acre 30 guntas. Yes, your lordship. It is totally different, your lordship. And my lord, their title deed is in respect of 23. And the trial court, after recording all the, considering all the evidence, has come to the conclusion that they have not proved that 23, how it became a 21/3.
This right for in respect of this property.
21/3, that is the plain schedule.
Actually, yes, my lord. But it's
Allah, subsequently,
originally-
1 minute, your lordship. Subsequently, Podiandre, they get this gift deed in the year 1970. They admit your 1944 there was a 4D 21/3, 21 was divided to 21/1, 2 and 3. Even there, their vendor's name does not find a place. And till date, your lordship, no revenue records are in their favor.
Well, it's originally, facts of the case is, it's originally this property. It's not correct, Millets. It belongs to one Venkatappa. Millets, from the Venkatappa, one Basappa had purchased the property in the year 1921, Millets, 1921. Earlier, Millets, this property is bearing survey number 23 to the extent of 2 acres, 4 guntas of land. 23. Subsequently, Millets, in the year 19, on 8/8/1944, there was a survey has been conducted. In respect of this property, Millets, new survey number has been given, Millets, 21/2, 21/2, and 21/3. 21/3, this Millets, earlier sale deed boundaries, and the subsequent Millets, the 21/3, clearly Millets, the survey records indicates old survey number is 23 and new survey number is 21/3 in the Millets, exhibit P8 to P11 documents have been produced, and Millets, the survey records indicates Millets, the property is one and the same. Subsequently, Millets, in the year 1970, Millets, proceedings have been initiated before the Tahsildar. Because 1944 only there was a survey was conducted. This survey number, Millets, after the earlier it is 2 acres 4 guntas. Subsequently, after the survey, Millets, restricted to 1 acre, Millets, to 1 acre 30 guntas of land. Millets, then Millets, the revenue records have been continued in the name of this original one Anumappa alias Basappa anta, Millets, son of Basappa anta. But this first respondent is concerned, Millets, their properties have been partitioned by them through a registered partition deed in the year 2000. Let's respond. The appellants are concerned. No way. First defendant is concerned. No. So insofar as this property is concerned, they have so many properties. They were partitioned the property. This property in the year 2004, because of revenue records, entered in the name of Anumappa son of Basappa Ididina, fraudulently a gift deed has been executed in favor of this sister-in-law. Immediately, we have filed the suit before the trial court. Still, we have been in possession of the property because of mistake of survey number. Taking advantage of the revenue records, he has executed the gift deed in favor of his daughter-in-law. Then, suit came to be filed. Not appreciated the survey records. Then, the suit came to be dismissed. Appeal has been filed. Surveyor has been examined. Whether survey number 23 and 21/3 one and the same, surveyor has been examined. Surveyor and also in the cross-examination, they have admit boundaries tallies with this 21/3 and 23 are the one and the same. And also, the survey which was conducted in the year 1944 indicates survey number, old survey number is 23, new survey number is 21/3. Surveyor has been examined. Then, subsequently, so many documents have been produced before the appellate court. Additional evidence has been led to indicate both the survey numbers are one and the appellate court has accepted this survey number, old survey number and the new survey number are the one and the same. Then, they set aside the judgment and decree, and the appellate court has decreed this one. Now, to show that their property belongs to, that is 21/3 belongs to them, and no documents have been produced before the court. No, and the revenue records wrongly indicate their name has been entered in the revenue records because my grandfather name and their name is one and the same. Taking advantage of that, a gift fraudulently gifted has been executed. Prior to that, 2000 only, they were partitioned all the properties through a registered document, exhibit P13. There, in the registered partition, my survey number has been left off. Now, subsequently, this was not included. Taking advantage of the revenue records, gift deed has been executed in favor of this daughter-in-law. Now, taking on the basis of gift deed, they are claiming right over the property. That too, the first appellant is concerned absolutely, she has no right over the property. She has already alienated in favor of this second appellant. Now, during the pendency of the appeal, both the appellants having the knowledge that the plaintiff is in possession of the property and all the documents that stands in the name of appellant. In spite of that, during the pendency of the appeal, first dependent and second dependent have sold the property. Now, the pendency of this appeal, when they have purchased the property, that too, first appellant has no right over the property. Second appellant, on the basis of this illegal sale deed, now they are claiming the right over the property. They are not in possession. Their vendors are not in possession. They have no documents at all. Boundaries is clearly admitted.
My lord, if the survey number 23 was subdivided in the year 1944, their gift deed is here on 29/5/1970, exhibit P2. In that, how come survey number 23 is continuous? ಅಲ್ಲಲ್ಲ ನಮ್ಗಲ್ಲ ಅವ್ರು ಗಿಫ್ಟೆಡ್ ಮಾಡಿರೋದು. ಇವಾಗ ವಾಟ್ ಹ್ಯಾಸ್ ಹ್ಯಾಪನ್ಡ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್, ದಿ ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಅಲ್ಲ ಅವ್ರು ಕ್ಲೈಮಿಂಗ್ ಎ ಟೈಟ್ಲ್ ಆನ್ ದಿ ಗಿಫ್ಟ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟೆಡ್ ಇನ್ ದೇರ್ ಫೇವರ್ ಟು ಫೇವರ್, ನೇಮ್ಲಿ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೆಂಪಣ್ಣ ಅಂಡ್ ನಾರಾಯಣ ಸ್ವಾಮಿ. ಹೌದು ಸ್ವಾಮಿ, ಹನುಮಪ್ಪ and that apart
23 ನಲ್ಲಿ my grandfather has purchased, then my lords 20 ನಲ್ಲಿ because of survey numbers 1944 ಅಲ್ಲಿ ರೀಸರ್ವೆ ಆದಾಗ 21/3 ಆಗಿರೋದನ್ನ ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಗಿಫ್ಟೆಡ್ ಅಲ್ಲಿ. ಎಸ್ ಮಿನಿಟ್ಸ್ 20 ನಲ್ಲಿ ಬಿಕಾಸ್ ಏನ್ ಓಲ್ಡ್ ಸರ್ವೆ ನಂಬರ್ ಕಂಟಿನ್ಯೂ ಆಗಿತ್ತು ಅದನ್ನೇ ಮೆನ್ಷನ್ ಮಾಡೋದು. ಒರಿಜಿನಲ್ ಮಿನಿಟ್ಸ್ ಗಿಫ್ಟೆಡ್ ಬೇಸಿಸ್ ಮೇಲೆ ಮಿನಿಟ್ಸ್ ಅವ್ರು ಕ್ರಿಯೇಟ್ ಮಾಡಿಲ್ಲ.
ಅವ್ರದ್ದು ನಿಮ್ದು ಅವ್ರದೇ ಗಿಫ್ಟ್. Exhibit P2 is their title, your lordship. That is the title on which the suit is filed.
Let's 2004 ಅಲ್ಲಿ
29/5/19 as executed. That apart, your lordship, the gift deed was made by Hanumappa in favor of Kempanna, the plaintiff, and the brother Narayana Swami. Narayana Swami has not made a party. Trial court records that a proper necessary party has not been made a party. And another, your lordship, conduct of the plaintiff, her lordship has to appreciate. In the plaint, they say their brother executed a release deed with a date 13/8/76, but that document is not produced before the court. And Narayana Swami is not made a party.
Millards, when they have to claim right under the gift deed, Millards, in the year 2004, how first defendant has acquired the property, Millards? No document have been produced before the court. Either Millards, they have to acquire the property either 21/23 or 21/3. ಅಲ್ಲ ನಮ್ಮದು 21/5/1917 ನಲ್ಲಿ Millards, my grandfather has purchased the property. Prior to the 23 ನಲ್ಲಿ registered sale deed ಆಯ್ತು ಬಸಪ್ಪನಿಂದ. exhibit P1, exhibit P1 ಆದ್ಮೇಲೆ P2. But won't the survey, the registered sale deed and the gift deed boundaries tallies with the 21/3 and old survey number 23. Euro 2004 ಅಲ್ಲಿ Millards, the gift deed has been created in favor of the second. How the gift deed 2004?
It is incorrect, your lordship. In exhibit P1, in exhibit P1, no boundaries have been mentioned.
ಇಲ್ಲ ಇದೆ 2004 ನಾವೇ ಹಾಕಿದೀವಿ.
ಅಲ್ಲ exhibit P2 ನಲ್ಲಿ boundaries ಇಲ್ಲ.
gift deed
ಅದು exhibit P2
ಅಲ್ಲ P4.
ಹೌದು
ಅಲ್ಲ P4 Millards, exhibit P4 one ಹನುಮಪ್ಪ ಮತ್ತೊಂದು ಗಿಫ್ಟ್ ಇದು ಇದ್ರ ಮೇಲೆ Millards, now they are claiming right over the. Yes Millards, in order to execute this gift deed in favor of daughter-in-law, Muniyappanna should be Millards acquired the right either under the registered document or Millards under any other document. They could have acquired the property. ಇದಕ್ಕಿಂತ ಮುಂಚೆ ಇಲ್ಲ ನಮ್ಮದು ಸರ್ವೆ ನಂಬರ್ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದಕ್ಕೆ ನಾವು they are claiming Millards 2004.
Your lordship, I am claiming a right under gift deed 21/3. Your lordship is right because it is my, yes your lordship, it is the ancestral property of my father after. Yes your lordship, it is ancestral property of my father.
For a moment kindly let's exhibit P13 ಮೇಲೆ
ಅಲ್ಲ 1969 ನಿಂದ 1960 ಅಲ್ಲ subsequent to evidence ಮಾಡಿದಾಗ we have produced RTC stands in the in the ದೊಡ್ಡ ಹನುಮಪ್ಪ from it is true your lordship then your lordship has to appreciate if the plaintiff are from Basappa purchased in 1929, but 21 up to date there is no revenue records in their favor. Yes your lordship, it is an ancestral property after the your lordship will kindly see my long question is there your lordship. Yes sir. ಹೌದು ಸ್ವಾಮಿ.
Thereafter Muniyappanna, his son, succeeded to the property.
Based on the revenue entries, you have created the gift deed dated 18/11/2004 anta.
Your lordship will appreciate Their donor is Anumappa. Anumappa has never had any revenue records on the date of the gift deed he executed in favor of the plaintiff. And your lordship, if it is really executed in favor of the plaintiff and his brother could have been examined. He has not even made a party. Trusting laws, ಹೌದು ಅದಲ್ಲ well reasoned order of the trial court on the presumption can the first appellate court can reverse it. On presumption is that your lordship I read only one paragraph from the first appellate court order.
Before that, let's say exhibit P13 may kindly be seen.
Your lordship will kindly appreciate
P13 minutes. ಅದು ಅಪಿಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಡಿಷನಲ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ. Before that, let's say exhibit P13 may kindly be seen.
Your lordship
there are so many properties.
Your lordship may consider only 2 paragraphs from the trial court order, first
registered
court order.
partition. ಇದೆ. Exhibit P8 to 11 ನೋಡಿದ್ರೆ clearly shows old survey number and new survey number. ಬರೀ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸ್ಟಿಲ್ ಸರ್ವೆ ನಂಬರ್ 23 ಅಂತ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಲ್ ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ 23 ಗೆ ಸಂಬಂಧಪಟ್ಟಂಗೆ ಅದು ಬೇರೆಯವರ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಓನ್ಲಿ ಟು ಮಿಸ್ಗೈಡ್ ದಿ ಕೋರ್ಟ್.
Your lordship, not I am misguiding your lordship.
But still 23 is existing. Even though appellant is claiming in respect of my property, all the revenue records have been produced. That property, 23 court has compared, and that property is totally different from the suit property.
My lord, ತಾವು ಫಸ್ಟ್ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಪೇಜ್ 39 ಅಲ್ಲಿ ಪ್ಯಾರಾ 29 ತಾವು ನೋಡಿದ್ರೆ ಸಾಕು ಸ್ವಾಮಿ. ಹೌದು ಹೌದು ಸ್ವಾಮಿ, ಪೇಜ್ 39 your lordship. 25 your lordship. Of course, the burden is upon the plaintiff to prove his title on his own by adducing acceptable evidence, and the plaintiff cannot rest his case on the part of defendant. However, in a case where the defendant has claimed title on the subject matter of the suit, the defendant must produce some evidence to show better title with him. The claim of the defendant over the suit schedule property is entirely based on the RTC entries continued in the name of the father of the first defendant in respect of survey number 21/3. The defendant number 1 has claimed that the suit schedule property is ancestral property, but it is surprised to see that in a family partition effected as per Exhibit P13 between the family members of the first defendant, the scheduled suit schedule property was not included. There is no any record in Exhibit P13 with regard to availability of suit schedule property in the family or about the reason. It is also appropriate to consider that the conduct of the defendants in transferring the title in favor of defendant number 4 who is none other than the daughter-in-law by way of a giftee, which creates a doubt about the transaction. The subsequent transfer during the pendency of the suit through the registered sale deeds in favor of the respondent 3 and 4 also appears to be suspicious transaction. Exhibit P8 to P11 and Exhibit P2 are sufficient to prove that the old survey number 23 was renumbered as 21/3. No, it is all of my documents. Exhibit P8 to P11 are my documents. The trial judge has rejected this suit mainly on the ground that there is a variation in extent mentioned in Exhibit P1 and P2, and the plaintiff has failed to prove that the former survey number was renumbered as survey number 21/3. I am of the view that said finding is not sustainable under the law. Your lordship, is not sustainable under the law, and under means what, on what basis, your lordship? Number, not sustainable is held in appreciating the evidence in proper significance. The title and the right which acquired through a registered instrument as per the procedure cannot be denied merely on the probable minor mistake correct in the documents and to legitimate claim of the person who does not have any evidence right or title. Therefore, I am of the view, Your Lordship, all that is the presumption of the First Appellate Court Judge, Your Lordship. It is not based on evidence. Now, Exhibit P8 is my document which they have produced. If Your Lordship takes it.
Para 24 allo appellate court. It's very clear.
But the income.
21/1 is subdivided 21/1 or 2 and 3. ಇಲ್ಲಿ ಕೆಳಗಡೆ 23 ಗೂ further ಇದೆ. Further details document ಇಲ್ಲಿ ಇದು 21/1
ಹೇಳ್ತೀನಿ.
21 totally measures 8 acres extension. Survey number 23 measures only 2 acres 4 guntas. 8 acres with the
23 ಎಷ್ಟು measures?
20 acres 4 guntas according to them 2 acres 4 guntas.
23 ಎಲ್ಲಿದೆ ಅದು?
ಅದು ಅವರು ಸೆಲ್ ಇದೆ.
ಇದು
23 ಕಂಟಿನ್ಯೂಷನ್ ಇದೆ ಗೊತ್ತಿಲ್ಲ.
ತಾವು ಎಕ್ಸಿಬಿಟ್ P8 ತಗೊಂಡ್ರೆ ಒಂದು ನಿಮಿಷ ತಾವು ನೋಡ್ಬೋದು ಆಗ್ಬೋದು. ಅದ್ರಲ್ಲಿ 21 ಡೀಟೇಲ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಹೆಂಗೆ ಡಿವೈಡ್ ಆಯ್ತು ಅಂತ. ಇವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್ವೆ ನಂಬರ್ 23 ಇಟ್ ಇಸ್ ಇನ್ಕಂಪ್ಲೀಟ್. ಇವಾಗ ಇಟ್ಸ್ ಇನ್ಕಂಪ್ಲೀಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್. ಮೇಲ್ಗಡೆ ರೀಸರ್ವೆ ನಂಬರ್ 21 ಅಂತಿದೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಕೆಳಗಡೆ 23 ಡೀಟೇಲ್ಸ್ ಇಲ್ಲ. ಅದು ಇಟ್ ಇಸ್ ಇನ್ಕಂಪ್ಲೀಟ್. ಇವಾಗ
P9 allo clear ಇದೆ. 23 has been rounded off and mentioned 21. Resurvey number, hale survey number, notes the indicate the sketch with regard to survey number 21/3 and 23 is concerned. Exhibit P10, P11 is very clear, notes P11. Old survey number 23 and new survey number 21, notes P11.
ಸರ್ವೆ ನಂಬರ್ 21
P11 ಅಲ್ಲಿ notes old survey number, ಪೂರ್ವದ survey number last ಅಲ್ಲಿ ಇದೆ. First 8/8/1944 ಅಲ್ಲಿ survey conduct ಮಾಡಿ notes ಪೂರ್ವದ ಹಳೆ survey number 23, resurvey number 21 clearly mentioned notes the old survey number and new survey number.
ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದಾರೋ?
Left bottom ಅಲ್ಲಿ survey sketch with regard to 21/3 is concerned.
21/3 ಅಲ್ಲ 21/1.
21/1
ಇಲ್ಲ 21 ಇದರಲ್ಲಿ ಅದು exhibit P11 ಅಲ್ಲಿ 23 P11 ಅಲ್ಲಿ ಫಸ್ಟ್ ಒನ್ ರೀಸರ್ವೆ ನಂಬರ್ 21 ಅದರ ಲೈನ್ ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ 23 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಪೂರ್ವದ ಸರ್ವೆ ನಂಬರ್ ಅದು, ಪೂರ್ವದ ಸರ್ವೆ ನಂಬರ್, ಓಲ್ಡ್ ಸರ್ವೆ ನಂಬರ್. ಮೇಲೆ ಡೇಟ್ ಕೂಡ ಇದೆ, ಯಾವಾಗ ಸರ್ವೆ ಆಯ್ತು 8/8/1944 ಅಲ್ಲಿ. That 2 minutes the TW1 has admitted minutes with regard to the boundaries and the old survey number and the new survey number.
23 boundary ಇದೆ, ಇಲ್ಲಿ 23 ಇದೆ.
ಎಕ್ಸಿಬಿಟ್ P11 ನಲ್ಲಿ ಲೆಫ್ಟ್ ಸೈಡ್ ನೋಡಿದ್ರೆ ಸರ್ವೆ ನಂಬರ್ 23 ಇದೆ ಸ್ವಾಮಿ.
ನೋ 21 ಅದು
23 ಇದೆ. ಎಕ್ಸಿಬಿಟ್ P11 ನಲ್ಲಿ 21 ಡಿವೈಡ್ ಆಗಿಲ್ಲ. 21/2 and 3 ಅದು ಇದರಲ್ಲಿ ಸೌತ್ ನಲ್ಲಿ ನೋಡಿದ್ರೆ ಸರ್ವೆ ನಂಬರ್ 23 ಅಂತಾನೆ ಇದೆ.
21 ಓಲ್ಡ್ ಮಿನಿಟ್ಸ್ ಮುನಿವೆಂಕಟಪ್ಪ.
ಬಾಟಮ್ ನಲ್ಲಿ 22.
21 23 and new survey number 21. Not exhibit P13 may kindly be seen notes. P13 registered partition deed ಅದು 2000 ಅಲ್ಲೇ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು. ಡಿಫೆಂಡೆಂಟ್ ನಂಬರ್ 1 and 2 2000 ಅಲ್ಲೇ
ಈ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ P13 ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡು.
ಹೌದು ಹೌದು.
ಈ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಪಿಟಿಷನ್ P13 ಅಲ್ಲೇ ನೀವು ಪಾರ್ಟಿ ಹೋದಲ್ಲ.
ಹೌದು.
ನಿಮಗೆ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ ಪ್ರಾಪರ್ಟಿ?
Your Lordship will kindly say in the family among the members, certain properties are treated as self-acquired property, therefore the
ancestral property
ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಿ.
Ancestral property partition.
True, my lord. True, my lord. True, my lord. My lord, if there is some weakness in my case, that will not give them a title.
No.
Your Lordship. Your Lordship, my records are that of the ancestral property 1969 in the RTC ಇದೆ. Your Lordship, now the question is this, Your Lordship. 1921 ಅವ್ರು ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರೆ 19 till the suit is filed, why no or
Correspondent kindly have filed a suit in OS number 726 of 2006, seeking the relief of declaration against the defendant, declaring that decree dated within 11/2004 executed by the first defendant in favor of second defendant is null and void. And also to declare that plaintiff is the absolute owner of the social property. And also sought for grant of permanent injunction. The trial court, having considered both oral and documentary evidence, dismissed the suit. Being approved by dismissal of suit and appeal is filed. The same is numbered as 15045 of 2015. The appellate court, having reassessed the material available on record, as well as recorded the additional evidence before the appellate court, comes to the conclusion that trial court was not justified in dismissing the suit. Also, the plaintiff has proved the identity of the property. Comes to the conclusion that the finding of the trial court is erroneous and reversible finding. The counsel appealing to the appellant to vehemently contend that appellate court fails to take note of the very survey number and say deed is purchased, plus the property is purchased in respect of survey number 23. Right deed is also in respect of survey number 23. Subsequently created a document of exhibit B2 of 15, wherein survey number is mentioned as B13 without any basis. The counsel also submit that the trial court committed an error in relying upon the document. The trial court committed an error in relying upon the document of exhibit B8 to 12 and also exhibit B13. Hence, it requires reconsideration. Press this court to admit a trial substantial question of law. Compared to the counsel appearing for the respondent plaintiff vehemently contend that trial judge did not consider the material on record, particularly in respect of change of survey number. Counsel brought to notice of this court exhibit B11 that the earlier survey number 23 was renumbered as survey number 21, or 21 bar 2 and 21 bar 3. And the same is reappreciated by the first appellate court, considering the document exhibit B12 and also exhibit B13. Evidence the fact that there was a partition among the members of the family of the defendant, wherein the property which is mentioned in exhibit B4 B3 is not forthcoming. Only based on the revenue entries created the document of exhibit B4 B3. Same is observed by the first appellate court in paragraph number 24, 25. Was the same. Then no grounds to admit and have substantive question of law. Having heard the appellate counsel and also the counsel appearing for the respondent, at first instance trial court dismissed the suit. Appellate court, having considered the oral and documentary evidence as well as recording of additional evidence, reversed the finding, coming to the conclusion that trial court is not justified in dismissing the suit. When such divergent finding is available with regard to the appreciation of the record, matter requires reconsideration. The following substantive question of law arises from consideration of this court. first appellate court committed an error in reversing the finding of the trial court, particularly relying upon the document of exhibit B12 or exhibit B13. Regarding flow of title between the parties. Whether the first appellate court committed an error in coming to the conclusion that server number 23 was renumbered as server number 21 was free. Without considering the material available on record in the same straightforward situation. Whether the first appellate court committed an error coming to the conclusion that the appellant defendant did not place it on record anything that the property which the defendant is claiming an ancestral property without any basis. The same amounts to perversity. That is the issue, that's the issue.
Let's stay of
Records of the trial court and first appellate court already received and no need to filing of paperwork. As filing of paperwork is dispensed. Did you know?
interim order, your lordship. Stay of the first appellate court judgment. ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. Your lordship may get a page. Page number 85 ನಲ್ಲಿ ಹಾಕಿದೀವಿ ಸ್ವಾಮಿ. ಹೌದು. ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ ಸರ್.
So date may be first week.
This is matter for hearing on
411.
28.
V. Vinod Reddy.
I am appearing for the appellant. I am permitted to file today because the advocate on record has designated a senior counsel. He has returned the file. Today I am filing wakalat. Idly some ಇವತ್ತು ಆಗ್ತಾ ಇದ್ದೀನಿ ರಿಜಿಸ್ಟ್ರಿಯಲ್ ಫೈಲ್ ಮಾಡ್ತೀನಿ. ಒಂದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಎನಿ ಡೇಟ್ ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿ. ಎನ್ ಗುರುವಾರೆಡ್ಡಿ. Senior.
ಹಾಕಿದೀವಿ. ಅಪ್ಪಿ ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಫೈಲ್ ಇದೆ. ಅಲ್ಲಿ ಕೆವಿಯಟ್ ಹಾಕಿದೆ. ಕೆವಿಯಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಪುಟ್ ಅಪ್. ಕೆವಿಯಟ್ ಹಾಕಿದ್ದಾರೆ.
ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್. ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದೀನಿ ಕೊಟ್ಟಿದ್ದೀನಿ. ಚಂದ್ರಚೂಡ್
ಕೇಳ್ತೀನಿ. ಚೆಕ್ ಇಟ್.
ನನ್ನೇ
ಕೆವಿಯಟ್ ಹಾಕಿದ್ದಾರೆ. ಚಂದ್ರಮೋಹನ್ ಅರ್ಜಿ.
Copies ಕೊಟ್ಟಿದ್ದಾರೆ. This matter for attention on Twitter.
29. Subramanya HV.
For appellant in this case. Raise for 1 week time, my lord. Senior sum. My lord, senior sum inconvenience, my lord. Kindly have any date.
ಇಲ್ಲ 30th my lord senior ಆಗಿ ಆಗಿದೆ ಮಾತ್ರ any date next date any date my lord ಇಲ್ಲ sir ಇಲ್ಲ sir
This is the court. Again, I'm almost looking the advocates are requested not to seek any adjournment.
next week any date my lordship date may fixed my lordship
Suit for partition.
Partition.
Declaration of permanent detention.
Please.
Was dismissed.
please
Coming to the conclusion that property is not the joint family property. Sir. All the issues are answered as negative.
next week
Also, ಮಾಡಿರ್ತೀರಿ ನೀವೇ ಓದ್ಕೊಳ್ಳಿ ಅಸಿಸ್ಟ್ ಮಾಡಿ. Also,
30. Debarration.
A week time may be given. A week time may be given. Senior out of station. One week ಅಷ್ಟೇ sir. One week.
Pains me.
Request my lord.
No adjournment. Divergent pending.
Divergent pending. Records pending.
ರಜಾ ಮುಗಿತು ಮೇಲೆ ಕೋರ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಯಿತು ಕೋರ್ಟ್ ಸ್ಟಾರ್ಟ್ ಆಗಿ ವಾರ ಆಯಿತು ಆದ್ರೂ ಟೈಮ್ ಹೇಳಕ್ ಬಿಡಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್
Yes my lord. Trial court dismissed the suit my lordship filed by the respondent. Fourteen 1/2011 ಅಲ್ಲಿ 6 AM ಅಲ್ಲಿ different number 4.
Or the appellant counsel and also the counsel appearing to the respondent. The respondent plaintiff filed the suit for the relief of performance based on the sale agreement dated 14/1/2011. And the trial court having considered both verbal and documentary evidence dismissed the suit in answering the question number 1 negative. Also, question number 2 as negative that was not ready and willing to perform this part of agreement. Comes to the conclusion that question number 2, 3, 7 to 9 have proved that the agreement is obtained by coercion. Hence, declined to grant the relief of specific performance. Being approved by the dismissal of the suit, an appeal is filed and appellate court comes to the conclusion that trial court committed an error not to have granted the relief of specific performance. That Sale agreement is approved. Always he is ready and willing to perform his part of contract. Directed to execute the same. Hence there is a divergent right. Counsel appearing to the appellant to payment to content that the appellant for error. Reversing the finding of the trial court as against the definite finding of trial court that agreement came into existence by way of coercion. And hence ought not to have granted the relief of successive performance. Also, the first appellate court was not justified in coming to the conclusion part of the contract. Hence, it requires interference. Not a counsel appearing to the respondent to support that. Trial court committed an error and the same is reversed by the appellate court. Reassessing the overall documentary evidence of the record. Not committed any error. Having heard the appellant counsel and also the counsel appearing reasoning of trial court and appellate court, there is a divergent finding to the claim of the plaintiff, also the claim of the defendant. Hence, the divergent finding is under the court's reconsideration. Admit the following substantive question of law arises from the consideration. The second appeal. Whether the first appellate court justified in holding that defendants have agreed to sell the suit property for sale consideration of 6 lakh by receiving an amount of 5 lakh 50,000 have executed the agreement of sale dated 14/1/14. Whether the first appellate court committed an error, whether the first appellate court was justified coming to a conclusion that plaintiff public respondent was always ready and willing to perform that part of the contract. Trial court committed an error in declining to grant the relief of sale agreement is obtained by coercion. Records are received, no need of filing of paper book. And 6 marks for failure in
Viresh P. Janathan.
For respondent.
pending the last step of the appellant Viresh E. Appellant counsel is absent. Counsel for the respondent is present. The order sheet discloses. Order sheet dated 24/9/25 discloses that none appears for the appellant. Today is also appellant counsel is absent. The appellant counsel doesn't appear in the state of hearing. Will be dismissed for
Achal.
32. Umashankar MN. Vishal Bhagat.
This matter was admitted on 19/2/2024. That should kindly see. ಇದು ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಬಂದಿತ್ತು ಒಂದ್ಸಾರಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇವ್ ಶು ಕೈಂಡ್ಲಿ ಟೇಕ್ 19/2025 ಆರ್ಡರ್ 2025 ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಬಂದಿತ್ತು. ಅದು ಮೇಡಮ್ ಅದು ಆಫೀಸ್ ಇದು ಐ ಫೈಲ್ಡ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಐ ಫೈಲ್ಡ್ ಸರ್ಟಿಫೈಡ್ ಕಾಪೀಸ್. ಅಪ್ಲಿಕೇಶನ್ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ರಿಜಿಸ್ಟರ್ ಮುಂದೆ ಬಂದಿತ್ತು. ಐ ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಇಟ್. ಪ್ಲೇಸ್ ದಿ ಮ್ಯಾಟರ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ ಅಷ್ಟೇ. ಹೌದು ನೋಡಿ ಇದರಲ್ಲಿ ನೋಡಿ ಲಾಸ್ಟ್ ಕೈಂಡ್ಲಿ ಸಿ ಫಸ್ಟ್ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಫಸ್ಟ್ ಅದೇ ಆಗಿದೆ. My learned friend has filed RSA number 816 of 2019.
816 of
19 ಇದೆ. My lord, it has to be posted after the disposal of that RSA. ಅದರಲ್ಲಿ if that RSA is allowed, my lord, this has to be set aside.
In this case, this appellant in this case is advocate.
ಅಲ್ಲ ಅದೆಲ್ಲ ಬೇಡ. ಅದೆಲ್ಲ ನೀವು ಅದ್ರ ಮೆರಿಟ್ ಮೇಲೆ ಕೇಳ್ತೀರಾ ಇಲ್ಲಿ?
Advocate. Matter may be referred to mediation. Matter may be referred to the mediation. I know this advocate also. He is a senior advocate from Chandrayapatna. If matter is referred to mediation.
My lord, no. Already execution, sale deed is executed through the process of the court.
ನಾನು ಗೊತ್ತುಂಟು ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿ 816
it is not admitted.
RSA ಇದೆ ಇಲ್ಲಿ. ಅದರ ಮೇಲೆ ಅವರು ಸಬ್ಸ್ಟಾನ್ಷಿಯಲ್ ಕ್ವೆಶ್ಚನ್ ಆಫ್ ಲಾ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ. ಅವರದ್ದು ನೋಡಿ ಸಮಯ ಅಪೀಲ್ ಮೆಮೊ.
ಯಾವುದರಲ್ಲಿ?
ಇದರಲ್ಲಿ ನೀವು ಅದರ ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ
no, that appeal is not admitted.
ನಿಮ್ಮ ಅಪೀಲ್ ನಲ್ಲಿ
RSA 816 of 2019 is not admitted, my lord.
I am not telling admitted.
Is not admitted.
In their appeal memo seen, my lord, they are telling that appeal memo be seen, my lord. They're one of the ground at page 19.
ಅಲ್ಲ substantial question of law ಇದೆ, my lord.
ಅದನ್ನ actually you have raised that substantial question of law regarding.
ಹೌದು.
ಹೌದು.
That has to be disposed of first.
ಅದು ಮಾಡಬಹುದು, ಎರಡೂ ಮಾಡಬಹುದು. If I try one
19, my lord.
21 816 of 21.
ಅಲ್ಲ 816 of 2019.
21
ಆಯ್ತು 21 ಆಗಿ ಅದು ಅಡ್ಮಿಟ್ ಆಗಲಿಲ್ಲ.
ಹೌದು
ಅಡ್ಮಿಟ್ ಆಗಲಿಲ್ಲ.
ಆಗುತ್ತೆ ಸರ್.
But that is not admitted. That let it be posted for admission.
816 of 2021. Of 2021.
Respondent counsel submits that in respect of the very same property, one more appeal RSA is pending before this court. That is RSA 816 of 2021.
Yes.
And if any decision is taken in this appeal and also in the said appeal, since both the second appeals pertaining to the very same property,
Relief is
same parties.
there will be a conflicting judgment.
Yes.
Hence, list RSA 816 of 2021 and also this appeal on 30/10.
Yes.
Now, this is under the heading.
This appeal for final hearing.
Final hearing.
And the other admission ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಆಗಿಲ್ಲ. ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಆಗಿತ್ತು.
Admission on the 30/10.
ನೋಡಿ ಇದರಲ್ಲಿ 30 ನಾ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಕೊಡಿ.
411 ಆಗ್ತದಾ?
411 ಯಾವಾಗ?
411 Tuesday
ಬರುತ್ತೆ.
7th or 6th? 6th ಮಲ್ಲ 6th. Paper book may be dispensed ಇದರಲ್ಲಿ. ಇಲ್ಲ ಅಡ್ಮಿಟ್ ಆಗಿರೋದ್ರಲ್ಲಿ ಪೇಪರ್ ಬುಕ್ ಏನು ಹೇಳಿಲ್ಲ ಸರ್. ಏನು ಹೇಳಿ? ಇಲ್ಲ ಅದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಆದ್ರೆ ಸಾಕು ಸರ್. ಅದ್ರಲ್ಲಿ ಎಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಅದೇ ರೆಕಾರ್ಡ್ಸ್ ಇದು. ಹೌದು ಅಲ್ಲ ಅದರಲ್ಲಿ ಸೂಟ್
ಇಲ್ಲ ಇಲ್ಲ ಸೇಮ್ ಅಲ್ಲಿ ಬೇರೆ ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್ ಇದೆ. ಬೇರೆ ಬೇರೆ ರೆಕಾರ್ಡ್ಸ್.
What was verification of the agreement of sale? ಒಂದು that is decreed. ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ ಇವ್ರು ಹೇಳೋದು ಇವರು ಈ ಸೂಟ್ ಫಾರ್ ಡಿಕ್ಲರೇಷನ್ ಅಂಡ್ ರಿಕವರಿ ಆಫ್ ಇಂಜಂಕ್ಷನ್ ಇದರಲ್ಲಿ
33 ಆನಂದರಾಮ್ಗೆ
Lord, appeal filed by defendant number 2, my lords. The suit for partition, Lord, the genealogy tree is at page 68, my lords. One Kalachari, my lord, is said to be the propositors as per the case of the plaintiff. He is said to have, my lord, 4 daughters and 1 son.
Kalachari is the only son.
Kalachari. Then, my lord, he is said to have 4 daughters and 1 son. Now, my lord, the Ningamma, one of the daughters, my lord, is the plaintiff. Then, my lord, the others, the appellant, my lord, is defendant number 2, the only son. And 2 other daughters are D1 and D3. One of my lord, the daughters died, my lord, and her children are made as parties. Defendant number 4 to 6. Now, my lord, the suit on the ground that it is a joint family property. For the 5 items of scheduled properties, my lord, one of the item was deleted, saying that there is no, it has been sold, and that has been deleted during the pendency of the suit, my lord. So 4 items, my lord, that is remaining. My lord, one of the grounds is that, my lord, between Kalachari and his brothers, my lord, there is a larger suit for partition that was pending, filed in 2012. That is, my lord, OS number 39 of 2012. This is filed in 2015. And that was decreed on 2/8/2018. And, my lord, the regular appeal is pending. There, my lord, the present appellant, who is defendant number 2, is a party
In the other suit.
in the other suit. And he has taken up a contention that his sisters, that may be plaintiff and other defendants here, are not made parties. So that is now pending, my lord, in the regular appeal. So there, my lord, the Kalachari's definite share itself has not been ascertained. So therefore, my lord, the present suit, which was filed during the pendency of the earlier suit.
Earlier suit also decreed.
Earlier suit decreed, my lord. There, Kalachari's share itself has not been ascertained.
But ಅದ್ರಲ್ಲಿ ಅಸರ್ಟೈನ್ ಮಾಡೇ ಡಿಕ್ರಿ ಆಗಿರೋದು ಈಗ.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಇನ್ನು ಮೀಟ್ಸ್ ಅಂಡ್ ಬೌನ್ಸ್ ಅಲ್ಲಿ ಏನೂ ಆಗ್ಲಿಲ್ಲ.
ಆಗುತ್ತೆ.
So which property ಎಂತದು ಏನು ಅಂತ ಏನೂ ಇಲ್ಲ.
But they are entitled. Sisters are entitled.
Yes, that is, my lord, one contention.
Then that's all.
No, the other contention is, my lord, with regard to the shares that has been allotted, my lords. 1/5 has been allotted. The Kalachari, my lord, he died in the year 1979. 27/11/1979 he died.
ಕಾಳಾಚಾರಿಗೆ ಇರೋದು 5 ಮಕ್ಕಳು.
ಹೌದು, 5 ಮಕ್ಕಳು.
1/5 ಕೊಡಬೇಕು.
Yes. ಅಲ್ಲ, deemed partition ಆಗುತ್ತೆ.
Deemed partition ಪ್ರಶ್ನೆನೇ ಬರಲ್ಲ ಈಗ. As on the date of suit, he is no more. Father is no more.
Father is no more.
It already it enlarges among the children. ಅಷ್ಟೇ. If father is alive, then your argument will be correct.
Yes.
1/5 only. 1/5 ಕೊಟ್ಟಿರೋದು.
1/5 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಹೌದು.
And the third argument, my lord, is with regard to the liabilities, my lord. Liabilities ಅಲ್ಲಿ, my lord, I have actually made some improvements in the property. And I have dug a borewell and, my lord, I have spent some money.
ಆಯ್ತು. Till date you are enjoying the property.
Lord, there is absolutely no income from the property. It is less than 2 acres of property.
Then why you are fighting for the property if you are not getting any income?
ಎಲ್ಲ ಸಾಲ ಗೀಲ ಮಾಡಿ ಅದಕ್ಕೆ ಬೋರ್ವೆಲ್ ಹಾಕಿದ್ದಾರೆ, ಅದರಲ್ಲೂ ಸರಿಯಾಗಿ ನೀರು ಸಿಕ್ಕಿಲ್ಲ. My lord, he has suffered a lot. So, my lord, 6(1)(c) says, my lord, they are not only entitled for property but also, my lord, they are liable for the liabilities, just like a co-partner.
ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
My lord, I have produced pronotes. DW2 to DW6 have been examined.
Very oral evidence.
And pronotes, my lord, for having obtained the loan, my lord, that has been produced. In fact, my lord, the appellate court says, at the time of execution ಅಲ್ಲಿ borewell ಇದ್ರೆ ಅದು second defendant ಗೆ share ಕೊಟ್ಟು ಅದ್ರ cost ಕೊಡ್ಲಿ ಅಂತ ಹೇಳಿ ಬರೆದಿದ್ದಾರೆ.
ಏನಂತ?
Second defendant ಗೆ if there is a borewell, that may be allotted to the share of defendant number 2 and the cost may be paid by the plaintiff ಅಂತ ಬರೆದಿದ್ದಾರೆ, page 29 ಅಲ್ಲಿ. So, my lord, and even PW1 in a cross examination admits, my lord, regarding the existence of borewell and other costs that has been incurred. Notice on
establishing the borrowing of money itself is not sufficient to hold that defendant borrowed money from defendant number 2 to utilizing it for the development of family properties. This is the reasoning. And digged borewell in the family properties.
Yes.
If at all second defendant utilized money borrowed by him for the development of scheduled properties and digged borewell in the scheduled properties, nothing registered him to place photographs to show the present photography of the scheduled properties, but no attempt was made by the second defendant. In case while executing preliminary decree, commissioner locates the borewell, then the portion in which the borewell exists may be allotted to the second defendant. ಅಷ್ಟೇ. ಅದನ್ನು ಮಾಡಿದ್ದಾರೆ. ನಿಮ್ಮ ಇಂಟ್ರೆಸ್ಟ್ ಅಲ್ಲೂ ಸೇಫ್ ಗಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಯಾಕಂದ್ರೆ 79 ಅಲ್ಲಿ
borewell ಜಾಗ ನಿಮಗೆ ಕೊಡಿ ಅಂತ.
ಹೌದು.
ಇನ್ನೇನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
My lord, 79 ಅಲ್ಲಿ ಡೆತ್ ಆಗಿದೆ. After more than 30 years, my lord, the suit.
You have enjoyed.
My lord, I have enjoyed without any income, my lord. I have suffered some liabilities. ಅದಕ್ಕೆ ಅಟ್ಲೀಸ್ಟ್ ಒಂದು ನೋಟಿಸ್ ಮಾಡಿದ್ರೆ ಸಮ್ ಸಾರ್ಟ್ ಆಫ್ ಕಾಂಪ್ರಮೈಸ್ ಮಿಲಾಡ್ ಇಫ್
ನೋಟಿಸ್ ಹೋಗಿ ಇಲ್ಲಿ ಬಂದು ಲಾಯರ್ ಇಟ್ಕೊಳಕ್ಕೆ ಎಷ್ಟು ಫೀಸ್ ಕೊಡ್ಬೇಕು ಗೊತ್ತಾ ಡಿಪೆಂಡೆಂಟ್ಸ್ ವಿತೌಟ್ ಎನಿ ಇನ್ಕಮ್ ಎಂತದ್ದು ಇಲ್ದಲೆ ಸೂಟ್ ಫಾರ್ ಪಾರ್ಟಿಷನ್
ಅವ್ರ ಮಿಲಾಡ್ 1979 ಮಿಲಾಡ್ ಬಿಫೋರ್ ಮಿಲಾಡ್ ಐ ನೋ ದಿಸ್
ಸೆಕೆಂಡ್ ಅಪೀಲ್
ಮಿಲಾಡ್ ಐ ನೋ ಮಿಲಾಡ್ the arguments will not hold good but still milord before the death of the father they were married and milord
ನೀವು ಅಡ್ವೊಕೇಟ್ ಪರ್ಸ್ಪೆಕ್ಟಿವ್ ಅಲ್ಲಿ ನೀವು ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ ನಾನು ಐ ವಿಲ್ ಸಿ ಬೋತ್ ದಿ ಎಂಡ್
I understand
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ರೀ ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ಕೇಸ್ ಇಲ್ದಲೆ ಏನಕ್ಕೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ ಆಮೇಲೆ ನಿಮ್ಗೆ ಗೊತ್ತಲ್ಲ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ಲಾಯರ್ನ ಎಂಗೇಜ್ ಮಾಡ್ಕೋಬೇಕು ಅಂದ್ರೆ ಎಷ್ಟು ಕೊಡ್ಬೇಕು ಅಂತ ಹೈಕೋರ್ಟ್ ಇದು ಕೇಸ್ ಇದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ
yes madam
ಕೇಸ್ ಇದ್ರೆ ನಾನೇ ಕೊಡ್ತೀನಿ ಕೇಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ
ಅದು larger suit is still pending milord unless Kalachari gets a share
that is not a ground even if assuming that whatever the father share will come they are entitled for 1/5
yes, subject to milord the decree in OS 39 finality in OS 39
heard the appellant counsel and this matter is listed for admission the second appeal is filed against the concurrent finding the factual matrix of case of plaintiff before the trial court in OS number 64 of 2010 while claiming the relief of partition and separate possession in her favor of 1/5 share categorically pleaded that social properties are ancestral and joint family properties. And hence he is entitled for a share. And defendant number 2 took the specific defense that he had borrowed an amount of 3 lakhs of loan for development of the social property and equally liable to pay the said loan amount. And trial court having considered the material available on record comes to the conclusion that property is an ancestral property of the plaintiff and defendants, and in order to claim of the defendant is concerned, though documents exhibit D 5 to 15 are produced on demand promissory note, conclusion that which was borrowed is spent for the development of the property, nothing is placed on record, and hence granted 1/5 share. Being agreed by the said judgment and decree, an appeal is filed in RA number 3 of 2023. With regard to the contention of the appellant also that he dug the borewell is also concerned. Well, considering the point number 2, that is in respect of issue number 3 is concerned that he had spent the money. In paragraph number 17 of the appellate court judgment also made it clear that if really borewell is in existence and the same is locates, then the portion in which the borewell exists may be allotted to the second defendant, if it was not possible in final decree proceedings, then plaintiff may be asked to pay the cost incurred by second defendant for digging borewell. Even at the time of consideration of appeal also taken care of the interest of the appellant and confirmed the judgment of the trial court. Being agreed by the concurrent finding, present second appeal is filed before this court. The main contention of the counsel appearing to the appellant that in respect of the property of the father of the plaintiff and defendant, already a suit is filed in OS number 39 of 2012 and the said suit was not attained its finality. Question of granting the relief of partition doesn't arise. And also counsel would contend that the trial court and first appellate erred in granting 1/5 share to the plaintiff, and hence it requires interference of this court. The counsel also would immediately contend that both the courts have not taken note of section 1C of the Hindu Succession Act with regard to the liabilities in respect of the social property, and hence this court has to frame substantive question of law by admitting the second appeal. Having heard the appellant counsel and also considering the reasoning of the trial court and appellate court in a concurrent finding, it is the specific case of the plaintiff before the trial court that it is an ancestral property. And with regard to the reasoning of the trial court and appellate court that property is an ancestral property, appellant not disputes the same. And only grounds urged before this court, granting of 1/5 share is not correct. But the fact is that the original propositors of the family left his legal heirs, that is 5 children, is not in dispute. And hence the very contention of the counsel appearing to the appellant that 1/5 share is allotted is not correct, cannot be accepted. The other contention that original suit OS number 39 of 2012 is pending for consideration for final adjudication and appeal is pending. And the fact that the said suit also decreed is not disputed by the appellant. And when such being the case, and the said suit is among the father of the plaintiff and defendants and their brothers, and their brothers. And the fact that property is an ancestral property and share is granted 1/5 in respect of the share of the property of the father of the plaintiff and defendant. And hence the same will not come in the way. The other contention of the appellant counsel is that the judgment and decree passed by the trial court and appellate court is contrary to section 61C of the Hindu Succession Act. And to that effect also the trial court as well as the appellate court taken note of, even if he had borrowed the money from the some persons and placed on record document exhibit D 5 to 15, and nothing is placed on record that the amount which was borrowed was spent for the development of the property. And even an observation is made by the appellate court in paragraph number 17 with regard to, while allotting the share, if any borewell is located, if the amount borrowed is spent for the digging to dug the borewell, and the same can be allotted in favor of the appellant. And when such reasoning is also given by the appellate court, I do not find any force in the contention of the appellant counsel to admit and frame substantive question of law. And both the courts taken note of factual aspects as well as question of law, and hence not a case for, and hence no substantive question of law arises for the consideration of this second appeal. In view of the same, in view of the discussion made above, I pass the following order. Appeal is dismissed.
34 action, 35. VV Shivkumar.
Another 2 appeals are pending before this court, my lord. RSN 991 and 992. Connected this along with this appeal.
Connected under hengi arising out of common judgment.
Yes.
Same judgment.
Same
Different
Different appeal. Appellant counsel submits that other 2 connected appeals are pending arising out of the same judgment.
991, 992.
ಕೊಟ್ಬಿಡಿ ಅವರಿಗೆ. Hence the registry is directed to post those 2 appeals also. ಯಾವ year ಅವು? 24. Along with this appeal on 3010. ಹೌದು, ಅದ್ಯಾವುದು ಅಡ್ಮಿಟ್ ಆಗಿಲ್ವಾ? ಫಾರ್ ಅಡ್ಮಿಷನ್
36.
ನಾಯಕ್ ಕೆನಾರ್ ಪಟಿಷನ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಮತ್ತೇನ್ರಿ ನಿಮ್ದು?
My humble request is this. One of the brother who is a allotee of 3 acre 22 guntas. That is Kamala Nayak is whereabouts not known. His property is also available for partition because it has been restored by way of PTCL Act. That land has been granted in his favor. That property is also with the first respondent. My father was also grantee of 4 acres of land. That property is also with my brother first respondent. Now the other property, other 4 acres is also granted in favor of first respondent. At para number 34, page number 28, your words. That particulars are available. Now, however, all the properties are joint family properties except 4 acres, which is allotted in favor of my brother. The other property is 8 acres of land, which is available for partition. Because I am not having any document, therefore I have filed a suit against the state. Assistant Commissioner and Tahsildar, state party made, and my brother is also made. In that suit, my lord, my brother is not examined before the court. No document has been placed.
That suit came to be dismissed on the ground that all the parties are not before the suit. That taken advantage of that dismissal. Now res judicata has been brought in this case. Now all the family parties are before the court now. So therefore, all the properties are ancestral properties, because when we are in joint, in the year 1969, we are in joint possession. Therefore, all the properties are joint family property.
Issue number 1 is answered as negative.
Yes.
In coming to the conclusion that property is not an
But
ancestral
my
property.
34, para number 34, kindly maybe look at it.
Ancestral property ಅಲ್ವೇ ಅಲ್ಲ ಅಂತ.
ಅಲ್ಲ ಅಲ್ವೇ ಅಲ್ಲ ಅಂತಂದ್ರು ಕೂಡ. But
ಅಂದ್ರೂ ಕೂಡ ಅಂದ್ರೆ
partition is available now.
unless you prove that.
ಅಲ್ಲ, because my father's property, they are
father's
admitting.
property ancestral property ಆಗೋದಿಲ್ಲ.
ಅಲ್ಲ ಬೇಡ, ancestor ಆಗುದು ಬೇಡ ಸ್ವಾಮಿ. ಅವ್ರು ತೀರ್ಕೊಂಡ್ ಬಳಿಕ we are entitled ಅಲ್ಲ.
Entitled section 8 applies ಅಷ್ಟೇ.
Yes.
Whether father had executed any testamentary document.
No document has been
ಇಲ್ಲ.
executed.
ನಿಮ್ ಫಾದರ್ ಪ್ರಾಪರ್ಟಿ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಿ?
Hazard proceedings.
ಏನ್ ಹಾಕಿದಿರಿ?
That is the document placed by the respondent himself, your lordship.
ನೀವು ಯಾವ ದಾಖಲೆನೂ ಹಾಕಿಲ್ಲ.
Page number 22.
ಹಾ.
Para number 15. He himself placed the document. Certified copy of grant certificate in respect of Jayanaka, he is the brother. Certified copy of grant certificate in respect of Kamla Naik. And another grant certificate in favor of my father.
ಎಲ್ಲಿದ್ದಾರೆ? ಎಲ್ಲಿಂದ ಓದ್ತಾ ಇದೀರಿ ನೀವು ಅದು?
Page number 10, Swami, appellate court judgment.
Page number 10.
10, ink page number 22.
20?
22.
22 na?
Our last. 15 para. During pendency of the appeal.
Appeal ಅಲ್ಲಿ.
ಹೌದು. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಮಾಡ್ಲಿಲ್ಲ.
ಕೆಳಗಿನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಕೊಡ್ಲೇ ಇಲ್ಲ.
ಕೊಡ್ಲೇ ಇಲ್ಲ. But this application has been allowed, but I have not permitted to allowed only on passing of the judgment. Because he has not examined before the trial court. And based on the averments of the written statement, suit came to be dismissed.
ಅಲೋ ಮಾಡಿದ್ಮೇಲೆ ಅದ್ರ ಮೇಲೆ ಎವಿಡೆನ್ಸ್ ಮಾಡಕ್ಕೆ ಪರ್ಮಿಷನ್
ಮಾಡಲೇ ಇಲ್ಲ, ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಮಾಡಲಿಲ್ಲ, ಅಲೋ ಅಂತ ಮಾಡಿಬಿಟ್ರು.
ಬಟ್ ಅದ್ರ ಮೇಲೆ ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿದಾರ? ಏನು
ಕೊಟ್ಟಿಲ್ಲ ಸುಮ್ಮನೆ ಅಲೋ ಮಾಡಕ್ಕೆ. ಯಾಕಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದರೆ ಅಲೋ ಮಾಡಿ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ.
ಎಷ್ಟು ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ರಿ ನೀವು?
9 ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿ.
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ರೆಸ್ಪಾಂಡೆಂಟ್
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
ಅಪಲೇಟ್ ಕೋರ್ಟ್ ನ. That IA is allowed.
Documents mentioned in the list are sounds 41 rule 27. Grant certificate in respect of dated. ನಿಮ್ ಫಾದರ್ ಯಾವ್ದು ಇದ್ರಲ್ಲಿ?
ಫಾದರ್ದು 3ನೇ ಸಮ್.
ಕಮಲಾ ನಾಯಕ ಅಥವಾ?
ಕಮಲಾ ನಾಯಕ.
ಕಮಲಾ ನಾಯಕ್ ಯಾರು? ಮದರ್?
ಬ್ರದರ್. ವೇರ್ ಅಬೌಟ್ಸ್ ನಾಟ್ ನೋನ್.
ಬ್ರದರ್.
ಬ್ರದರ್ಸ್.
ಇನ್ನೊಬ್ಬ ಜಯ ನಾಯಕ್.
he is my elder brother.
ಲಕ್ಷ್ಮಣ್ ನಾಯಕ್ is
my
father. Father. ಎಷ್ಟು ಎಕರೆ ಇದೆ ಅದರಲ್ಲಿ?
4 ಎಕರೆ.
4 ಎಕರೆ.
ಅಲ್ಲಿ 3 ಎಕರೆ 22 ಗುಂಟೆ. ಕಮಲಾ ನಾಯಕ್.
ಕಮಲಾ ನಾಯಕ್ ಈಗ ಅವನು ಯಾವಾಗ ಮಿಸ್ಸಿಂಗ್ ಆಗಿದ್ದು? ನೋ ಇಶ್ಯೂಸ್.
ಎಲ್ಲಿ
ನೋ ಇಶ್ಯೂಸ್?
ಎಲ್ಲಿ ಇಲ್ಲ.
ಅಲ್ಲ ಅವನಿಗೆ ನೋ ಇಶ್ಯೂಸ್ ಅಂದೆ.
ಹೌದು.
If any property is granted in favor of the father only, then you are entitled for share in the property of the father.
Lakshman Naik.
Issue notice. And registry, in the meanwhile, registry is directed to get the records of trial court and appellate court. List this matter on 11/11. 37.
Kevin Narasimhan, Prasanna VR. Respond.
Suit for injunction. Ilva Euro. Pass over.
Yes.
38, Kalimullah Sharif.
ಇವರಿಗೆ ಹೇಳಿದ್ವಲ್ಲ ಮಧ್ಯಾಹ್ನ 2:30 ಬನ್ನಿ ಅಂತ. ಫೈಲ್ ಇಲ್ಲ ಅಂದ್ರು, ಫೈಲ್ ತಂದಿಲ್ಲ ಅಂತ.
39, Ramesh Kher.
In this matter, my lord, the defendants of
easementary right.
Ex parte judgment.
ABCD.
Your lordship may kindly peruse the
sketch at page 62, my lord. On the basis of this rough sketch, the trial court, without there being any supporting documents, my lord, ಇದೊಂದ್ರ ಮೇಲೆ ಡಿಕ್ರಿ ಮಾಡಿದರೆ expert judgment.
ಮತ್ ನೀವ್ ಹೋಗ್ದವ್ರೆ ಅವ್ರಿಗೇನು
ಅದರಲ್ಲಿ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನವ್ರು ಏನ್ ಮಾಡ್ಬೋದು? ನಿಮ್ಗೆ ಸರ್ವಿಸ್ ಆಯ್ತಾ ಇಲ್ಲ?
ಫಸ್ಟ್ ಅಪ್ಲೈಡ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ನಿಮಗೆ ಸರ್ವಿಸ್ ಆಯ್ತಾ ಇಲ್ಲ?
ಆಗಿತ್ತು ಸ್ವಾಮಿ.
ಮತ್ ನೀವು ಕಂಟೆಸ್ಟ್ ಮಾಡಿದವ್ರು ಏನ್ ಮಾಡ್ಬೇಕು?
80 ವರ್ಷ ಆಗಿರುತ್ತೆ ಅವರಿಗೆ.
ಓನ್ಲಿ ರೈಟ್ ಆಫ್ ಈಸ್ಮೆಂಟ್ರಿ ರೈಟ್ ಕೇಳಿದಾರೆ, ABCD ಪಾತ್ವೆ ಅಂಡ್ ಆಲ್ಸೋ ಫಾರ್ ಪರ್ಮನೆಂಟ್ ಇಂಜಂಕ್ಷನ್ ಅಂಡ್
RTC ಮಾರ್ಕ್ ನನಗಿರೋದು 12 ಕುಂಟೆ ಜಮೀನು, ಅದ್ರಲ್ಲಿ ದಾರಿ ಇದೆ ಅನ್ನೋದಕ್ಕೂ ಪ್ರೂಫ್ ಇಲ್ಲ, ಅಥವಾ ಅವ್ರ ದಾರಿ ಅವ್ರ ಪ್ರಾಪರ್ಟಿಗೆ ಇಲ್ಲ, ಇದೆ ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅದು ಇಲ್ಲ. ಫಸ್ಟ್ ಅಪ್ಲೈಡ್ ಕೋರ್ಟ್
ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅನ್ನೋದನ್ನ ಯಾರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕ್ರಿ? ಆಲ್ಟರ್ನೇಟಿವ್ ಪಾತ್ವೆ ಇದೆ ಅನ್ನೋದನ್ನ ಯಾರು ಪ್ರೂವ್ ಮಾಡ್ಬೇಕು?
The first appellate court has dismissed the appeal on the ground of delay. ಇದನ್ನ
ಎಷ್ಟು ದಿವಸ ಇದೆ ಡಿಲೇ?
ಡಿಲೇ 2 months ಇದೆ, ಬಟ್ ಫಸ್ಟ್ ಅಪ್ಲೈಟ್ ಕೋರ್ಟ್ ಅವರು ಇದನ್ನ ಎಕ್ಸ್ಕ್ಲೂಡ್ ಮಾಡ್ಲಿಲ್ಲ. ಕೋವಿಡ್ ಪೀರಿಯಡ್ ನ 716 ದಿವಸ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಇರುತ್ತೆ ಸ್ವಾಮಿ.
ಡಿಗ್ರಿ ಪಾಸ್ ಇನ್ ಸೋನ್ಸೋ ಕನ್ಫರ್ಮ್.
ಡೇಟ್ ಆಫ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಸ್ 21/2020. ಡೇಟ್ ಆಫ್
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಯಾವಾಗ?
21/2020.
January 23.
ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಅವಾಗ ಏನ್ ಯಾವ ಕೋವಿಡ್ ಇಲ್ಲ
ಅಲ್ಲ, ಮಾರ್ಚ್ ವಿತ್ ಇನ್ ದಿ ಲಿಮಿಟೇಷನ್ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ಸೂಟ್ ವಾಸ್ ಫೈಲ್ಡ್ ಇನ್ 2018. ನಿಮಗೆ ಸರ್ವ್ ಆಗಿದೆ ಯಾವಾಗ ಹೇಳಿ?
ಅಲ್ಲ, ನಾನು ಅಪೀಲ್ ಇಸ್
ನಿಮಗೆ ಸರ್ವ್ ಆಗಿದೆ ಯಾವಾಗ? ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ
ನೋಡಿ, ಇನ್ ಟೈಮ್ ಅಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮತ್ತಿನ್ನೇನು 2 ವರ್ಷ ನಿಮ್ಮನ್ನ ಕಾಯ್ದವ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡಕ್ಕಿಂತ ಮುಂಚೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ, ಹೌದಾ? Under unregistered property dated 10/2/9, since then the plaintiff has been in possession and enjoyment of the defendant is having land towards the plaintiff property bearing certain positions and are totally measuring 25 kuntas, out of which kuntas of northern portion fell to the share of defendant. Defendant has constructed his residential house towards southwest and constructed coconut shed towards east of so and so. In between house and coconut shed 40 feet vacant space. After the said property, plaintiff and defendant is having cultivable land. Since from the time of his father passing through the property of defendant in the northern side of the notary has been used as a pathway. ಎಲ್ಲ ಅಂತಂದಿರು ಅದ್ರಲ್ಲಿ ಏನ್ರಿ ಅದು? PWD road towards the west of the defendant property, which runs north south from the Bay Ghat. ABCD pathway as shown in the plaint rough sketch. Since from the time of plaintiff and defendant father, the same has been used by the plaintiff without any interruption, openly, hostilely, visibly, more than 25 years to the knowledge of the defendant and plaintiff had so and so.
Allah, WhatsApp may kindly appreciate, merely on the basis of this rough sketch, without there being any making out of case, the trial court has decreed. First appellate court opportunity kodlilla, delay mele hodta, delay mele appeal has been dismissed, my lord. An opportunity, my lord, may kindly
PCD.
May kindly be remanded, my lord, so that
ಅಲ್ಲ ರೀ, ಪ್ರಾಪರ್ಟಿ ಆ ಪ್ಲೇಂಟಿಫ್ ಹೆಂಗ್ರಿ ಹೋಗ್ತಾರ ಮತ್ತ ಅವರು?
ಅಲ್ಲ, ಬೇರೆ ದಾರಿ ಇದೆ.
ಎಲ್ಲಿದೆ ತೋರಿಸಿ ನೀವು.
ಬೇರೆ ದಾರಿ ಇದೆ.
ನೀವೇನು ತೋರಿಸಿಲ್ಲ, ಹೇಳಿಲ್ಲ, ಏನು ಮಾಡಿಲ್ಲ, ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ?
ಎಕ್ಸ್ಪರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್
ಅಪೀಲ್ ಅಲ್ಲಿ ಏನಾಯ್ತು?
ಅಪೀಲ್ ಅಲ್ಲಿ ಲಿಮಿಟೇಷನ್ ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು, saying that, my lord, without excluding the delay
sufficient grounds to condone the delay. Learned trial judge failed to consider the fact that as per the rough sketch there is an alternative road for the plaintiff to reach his land. ಇಲ್ಲ, but not only delay no consider ಮಾಡವ್ರೆ, even merits ಮೇಲೂ consider ಮಾಡವ್ರೆ. Point number 2 also answered. Point number 3 also answered. Not only on delay.
ಇದರಲ್ಲಿ based on the rough sketch, your lordship may kindly ಇದರಲ್ಲಿ
ಅಲ್ಲ ರೀ, ನೀವು ರೀಸನಿಂಗ್ ನೋಡ್ರಿ, ಅಪರೆಂಟ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಮೂರ್ ಪಾಯಿಂಟ್ ರೈಸ್ ಮಾಡಿದ್ದಾರೆ. ಆಲ್ ದಿ 3 ಆರ್ ಆನ್ಸರ್ಡ್.
ಪ್ಲೀಸ್.
ಮತ್ತೆ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್ಸ್ ಏನ್ ಹಾಕಿದ್ರಿ ಡಿಲೇಗ್? ಅದು 23ನೇ ಇಸ್ವಿದ್ ಹಾಕಿದಿರಿ. ಅದೆಲ್ಲ ನೋಡ್ ಬರ್ದಿದಾರ್ರಿ, ಡೀಟೇಲ್ ಆಗಿ ಬರ್ದವ್ರು ನೋಡಿ. 18 ಅಲ್ಲಿ, ಪ್ಯಾರಾ 18 ಅಲ್ಲಿ. ಆಮೇಲೆ ಲಿಫ್ಟಿಂಗ್ ಆಫ್ ಕೋವಿಡ್ ಆಲ್ಸೋ ಇಸ್ ಮೆನ್ಷನ್ಡ್ ಇನ್ 2021 ಇಟ್ ಸೆಲ್ಫ್. ನೀವು ಅಪೀಲ್ ಹಾಕಿರೋದು 22 ನಲ್ಲಿ.
20 ನಲ್ಲಿ ಕೋವಿಡ್ ಇರ್ಲಿಲ್ಲ, 20 ಫೆಬ್ರವರಿನಲ್ಲಿ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
ನೋ ಗ್ರೌಂಡ್. ಅವರು ನಿಮ್ಮ ಅಣ್ಣ ತಮ್ಮದಿರು, ಅವ್ರಿಗೆ ಪ್ಲೇಂಟಿಫ್ ಗೆ ಪ್ರಾಪರ್ಟಿ ಬ್ಯಾಕ್ ಸೈಡ್ ಇದೆ, ನಿಮ್ ಪ್ರಾಪರ್ಟಿ ಫ್ರಂಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇದೆ,
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
ದಾರಿ ಇಲ್ಲ. ಕೊಡಿ ಏನಾಗಲ್ಲ.
ಅಲ್ಲ ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ರೆ
ಏನ್ ಆಪರ್ಚುನಿಟಿ ಕೊಡು ತೊಗೊಳ್ಳಿ. This matter is listed for admission.
ಅಲ್ಲ ಇರೋದು 12
Heard the appellant counsel. This second appeal is filed against the judgment of granting easementary right. The factual matrix of the case of the plaintiff in OS number 349 of 2018 while seeking the relief of easementary right. It is specifically pleaded that in between house and coconut shed, 40 feet vacant space, and after the said up to the property of plaintiff, the defendant is having cultivable land. Since from the time of his father, the plaintiff is passing through the property of defendant in the northern side to reach his land, and same has been used as pathway which is runs east to west, which is suit scheduled property. There is a PWD road towards the west of defendant property which runs north south from the to Kadabal sketch. Since from the time of plaintiff's and defendant father, the same has been used by the plaintiff without any interruption, openly hostilely, visibly more than 25 years to the knowledge of defendant and other adjacent owners of the land. The plaintiff gained access to his property, which is situated towards east of the defendant property from the said PWD road through the property of defendant ABCD pathway as shown. The said road is absolute necessity for plaintiff for enjoyment of his property. The plaintiff has acquired the ABCD pathway by way of prescriptive right and also by way of easement of necessity. Now the defendant is trying to obstruct and using of the said pathway and hence filed the suit. In the said suit, notice was issued, summons was issued to the defendant, and he has appeared through his counsel, but he has not filed any written statement to contest the case. And hence the plaintiff examined himself as PW1 and got marked document exhibit P1 to 4, and also examined one witness as PW2. The trial court, having considered the pleadings of the plaintiff, formulated the point whether plaintiff proves that there is existence of ABCD pathway as per plaintiff sketch and same is using by the plaintiff to reach his property, and whether defendant is interfering. And having considered both oral and documentary evidence available on record, particularly the RTC extracts as well as oral evidence of PW1 and 2, trial court comes to the conclusion that there is no any other alternative way to reach the property of the plaintiff. And in paragraph number 10, in detail discussed the same and also taken note of the plaintiff sketch, which clearly mentioned towards northern side of the defendant property. He has shown the road to his property. First off, on the other hand, though the defendant appeared through his counsel, but he did not file any written statement and contest the matter. And hence it is clear that defendant had the knowledge of filing of the suit and did not object for the pathway of ABCD which is shown in the rough sketch, and hence trial court granted the relief. Being agreed by the said judgment and decree, appeal is filed in 2022, though the judgment of trial court was passed in 2020 itself. And though there was a delay, and trial court taken note of the delay aspect as well as the merits of the case by framing point for consideration. in respect of delay, point number 1, and with regard to the sketch and reasoning of the trial court, point number 2, and point number 3, whether it requires interference of this court. And the first appellate court, having considered the delay aspect is concerned, also taken note of judgment was passed on 21/20/20, and also taken note of, though it is pleaded that immediately COVID period was prevailing, but COVID lockdown was also lifted in the year 2021 was taken note of in paragraph number 18, and the appeal is filed in 20. Hence comes to the conclusion while answering point number 1 that delay has not been properly explained. And though a document was placed before the court with regard to the health condition is concerned, that is exhibit A2, and the same is of the year 2023. But appeal was instituted in the year 2022 itself, and hence did not accept the same. And apart from that, the appellate court also taken note of the pleadings of the and also taken note of when the defendant has not contested the suit by filing his written statement, and the fact that suit was filed in 2018 and the same was disposed of in 2020, and the same is not registered. And counsel appearing to the appellant would contend that an opportunity may be given, and question of giving opportunity on whims and fancy of the appellant doesn't arise. And when sufficient time he was having, and when the summons was served and represented through counsel, he did not file any written statement and not contested the matter, and even appeal was also filed in 22 after the initiation of suit in the year 2018 after four years. And when such being the case, and also records discloses that the plaintiff and defendant are the brothers.
Plaintiff and brothers alla
TV Lakshmana Goreಗೌಡ
please your lordship
cousins ಇರಬೇಕು ನೋಡಿ.
ಇದರಲ್ಲಿ ಪೇಜ್ 62 ನಲ್ಲಿ ನೋಡಿ ಅವ್ರಿಗೆ ಬೇರೆ ಅವರಿಬ್ರು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಳ್ಬೇಕಾದ್ರೆ ದಾರಿನ ಬಿಟ್ಟಿಲ್ಲ.
ಯಾರಿಬ್ರು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೋಬೇಕು?
ಡಿಫೆಂಡ್ ಪ್ಲೇಂಟಿಫ್ ಇಸ್ ಬ್ರದರ್ಸ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಪೆರೋಸ್ ಪೇಜ್ 62 ಅವ್ರದೇ ಸ್ಕೆಚ್ ಎಲ್ಲ ಅವ್ರದ್ದು ಬ್ರದರ್ ಪ್ರಾಪರ್ಟಿ ತೋರಿಸ್ತಾರೆ.
ಆಯ್ತು ಬಿಡಿ, ಅದು ಬಿಟ್ಟೆ ಬಿಡಿ, ಏನಾಯ್ತು ಹೇಳಿ, ನೆಕ್ಸ್ಟ್ ಬೇಡ.
ಆ 62 ಪೇಜ್ ಮೈ ಕೈಂಡ್ಲಿ ಅಲ್ಲಿ ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ ಇದೆ, ಅದ್ರಲ್ಲಿ ದಾರಿ ಬಿಟ್ಕೊಳ್ಳಲ್ಲ, ನಮ್ಮದ್ರಲ್ಲಿ ಕೇಳ್ತಾರೆ.
ಆ ಕಡೆ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಅವ್ರದ್ದು ಅಲ್ರಿ ಅದು.
ಇಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಆಫ್ ದಿ
ರಫ್ ಸ್ಕೆಚ್ ನೋಡ್ರಿ, ರಫ್ ಸ್ಕೆಚ್ ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕಿರೋದು.
ಅಲ್ಲಿ ಡಿಫೆಂಡೆಂಟ್
ನಿಮ್ಮವನ ಹೆಸರೇನು ಹೇಳಿ?
ಡಿಫೆಂಡೆಂಟ್ಸ್ ಪ್ರಾಪರ್ಟಿ ಕೆಳಗಡೆ
ನಿಮ್ಮವನ್ ಪ್ರಾಪರ್ಟಿ ರೋಡಿಗೆ ಅಪಟ್ಟಂಗ್ ಆಗಿದೆ, ಹೌದಾ?
ಹೌದು.
PWD ರೋಡಿಗೆ ಅಪಟ್ಟಿಂಗ್ ಆಗಿ
ಅಲ್ಲ, ಅವ್ರದ್ದು ರೋಡಿಗೆ ಅಪಟ್ಟಿಂಗ್ ಆಗಿದೆ.
ಎಲ್ಲಿದೆ?
ಇಮಿಡಿಯೇಟ್ ಕೆಳಗಡೆ
ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ ಬ್ಯಾಕ್ ಸೈಡ್ ಇದೆ ರೀ.
ಅಲ್ಲ, ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಪ್ಲೇಂಟಿಫ್ಸ್ ಬ್ರದರ್ ತಿಮ್ಮೇಗೌಡ ಅಲಿಯಾಸ್ ತಿಮ್ಮಯ್ಯ ಅವರಿಬ್ರು ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಾಗ ಇಲ್ಲಿ ಎರಡನೇದು ಡಿಫೆಂಡೆಂಟ್ಸ್ ಪ್ರಾಪರ್ಟಿ ಪಕ್ಕದ್ದು ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ
ಆಫ್ ಪ್ಲೇಂಟಿಫ್ ಬ್ರದರ್ ತಿಮ್ಮೇಗೌಡ
ಇದು ಅವ್ರ ಪಾರ್ಟಿಷನ್ ಮಾಡುವಾಗ ಇಲ್ಲಿ ಜಾಗ, ಇಲ್ಲಿ ರೋಡ್ ಇಂದ ಜಾಗ ಇದೆ, ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ.
ಅದನ್ನ ಕೇಳೋದಿಲ್ಲ, ಮೊದ್ಲಿಂದ ಅವ್ರು ಯೂಸ್ ಮಾಡ್ತಾ ಇರೋದೇ ಈ ರೋಡ್ ಅಂತ ಅವ್ರು ಹೇಳಿದಾರಲ್ಲ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ. ಆ ಪ್ಲೀಡಿಂಗ್ ಅದು
ಅಲ್ಲ, ಯೂಸ್ ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ.
ನೀವೇನು ಹಾಕೇ ಅಲ್ವಲ್ಲ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಏನು ನಾಟ್ ಡಿನೈಡ್ ಅಟ್ ಆಲ್.
ಅಪರ್ಚುನಿಟಿ
ಏನ್ ಅಪರ್ಚುನಿಟಿ ಈಗ ಕೊಡೋದು? 14 ವರ್ಷದ ಮೇಲೆ
ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಅವ್ರದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ ಅವ್ರದೇ ಥ್ರೂ ಅಪ್ರೋಚ್ ಇದೆ, ಸುಮ್ಮನೆ ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ ಥ್ರೂ ಅಲ್ಲಿ ಈ ಡಿಡ್ ನಾಟ್ ಸೇ ಎನಿಥಿಂಗ್ ಅಬೌಟ್ ದಟ್. ಅವ್ರ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಾಗ ಅಲ್ಲಿ ಅವ್ರು ತಗೊಳ್ತಾರೆ, ಇಲ್ಲಿ ಇವ್ರು ತಗೊಳ್ತಾರೆ, ಇಲ್ಲಿ ರೋಡ್ ನಮ್ಮದ್ರಲ್ಲಿ ಕೇಳ್ತಾರೆ.
Kindly see in the
could have sought for road in that property.
Next to that property itself, property of Manjegoda is a third party, my lord. That is a third party. We can't have an access. So we need to bypass the two property if the very contention of the appellant has been taken into consideration, at least for the sake of argument. Whereas the trial court, which is rightly held, is the proper pathway which we are using from time immemorial.
Property of Manjegoda.
That is is also a third party.
Back side on adjacent property belongs to someone else.
ಇವ್ರಿಬ್ರು ಪಾರ್ಟಿಷನ್ ಮಾಡಾಗ ಅವ್ರಿಗೆ ಬರಕ್ ಚಾನ್ಸಸ್ ಇಲ್ಲ.
ಫಸ್ಟ್ ಪಾರ್ಟಿಷನ್ ಏನ್ ಬರ್ತದೆ?
ಅಲ್ಲ ಇವು ಪ್ರಾಪರ್ಟಿ ಆಫ್ ದಿ ಪ್ಲೇಂಟಿವ್ಸ್ ಬ್ರದರ್.
ಆಯ್ತ್ರಿ ಅವ್ನ ಪ್ರಾಪರ್ಟಿಗೆ ಹೆಂಗ್ರಿ ಹೋಗ್ಬೇಕು ಮತ್ತೆ ಪ್ಲೇಂಟಿವ್ ಪ್ರಾಪರ್ಟಿಗೆ?
ಬ್ರದರ್ಸ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಹೋಗ್ಬೋದಿತ್ತು.
ಹೆಂಗ್ ಹೋಗಕ್ಕಾಗುತ್ತೆ? ಬದರ್ ಪ್ರಾಪರ್ಟಿ ಇವನ್ ಡಿಪೆಂಡೆಂಟ್ ಪ್ರಾಪರ್ಟಿಯ ಪಕ್ಕದಲ್ಲಿ ಇದೆ. ಅವ್ನ ಹಿಂದ್ಗಡೆ ಪ್ರಾಪರ್ಟಿ ಇರೋದು ಪ್ರಾಪರ್ಟಿ ಆಫ್ ಮಂಜೇಗೌಡ. ದೇರ್ ಇಸ್ ಎ ಫೋರ್ಸ್ ಇನ್ ಹಿಸ್ ಸಬ್ಮಿಷನ್. ಈ ಬ್ರದರ್ ಪ್ರಾಪರ್ಟಿ ಪೂರ್ತಿ ಇದ್ದಿದ್ರೆ ನೀವ್ ಹೇಳಂಗೆ, ಇಫ್ ಇಟ್ ಇಸ್ ಕಂಟಿನ್ಯೂಡ್ ಫುಲ್ ಎಕ್ಸ್ಟೆಂಟ್, ದೆನ್ ಯುವರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕ್ಯಾನ್ ಬಿ ಅಕ್ಸೆಪ್ಟೆಡ್.
ಅಲ್ಲ ಅವಾಗ ಇನ್ ಸಚ್ ಅನ್ ಇವೆಂಟ್ ಮೇಲೆ ಆ ಎಂಡ್ ಅಲ್ಲಿ ನಮ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲೂ ಬ್ರದರ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲೂ ನಮ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲೂ ಸೇರ್ಸ್ ರೋಡ್ ಕೊಡ್ಬೋದಾಯ್ತು. ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಆದ್ರೆ ನನ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲೂ ಬ್ರದರ್ ಪ್ರಾಪರ್ಟಿನಲ್ಲೂ ಸೇರ್ಸ್ ರೋಡ್ ಕೊಡ್ಬೋದಾಯ್ತು.
ಈಸ್ಮೆಂಟ್ರಿ ರೈಟ್ ಅನ್ರಿ ಬರೋದು.
ಅಲ್ಲ ಅದು ಹೌದು, ಬಟ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಪ್ರೂವ್ಡ್. ಅಲ್ಲಿ ಏನು ಇಲ್ಲ ಅನ್ನೋದು ಏನು ಪ್ರೂವ್ ಮಾಡಲ್ಲ.
ನೀವು
ಅದು ದಟ್ ಇಸ್
ನೀವ್ ಹೇಳ್ಬೇಕಿತ್ತು.
ಅಲ್ಲ ಅದನ್ನ
ಇಲ್ಲ ಅವನಿಗೆ ಬೇರೆ ಆಲ್ಟರ್ನೇಟಿವ್ ಇದೆ. This cannot be an easementary right ಅಂತ.
ಅಲ್ಲ ಹೆಲ್ತ್ ಇಶ್ಯೂಸ್ ಇದೆ, ಏಜ್ಡ್ ಅಬೌಟ್ 80 years, ಅದನ್ನ ಫಾಲೋ ಮಾಡಿಲ್ಲ. ಒಂದು ಅವಕಾಶ ರಿಮಾಂಡ್ ಮಾಡೋ ಒಂದು ಅವಕಾಶ ಕೊಟ್ಟರೆ
ಏನ್ ರಿಮಾಂಡ್
ಟೈಮ್ ಫ್ರೇಮ್
ಬಂದಾಗೆಲ್ಲ ರಿಮಾಂಡ್ ಮಾಡೋದು
ಸೇರಿಸ್ಕೊಟ್ಟು ಸೇವ್ ಮಾಡಬಹುದಿತ್ತು ಸ್ವಾಮಿ. ಅವ್ರದೇ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ನನಗೆ ಕೊನೆ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಒಂಚೂರು ಜಾಗ ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ರು ಆಗಿತ್ತು. ಅವ್ರದೇ ಪ್ರಾಪರ್ಟಿ ಡಿವೈಡ್ ಮಾಡ್ಕೋಬೇಕಾದ್ರೆ ಜಾಗ ಬಿಡ್ಕೊಳ್ಳೋದನ್ನ ಡಿವೈಡ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ನನ್ನ ಪ್ರಾಪರ್ಟಿನಲ್ಲಿ ಕೇಳ್ತಾರೆ. ಇಟ್ ರಿಕ್ವೆಸ್ಟ್ ರೀಕನ್ಸಿಡರೇಷನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ give an opportunity within a time from 3 months.
No, my lord. Serious objections by that. Even RA court has been clearly upheld with the same judgment by the trial court, where the first appellate court, after giving due opportunities, whatever the appellant now is pleading before this honorable court, could not even establish their merits. And this is the second appellate court. Now they are coming up with the option that should be one more opportunity should be considered. Cannot be accepted, my lord.
ಏನಾಯ್ತು ಮೇಡಮ್? ಆಫ್ಟರ್ 4 years.
ಅಲ್ಲ 2 years.
ಅಲ್ಲ ರೀ ಸೂಟ್ ನೀವು ಸೂಟಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿರೋದು ಯಾವಾಗ? 2018 ಅಲ್ಲೇನೆ. 4 years. ಅಂಡ್ ಆಲ್ಸೋ
ಅಲ್ಲ 20 ನಲ್ಲಿ ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
20 ಡಿಸ್ಪೋಸ್ ಆಯ್ತ್ರಿ. ನೀವು ಸೂಟಲ್ಲಿ 2018 ಅಪಿಯರ್ ಆಗಿದ್ದೀರಿ. 18 ಇಂದ 22 ವರೆಗೆ ನೀವು ಏನು ಮಾಡಿಲ್ಲ.
ಅಲ್ಲ ಅಪೀಲ್
ಈಗ ಆಪರ್ಚುನಿಟಿ ಕೊಡಿ ಅಂತ ಕೇಳ್ತೀರಿ. ಅಪೀಲ್ ಬಿಟ್ಬಿಡ್ರಿ. ಅಪೀಲ್ ಆಯ್ತು, ಸೂಟ್ ಇದೆಯಲ್ವಾ? ಸೂಟಲ್ಲಿ ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ದ ಯಾವಾಗ? 2018 ಅಲ್ಲೇನೆ.
2 ವರ್ಷದೊಳಗಡೆ
ಮತ್ತೆ ಅಲ್ಲೇನು ಮಾಡ್ಲೇ ಇಲ್ಲ.
2.5 ವರ್ಷದೊಳಗಡೆ
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? And also the pleadings of the plaintiff remained unchallenged. And the same is considered by the appellate court when the argument was addressed with regard to point number 2 and 3 in paragraph number 35 of the judgment of the first appellate court. And when the appellant did not challenge the pleadings of the plaintiff with regard to the existence of pathway, that is ABCD, which leads to the property of the plaintiff, and also the records rough sketch clearly discloses that the property of the defendant is abutting to the property of the PWD road. In order to access the property of the plaintiff, only the pathway ABCD is the easementary right to go to the property of the plaintiff. And when such being the case, I do not find any force in the contention of the counsel appearing to the appellant. And nothing is on record to substantiate the contention of the appellant. And also nothing is placed before this court as well as before the first appellate court that the plaintiff is having an other alternative access to ingress and egress the property of the plaintiff. And when such being the case, I do not find any ground to admit and frame substantive question of law. Any of the discussions made up, I pass the following order. Second appeal is dismissed.
40 and 41. PF Kumbar.
Copies, sir. KVT respondent number 5, contesting respondent died after filing the appeal during the pendency of the appeal before this court on 21/3.
He died on 23/4.
23/4/25. He is a contesting respondent. I am the KVT respondent number 5.
If my lawyer friend furnishes the particulars that I can.
I'll furnish.
Make necessary.
I'll furnish.
Counsel appearing to the respondent files memo stating that respondent number 5 passed away on 23/4/2025. and death certificate will be furnished in the next date of hearing. The counsel appearing with the appellant seeks details to bring the LRs of respondent number 5, and counsel for the respondent undertakes to furnish the same in the next date of hearing, and hence yes yavat ಬೇಕು list yavat ಕೊಡ್ತೀರಿ details list this
What
matter
I
on.
request is I'll furnish it within weeks. Let him file application, it will come up before the court.
Undertakes to furnish the details within 1 week.
Please.
And hence appellant counsel is given 2 weeks time to
Please.
file necessary application to bring the LRs.
Much.
List this matter on 3010.
42. Narendra Babu BK.
ಏನಾಯ್ತ್ರಿ ಮೀಡಿಯೇಷನ್?
Mediation fail ಆಯ್ತು.
ಹೌದಾ?
Not agreed for. ಅದು ಪ್ರಪೋಸಲ್ ಅವ್ರು ಯಾರು ಒಪ್ಪಲಿಲ್ಲ ಅಂತ ಹೇಳಿ ವಾಪಸ್ ಹಾಕಿದ್ದಾರೆ. ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ. It's failed. Mediation.
ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ವಾ?
ರಿಪೋರ್ಟ್ ಬಂದಿಲ್ಲ.
ನಾನ್ receipt of mediation report from Kundapur mediation center ಬರ್ಲಿಲ್ಲ ಮೇಡಮ್ ನೋಡಿ?
It's failed.
ಹಾ
2 months ಆಯ್ತು ಆಲ್ರೆಡಿ. Mediation fail ಆಗಿ 2 months ಆಯ್ತು ಅವ್ರು ಕಳಿಸಿಲ್ಲ.
ಹೌದಾ?
So in the meantime what happened now, ಇವ್ರಿಗೆ ಯಾರಿಗೆ ಲಾಟ್ಸ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದ ಸ್ಕೆಚ್ ಅರ್ಲಿಯರ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಅದರಲ್ಲಿ
ಲಾಸ್ಟ್ ಟೈಮ್ ಹಾಕಿದಿರಲ್ಲ ಅದು.
ಹೌದು ಸ್ವಾಮಿ. ಅದರಲ್ಲಿ ಇವಾಗ ಏನಾಗಿದೆ, ಅವ್ರು ಮುಂಚೆ ಕೊಟ್ಟವ್ರಿಗೆ ಅಂದ್ಬಿಟ್ಟು ಐಟಮ್ ನಂಬರ್ 1 ಇದೆಯಲ್ಲ, ಆ ಪಕ್ಕದ ಲ್ಯಾಂಡ್ ಅವರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ಅಂತ ಹೇಳಿ ಒಂದು ಮರವನ್ನ ತೆಗೆದು ಕಟ್ ಮಾಡಕ್ ಹೇಳಿದ್ರು, ಮಾಡಿದ್ರು. ಟೇಕಿಂಗ್ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ದಟ್ ನಾವು 9 ಟೀಕುಡ್ ಮರ ಒಂದು ಇದ್ರದ್ದು ಕಾಡ್ ಮರನ ಕಟ್ ಮಾಡಿಟ್ಟಿದ್ದಾರೆ. ನಾವು ದೇ ಆರ್ ಟ್ರೈಂಗ್ ಟು ಸೆಲ್ ದಟ್ ಮರಗಳನ್ನು ಕೂಡ. ಸೊ ದಟ್ಸ್ ವರ್ತ್ ಅಬೌಟ್ 8 to 9 lakh rupees ವರ್ತ್ 10 ಮರ ಕಡ್ದಿದ್ದಾರೆ. ಸೊ ಅವ್ರಿಗೆ ಅದು ಕಡಿಬೇಡಿ ಅಂತ ಹೇಳಕ್ ಹೋದ್ರೆ, ನೀನ್ ಯಾರು ಹೇಳಕ್ಕೆ, ನನಗೆ ಸ್ಟೇ ಇಲ್ಲ ಏನಿಲ್ಲ, ನಾನು ಮಾಡ್ಕೊಂತೀನಿ, ಏನಾದ್ರು ಮಾಡ್ಕೊಂತೀನಿ, ಯು ಕೆನಾಟ್ ಕ್ವಶ್ಚನ್ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದು ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಲಾರ್ಡ್ಶಿಪ್ ಡೈರೆಕ್ಟೆಡ್ ಆಲ್ಸೋ ಅವರಿಗೆ.
I am representing the respondent number 22-23. You are not
22-23 na
20 ರಿಂದ 23 I am representing respondent number.
Yes, I represent respondent number 2.
ನೀವು respondent number 2. ಮರ ಕಡ್ದಿರೋದು ಯಾರು ಹೇಳ್ರಿ?
ಹೌದು, ಜಯಂತಿ ಅನ್ನೋರು ನಂಬರ್ 1 ಐಟಮ್ ನಂಬರ್ 1 ಅಲಾಟ್ ಮಾಡಿರೋದು.
ಐಟಮ್ ನಂಬರ್
1
I represent.
ನೀವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
I don't have instructions with regard to this matter.
ಅದು ಆಲ್ರೆಡಿ ಪಾರ್ಟಿಷನ್ ಆಗಿದೆ.
Please minutes. Demarcated also.
ಆಗಿದೆ. ಮತ್ತೆ ನೀವು why have removed the tree?
ಅಲ್ಲ, that belongs to their
removed.
ಅಲ್ಲ, that belongs to allotted to their property.
ಅಲಾಟ್ ಆಗಿರೋದೇ ಅವ್ರು ಕ್ವಶನ್ ಮಾಡ್ಕೊಂಡು ಬಂದಿರೋದು.
ಅದೇ
ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡಿರೋದೇ ನಾಟ್ ಕರೆಕ್ಟ್ ಅಂತ ಅವ್ರು ಕ್ವಶನ್ ಮಾಡಿ RIC
they are seeking only the pathway road,
not regarding
this.
Area allotment is question.
Allotment is question.
Area allotment is question. ನಿಮಗೆ ಐಟಮ್ ನಂಬರ್ 2
ಐಟಮ್
ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಂಬರ್ 2 ನಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇ ಬ್ಯಾಕ್ ಸೈಡ್ ಇದೆ ಅಂತ.
ನಮಗೆ ಮೇಜರ್
ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ ರೋಡ್ ಇಲ್ಲ ಅಂತ ಅವ್ರದ್ದು.
ಮತ್ತೆ ಅವ್ರಿಗೆ ಬೇಕಲ್ಲ.
ಅಲ್ಲ, ಅದಕ್ಕೆ ರೋಡ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
The contention was that matter in the previous occasion, saying that the road which was allotted to them, it is not enough, and in the carving they cannot take the vehicle ಅಂತ ಹೇಳಿ objection ಇತ್ತು.
ಅದು ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಕೊಟ್ರೆ ನಾವು ಮಾಡ್ಕೋತೀವಿ ಅಂತ ಅವರು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ.
That's the reason lordship has sent this mediation. And that road has been obstructed ಅಂತ ಹೇಳಿ contention ಇತ್ತು.
ಏನ ಮರಗಳಿತ್ತು ಅಂದ್ರಲ್ಲ, ಅದು ಯಾವ ಜಾಗದಲ್ಲಿ ಇತ್ತು?
ಈ ಐಟಮ್ ನಂಬರ್ 1 ಅವರಿಗೆ ಈ ಲೈನ್ ಅಲ್ಲಿ ಫುಲ್ ಮರಗಳಿತ್ತು. ಎಲ್ಲ ಮರನೂ ಕಡಿದು ಬಿಟ್ಟಿದ್ದಾರೆ. ಫುಲ್ 10 ಮರ ಇತ್ತು, 10 ಮರನೂ ಕಡಿದು ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅವ್ರ ಪ್ರಕಾರನೇ ಅದು ರೋಡ್ ಮಾಡಕ್ಕಾಗಿ ಒಂದ್ ಮರ ಕಡಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ ರೋಡ್ ಮಾಡಕ್ಕೆ ಪಕ್ಕದ ನೇಬರ್ಸ್ ಪಕ್ಕದಲ್ಲಿ ಮನೆ ಇದೆ, ಆ ಮನೆಯವರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು, ನಿಮ್ದು ಮರ ಬಿದ್ರೆ ನಮಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ ಅಂತ. ಅದಕ್ಕಾಗಿ ಒಂದ್ ಮರವನ್ನ ಕಡಿಯುವ ಅವಶ್ಯಕತೆ ಇತ್ತು, ಕಡಿದಿದ್ರು. ಅದನ್ನ ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು ಈಗ 10 ಮರನು ಕಡಿದ್ಬಿಟ್ಟು ನನ್ಗೆ ಅಲಾಟ್ ಆಗಿರೋ ಪೋರ್ಷನ್ ನಾನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಮೀಡಿಯೇಷನ್ ಫೇಲ್ ಆಗಿದ ತಕ್ಷಣ ಇಮಿಡಿಯೇಟ್ಲಿ ಪಾಣಿ ಹಸ್ ಬಿನ್ ಚೇಂಜ್ ಇನ್ ದೇರ್ ನೇಮ್ಸ್. ದೇ ಕುಡ್ ನಾಟ್ ಹ್ಯಾವ್ ಬಿನ್ ಡನ್ ದಟ್ ಆಲ್ಸೋ. RTC ಚೇಂಜ್ ಮಾಡ್ಕೊಂತಾರೆ. RTC ನ ಫಾರೆಸ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟು ನಮಗೆ ತೊಂದರೆ ಆಗ್ತಿದೆ ಅಂತ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಮರಗಳನ್ನ ಕಡಿತಾರೆ. ಸೊ ಈಗ RTC ಚೇಂಜ್ ಮಾಡಿದೆ ತಪ್ಪು ಫಸ್ಟ್ ಪಾಯಿಂಟ್ ಅಲ್ಲಿ. ಕೇಸ್ ಇಸ್ ಪೆಂಡಿಂಗ್ ಇನ್ ದಿಸ್ ಕೋರ್ಟ್, RSA ಪೆಂಡಿಂಗ್ ಇದೆ. ಅವ್ರ ಹೆಸರಿಗೆ ಪಾಣಿ ಚೇಂಜ್ ಮಾಡ್ಕೊಂತಾರೆ, ತಕ್ಷಣ ಮರಗಳನ್ನ ಕಡಿತಾರೆ. ಇವಾಗ ಅವ್ರದ್ದು ಆರೋಗ್ಯಂಟ್ ಆನ್ಸರ್ ದಟ್
ನಿಮ್ ಗ್ರೀವೆನ್ಸ್ ಇರೋದು ರೋಡ್ ಏನ್ ಬಿಟ್ಟಿದ್ದಾರೆ.
ಹೌದು, ದಟ್ ಇಸ್ ನಾಟ್ ಸಫಿಶಿಯಂಟ್.
ಫ್ರಂಟ್ ಅಲ್ಲಿ 7.0 ಇದೆ.
ಹೌದು,
ಒಳಗಡೆ ಬರ್ತಾ ಕಡಿಮೆ ಆಗಿದೆ ಅಂತ.
ಇಲ್ಲಿ ಹೋಗಿ ಟರ್ನ್ ಆಗುತ್ತೆ. ಈ ಟರ್ನ್ ಆಗಲ್ಲ, ನನ್ಗೆ ಇಲ್ಲಿ ಪೋರ್ಷನ್ ಇದೆ, ನಾನು ಡೆವಲಪ್ ಮಾಡಕ್ ಆಗಲ್ಲ. ಇಲ್ಲೇ ಒಂದು ಲಾರಿ ಹೋಗಕ್ಕೂ ಆಗಲ್ಲ, ಹಿಂಗ್ ಟರ್ನ್ ಆಗಲ್ಲ ಅಂತ. ಇದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಹಿಂದಕ್ಕಾದ್ರೂ ತಳ್ಳಿ ಅಂದ್ರೆ ಅದಕ್ಕೂ ಇವ್ರು ಒಪ್ಪಲ್ಲ. ಫಸ್ಟ್ ಪಾರ್ಟಿ ಜಯಂತಿ ಏನಿದೆ, ನಾಟ್ ಅಟ್ ಆಲ್ ಕೋಆಪರೇಟಿಂಗ್ ಫಾರ್ ಎನಿಥಿಂಗ್. ಈಗ ನಾನು ಹೇಳ್ತೀನಿ, ಇಲ್ಲ ನೀನು ಇದು ಹಿಂದಕ್ಕೆ ಹೋಗು, ಇಲ್ಲ ಬೇರೆ ಪೋರ್ಷನ್ ಅಲಾಟ್ ಮಾಡ್ಲಿ ಅಂತ. ಕ್ಲೀನ್ ಆಗಿ ಅದನ್ನ ಸರ್ವೆ ಮಾಡಿದ್ರೆ ಇಟ್ ಇಸ್ ನಾಟ್ ಸೈಂಟಿಫಿಕಲಿ ಕರೆಕ್ಟ್ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಮೀಡಿಯೇಟರ್ ಆಸ್ ಆಲ್ಸೋ ಅಡ್ವೈಸ್ಡ್. ಯಾವ್ದಕ್ಕೂ ಹೋಗ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ. ವಿ ಆರ್ ಆಲ್ಸೋ ಗಿವನ್ ಒನ್ ಮೋರ್ ಆಪ್ಷನ್ ದಟ್ ಇಲ್ಲ ನನ್ನ ಪೋರ್ಷನ್ ನೀನ್ ಕೊಂಡ್ಕೋ, ಇಲ್ಲ ನಿನ್ ಪೋರ್ಷನ್ ನಾನ್ ಕೊಂಡ್ಕೊಂತೀನಿ ಫಾರ್ ದ ಮಾರ್ಕೆಟ್ ರೇಟ್, ನನಗೆ ಕಡಿಮೆ ಕೊಡ್ಬೇಡ. ಯಾವ್ದಕ್ಕಾದ್ರೂ ಒಂದು ಬರ್ಬೇಕು, ಬರಲೇ ಇಲ್ಲ ಅಂತಂದ್ರೆ.
ಈಗ ಐಟಮ್ ನಂಬರ್ 1 ಯಾರಿಗೆ ಸೇರಿರೋದು?
ಜಯಂತಿ.
ಜಯಂತಿ ನೀವಿಬ್ರೆ ಸಾಲ್ವ್ ಮಾಡ್ಕೋಬೇಕು.
But as per when we see the instructions, my lords, there is a road which is existing. I have presented the memo also, my lords. My lords may see memo dated.
ಆಯ್ತ್ರಿ, ನಿಮ್ ಲ್ಯಾಂಡ್ ಪಕ್ಕದಲ್ಲಿ ಒಂದು ಜಾಗ ಬಿಟ್ಟಿದಿರಿ.
ಜಾಗ ಬಿಟ್ಟಿದೆ, ಹೌದು.
ಈ ಗ್ಯಾಪ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಜಾಗ?
ಜಾಗ, my lords, it's
ಬರ್ತಾ ಅದು
7 feet road is there, my lords. 7 feet road is there.
7 feet road ಅಲ್ಲಿ ಏನ್ರಿ ಮಾಡಕತ್ತೆ?
7 meters road. 7 meters road is there, my lords. That is not at all disputed.
22 feet road.
ಬಟ್ ಇಲ್ಲಿ ಬರುವಾಗ ಇಲ್ಲಿ ಕಡಿಮೆ ಆಗಿದೆಯಲ್ಲ, ನ್ಯಾರೋ ಆಗಿದೆಯಲ್ಲ ಇದು. ಅದೇ 7 feet full ಬಿಟ್ಬಿಡಿ ಅಷ್ಟೇ.
My lords, as per the instruction, my lords, vehicle can easily pass there, my lords. They want to take the truck and all, my lords. Such a large vehicle, my lords. Even we don't have that much of land within us, and we are fine with the land which is allotted to us, my lords. But my lords, ಅವ್ರು ಹೇಳ್ತಿರ್ತಾರೆ ಕರ್ವಿಂಗ್ ಅಲ್ಲಿ ನಮ್ಗೆ ಟ್ರಕ್ ಕೂಡ ಪಾಸ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳ್ಕೊಂಡು ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಇದೆ. ಬಟ್
ಆಯ್ತಾ, ಕರ್ವಲ್ ಎಷ್ಟಿದೆ ಜಾಗ ಹೇಳಿ?
My lords, it's almost about 9 feet, around 9 meter ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
9 meter ಅಂದ್ರೆ ಫಸ್ಟ್ ಎಂಟ್ರೆನ್ಸ್ ಅಲ್ಲೇ 7 ತೋರಿಸಿದ್ದಾರೆ, ಅದ್ ನ್ಯಾರೋ ಆಗ್ತಾ ಬಂದಿದೆ.
No, my lords, 7 meters of land which is
ಸ್ಟಾರ್ಟಿಂಗ್ ಅಲ್ಲಿ ಇದೆ.
Please, my lords.
ಅದೇ 7 feet ನೀವು ಫುಲ್ ಬಿಟ್ಟಿದ್ರೆ 7 meters full ಬಿಟ್ಟಿದ್ರೆ
please, my lords,
ಅವ್ರದೇನು
as
ಗ್ರೀವೆನ್ಸ್
per the instruction, my lords, it's there in the same width only, my lords, and the vehicle can pass ಅಂತ.
ಅವ್ರ ಗ್ರೀವೆನ್ಸೇ ಇಲ್ಲ. ನಿಮ್ ಈ ಸ್ಕೆಚ್ ಮಾಡಿದ್ರಲ್ಲ, ಅವ್ರ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲಿದೆ? ಎಷ್ಟೆಷ್ಟು ಬಿಟ್ಟಿದ್ದೀರಾ ಇನ್ ತೋರ್ಸಕ್ಕೆ?
This case, Malad, the item number 3.
Survey report
That's
itself.
the house. House is come to the end of this road. And this side.
ಹೌಸ್ ಅಲ್ಲಿವರೆಗೂ ಇದೆಯಾ?
ಇದು ಐಟಮ್ ನಂಬರ್ 3 ಅಲ್ಲಿ ಹೌಸ್ ಅಲ್ಲಿವರೆಗೂ ಬಂದಿದೆ. ಈ ಕಡೆ ಇರೋದು ಪೂರ್ತಿ ಇವ್ರ ಲ್ಯಾಂಡಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಅಂತ ಇವ್ರು ಬಿಟ್ಕೊಂಡಿರೋ ರೋಡ್ ಇಷ್ಟು ಉದ್ದಕ್ಕೆ. ಅಲ್ಲಿ ಒಳಗಡೆ ಅಲಾಟ್ ಆಗಿದ್ದು ಐಟಮ್ ನಂಬರ್ 1 ಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಅಂತ ಅವ್ರು ಬಿಟ್ಕೊಂಡಿರೋ ಲ್ಯಾಂಡ್. ಇದಕ್ಕೂ ಅದಕ್ಕೂ ಮಧ್ಯದ ಕಾಂಪೌಂಡ್ ಹಾಕಿ ಇವ್ರ ಲ್ಯಾಂಡಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಅಂತ ಇವ್ರ ಲ್ಯಾಂಡ್ ಇವರೇ ಬಿಟ್ಕೊಂಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ನಿಮ್ ಲ್ಯಾಂಡ್ ಐಟಮ್ ನಂಬರ್ 3 ನಿಮಗೆ ಸೇರಿರೋದಾ?
ನಮಗೆ ಸೇರಿ.
ಮತ್ತೆ ಯಾರ್ದು ಅದು?
ಅದು ಅವ್ರಿಲ್ಲ.
Respondent number 3 ಬಂದು respondent number 1 ಶೀಲಾ ಅನ್ನೋರು.
ಅವ್ರಿಗೆ ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಾರೆ? ಕೌನ್ಸಿಲ್.
Respondent number 1, they are there on the record. They are there on the record.
ಯಾರು ಕೌನ್ಸಿಲ್? ಯಾರು ಅಂದೆ?
Number 1. ಈ ಸರ್ವೆ ಮಾಡಿ ಅಲಾಟ್ಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಸೈಂಟಿಫಿಕಲಿ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಡನ್ ಅಂತ ಮಾಡಿದ್ರೆ ಅಟ್ ಲೀಸ್ಟ್ ಮೇಜರ್ ಪೋರ್ಷನ್ ನನಗೆ ಇಟ್ಕೊಂಡು ನನಗೆ ರೋಡ್ ಎಂಟ್ರಿನೇ ಕೊಡಲ್ಲ ಅಂತಂದ್ರೆ ಮುಂದೆ ಇರೋದನ್ನೇ ಅವ್ರಿಗೆ ಕೊಡಬೇಕು ಅಂತಾನೂ ಏನಿಲ್ಲ. ದಟ್ ಪೋರ್ಷನ್ ಕ್ಯಾನ್ ಅಲಾಟೆಡ್ ಟು ಮೀ ಆಲ್ಸೋ. ಫ್ರಂಟ್ ಅಲ್ಲಿ ಮನೆಗಳು ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ದಟ್ ಪೋರ್ಷನ್ ಕ್ಯಾನ್ ಆಲ್ಸೋ ಬಿ ಅಲಾಟೆಡ್ ಟು ಮೀ. ದೇ ಆರ್ ಸೇಯಿಂಗ್ ದಟ್ ವಿ ಆರ್ ಲಿವಿಂಗ್ ದೇರ್ ಅಂತ. ಅದು ತಾತನ ಮನೆ, ಬೆಳೆದಂತ ಮನೆಯಲ್ಲಿ ಗಂಡ್ ಮಗ ಒಬ್ನೇ ಮಗ. ಅಪಲೆಂಟ್ ಹಿಯರ್ ಇದೆ.
May submit one submission. Memo dated, my lords, 21/7/2025. I produced the photograph there. There is a road, my lords, that has been obstructed from respondent number 1. That is the reason, my lords, they are not having the access to the road. That is their grievance, my lords.
Yadu?
Memo dated, my lords, 21/7/2025.
The same sketch they have produced, please. Item number 1 ಏನಿದೆ?
Photos are there, my lords.
Photos ಹಾಕಿದಿರಿ?
Please, my lords, in page number 5, my lords.
5.
My lords, may kindly see, my lords. There is a shutter and the house which are adjacent to there.
ಹೌದು, ಬಿಲ್ಡಿಂಗ್ ಇದೆ.
Please, my lords, that shutter, the shop which is there, my lords, that is actually the road that has been obstructed from respondent number 1. And the gate which is there.
ಬಿಲ್ಡಿಂಗ್ ಇದೆಯಲ್ರಿ ಇದರಲ್ಲಿ?
Please, my lords, that is the house of the respondent number 1. That is not please, my lords.
Respondent number 1 ಯಾರು?
ಅವ್ರಿಗೆ he is not representing. No.
ಆ ಜಾಗನ ಅವ್ರಿಗೆ ಈಗ ರೋಡ್ ಮಾಡಿರೋದಾ?
No, my lords. Adjacenting to that, my lords, there is a pathway which is left to the access to the property of the appellant.
ಸರಿ ರೀ, ನೀವ್ ಹೇಳ್ತಾ ಇರೋದು ಏನು ಇಲ್ಲಿ ಇದೆಯಲ್ಲ, ಯಾವ ಜಾಗ ನೀವ್ ಹೇಳೋದು ತೋರಿಸಿ ನನಗೆ.
ಅದೇ ಸ್ವಾಮಿ,
ಆ ಸೆಡ್ಗೂ ಗೇಟ್ಗೂ ಮಧ್ಯದಲ್ಲಿ ಇರತಕ್ಕಂತ ಜಾಗನೇ ರೋಡ್.
ವೈಟ್ ಲೈನ್ಸ್ ಅನ್ನ ಡ್ರಾ ಮಾಡಿ
ಜಾಗ ಇದೆಯಾ?
ವೈಟ್ ಲೈನಿಂಗ್ ಡ್ರಾ ಮಾಡಿದೆ
ಬಿಟ್ವೀನ್ ದಿ ಶೆಡ್ ಅಂಡ್.
ಹೌದು, ಅಷ್ಟು ರೋಡಿಗೆ.
ಅಲ್ಲಿ ರೋಡ್ ಇಲ್ಲ, ಅಲ್ಲಿ ಮರನೇ ಇದೆ.
ಅದೇ ಮರ ಇದೆ ಅಂದ್ರೆ ಅವರು ರೋಡ್ ನ ಡೆವಲಪ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ರೋಡಿಗೆ
ಬಿಟ್ಟಿರೋ ಜಾಗ ಅದು ಡೆವಲಪ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ.
ಅವ್ರ ಆ ಜಾಗನ ಹಾಗೆ ಬಿಟ್ಟು ಈಗ ಅದಕ್ಕೆ ಆಗಿದೆ.
ಇಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸಿ, ಇಲ್ಲಿ ಒಂದು ಮನೆ ಇದೆ, ಇಲ್ಲೊಂದು ಗೇಟ್ ಇದೆ, ಇನ್ ಬಿಟ್ವೀನ್ ಜಾಗ ಏನಿದೆ ಅದರಲ್ಲಿ ಲಾರ್ಡ್ಶಿಪ್ ಕೈಂಡ್ಲಿ ಸೇ ಸ್ಕೆಚ್. ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ, ಇಲ್ಲಿ 7 meters ಜಾಗ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಆ 7 meters ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋ ಜಾಗಕ್ಕೆ ಒಂದು ಕಾಂಪೌಂಡ್ ಹಾಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಹಿಂಗ್ ಫುಲ್ ಹಿಂಗೆ.
7 meters ಬಿಟ್ಟು ಅದು
ಕಾಂಪೌಂಡ್ ಇಲ್ಲಿ ಕಾಣ್ತಾ ಇಲ್ವಲ್ಲ?
ಗೇಟ್ ಇದೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ,
ಗೇಟ್ ಇದೆ ಅಷ್ಟೇ.
ಅಲ್ಲ, ಇಲ್ಲೇನಿದೆ, ಇಲ್ಲಿ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾರಲ್ಲ ಹಿಂಗ್ ಲೈನಿಂಗೆ, ಈ ಲೈನ್ ಫುಲ್ ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಹಿಂಗೆ. ಈ ಪೀಸ್ ಅಲ್ಲಿ ಎಂಟರ್ ಆಗ್ಬೇಕು ನಮ್ಗೆ, ಈ ಪೀಸ್ ಅಲ್ಲಿ ಎಂಟರ್ ಆಗಕ್ ಆಗಲ್ಲ.
ಸರಿ, ನೀವು ಎಂಟರ್ ಆಗಕ್ಕೆ ಇಲ್ಲಿ ಜಾಗ ಇದೆಯಲ್ಲ, ಅದೆಲ್ಲ ಎಂಟ್ರಿ ಇದು?
ಅದೇ ಜಾಗ.
ಈ ಜಾಗನೇ ಅವ್ರು ಕ್ಲೋಸ್ ಮಾಡೋದು. ಇಲ್ಲಿ ಈ ಗೇಟ್ ಇದೆಯಲ್ಲ ಪಕ್ಕದಲ್ಲಿ, ಗೇಟ್,
ಹೌದು,
ಗೇಟ್ ಇಂದ ಪಕ್ಕದಲ್ಲಿ ಇರ್ತಕ್ಕಂತ ಜಾಗ ಇಬ್ರಿಗಿದೆ. ನನಗೆ ಮತ್ತೆ ಐಟಮ್ ನಂಬರ್ 1 ಗೆ.
ಈ ಫೆನ್ಸಿಂಗ್ ಫೆನ್ಸಿಂಗ್ ಹಾಕಿದಾರಲ್ಲ ಅದೇ ಆದ್ರಿ ನಿಮಗೆ
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಮೇಲೆ ಐಟಮ್ ನಂಬರ್ 1 ಗೆ ಹೋಗುವಂತ ಇರುವಂತ ಜಾಗ
ಈ ಗೇಟ್
ಗೇಟ್ ಇರೋದು ನಾವು ಮಾಡ್ಕೊಂಡಿರೋದು ಕಾಲ್ದಾಡಿ ಇದೆ ಮೇಲೆ
ಅದು ಅವ್ರ ಲ್ಯಾಂಡಿಗೆ ಹೋಗಿ ಗೇಟ್
ಹೋಗ್ಲಿಕ್ಕೆ ನಾವು ಮಾಡ್ಕೊಂಡಿದ್ದು ನಮ್ಮ ಜಾಗದಲ್ಲಿ ನಾವು ಮಾಡ್ಕೊಂಡಿದ್ದು
ಆ ಜಾಗನೇ ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ತಾರೆ ಹಿಂಗೆ ನನಗೆ ಇಲ್ಲಿ
ಕ್ಲೋಸ್ ಹೆಂಗ್ರಿ ಮಾಡ್ತಾರೆ
ಇಲ್ಲಿ
ನೀವು ಇಷ್ಟ ಹೇಳಿ ಆ ಫೋಟೋಗ್ರಾಫ್ ಇದೆಯಲ್ಲ ಈ ಫೆನ್ಸಿಂಗ್ ಮತ್ತೆ ಇಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಆ ಕಡೆ ಶೆಡ್ ಇದೆಯಲ್ಲ ಶಾಪ್ ಇಷ್ಟು ಜಾಗ ನಿಮ್ಗಿದೆಯಾ
ಈ ಪೀಸ್ ಇಲ್ಲಿ ಮುಂದ್ಗಡೆ ಏನ್ ಕಾಣ್ತಾ ಇದೆ ಈ ಪೀಸ್ ಇಲ್ಲಿ ಮುಂದೆ ಕಾಣ್ತಾ ಇರೋ ಜಾಗ ಇಲ್ಲಿದೆ ಎಂಟ್ರಿಗೆ ಒಳಗಡೆ ಹೋಗ್ತಾ ಫುಲ್ ಇಲ್ವೇ ಇಲ್ಲ
ಇದೆಲ್ಲ ಇದಿಲ್ವೇ ಇಷ್ಟು ಜಾಗ ಇಲ್ಲಿಂದ ಇಷ್ಟು
ಇಲ್ಲಿದೆ ಮುಂದ್ಗಡೆ ಇದೆ ಒಳಗಡೆ ಇಲ್ಲ
ಒಳಗಡೆ ಎಷ್ಟಿದೆ ನಿಮ್ ಪ್ರಕಾರ ಎಷ್ಟಿದೆ ಹೇಳಿ
ಇಲ್ಲಿ ಒಳಗಡೆ ಹೋದ್ರೆ ಇಲ್ಲಿ
ಸರಿ ನಿಮ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ ಹೇಳ್ರಿ ನಿಮ್ ಪ್ರಕಾರ
ಒಂದು 10 ಫೀಟ್ ಕೂಡ ಇಲ್ಲ ಇಲ್ಲಿ ಟರ್ನಿಂಗ್ ಅಲ್ಲಿ 10 ಅಡಿ ಕೂಡ
ನೀವು ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿ ಹೇಳಿ ನಾಡಿದ್ದು ಹೇಳಿ ಎಷ್ಟಿದೆ ನೋಡೋಣ
ಪ್ಲೀಸ್
ಆ ಜಾಗ
ಪ್ಲೀಸ್
ಅಟ್ಲೀಸ್ಟ್ ನಿಮ್ಗೊಂದು ಲಾರಿ ಹೋಗಕ್ ಜಾಗ ಬೇಕು
ನಮ್ಗೆ ಅಲ್ಲಿ ಹಿಂದೆ ಟರ್ನ್ ಆಗ್ಲಿಕ್ಕೆ ಜಾಗ ಇಲ್ಲ
ಅಷ್ಟೇ ಅಲ್ವಾ
ನಮ್ ಗ್ರೀವೆನ್ಸ್ ಏನಂದ್ರೆ ಈ ಐಟಮ್ ನಂಬರ್ 1 ಏನಿದೆ ಇದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಇನ್ನ ಒಂದು 8 ಅಡಿ ಹಿಂದಕ್ಕೆ ತಗೋಬಹುದು ಇನ್ನೊಂದು ನಮಗೆ ಸೇಲ್
ಆಲ್ರೆಡಿ ಆಗಿರೋದು
ಇಲ್ಲ ಅಂದ್ರೆ ರೀಸರ್ವೆ ಮಾಡಿದ್ರೆ
ಜಾಗ ತೋರಿಸಿರೋದ್ರ ಪ್ರಕಾರ
ರೀ ಅಲಾಟ್ಮೆಂಟ್ ಕ್ಯಾನ್ ಆಲ್ಸೋ ಬಿ ಡನ್
ಎಷ್ಟಿದೆ ಹೇಳ್ರಿ ಫಸ್ಟ್ ರೀ ಅಲಾಟ್ಮೆಂಟ್ ಆಮೇಲೆ ನೋಡೋಣ
ಪ್ಲೀಸ್
ಆ ಲ್ಯಾಂಡಿಗೆ ಒಟ್ನಲ್ಲಿ ಹೋಗಕ್ ಜಾಗ ಬೇಕಷ್ಟೇ ನಿಮ್ಗೆ
ಹೌದು
ಮೋಸ್ಟ್ಲಿ ನಿಮ್ ಗ್ರೀವೆನ್ಸ್ ನಂಗೆ ಹಿಂದೆ ಕೊಟ್ಬಿಟ್ಟವ್ರೆ ಅಂತ ಇರ್ಬೇಕು
ಒಂದು ಅದೂನು ಇದೆ ಅವರಿಗೆ ಸಣ್ಣ ಮಗ 4 ಪೋರ್ಷನ್ ಇದೆ ಹಿಂದ್ಗಡೆ ಹೋಗಿದೆ ಅನ್ನೋದೊಂದು ರೋಡ್ ಅಪ್ರೋಚ್ ಇಲ್ಲ ಈ ಮುಂದೆ ರೋಡ್ಗಾದ್ರೂ ಇದ್ರೆ ವ್ಯಾಲ್ಯೂ ಇರುತ್ತೆ ಅದು
ರೋಡ್ ಅಪ್ರೋಚ್ ಈಗ ನೀವು ಮಾಡ್ಕೋಬಿಡಿ
ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ ಹಿಂದೆ ಇರೋದ್ರಿಂದ ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ ಒಂದು ಇಲ್ಲ ಅಪ್ರೋಚ್ ಕೊಡಲ್ಲ ಅಲ್ಲಿ ಟರ್ನ್ ಆಗಕ್ ಬಿಡಲ್ಲ ಅಲ್ಲಿ ಜಾಗ ಬಿಡಲ್ಲ ಅಂತಾರೆ
ಆಯ್ತು
ಸ್ವಲ್ಪ ಹಿಂದಕ್ಕೆ ಹೋಗ್ರಪ್ಪ ಅಂದ್ರೆ ಹಿಂದಕ್ಕೂ ಹೋಗಲ್ಲ
ಬೈಫರ್ಕೇಶನ್ ಮಾಡಿದಾಗ ಕಮಿಷನರ್ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿದೀರಾ
ಹೇಳಿದ್ವಿ ಅವ್ರಿಗೆ ಈ ತರ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು
ಹೇಳಿರೋದ್ ಬೇಡ ತಕರಾರು ಹಾಕಿದೀರಾ
ಈ ತರ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿಲ್ಲ ಅವರು ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್
ಮತ್ತೆ
ದಟ್ ಇಸ್ ಓನ್ಲಿ ಇಶ್ಯೂ
ನೀವು ತಕರಾರು ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು ಆಯ್ತು ನನಗೆ ಮೆಜರ್ಮೆಂಟ್ ಎಷ್ಟಿದೆ ನೋಡಿ ಹೇಳಿ ವೆಹಿಕಲ್ ಹೋಗಿ ಬರಂಗ್ ಇದೆಯಾ ಇಲ್ಲ ನೋಡೋಣ ಇಲ್ಲ ಅಂದ್ರೆ ನೋಡೋಣ
ಪ್ಲೀಸ್
ನೋಡಿ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ R1 ಕೌನ್ಸಿಲ್ ಯಾರ್ರಿ ಮೇನ್ ಈ ಐಟಮ್ ನಂಬರ್ 2 ಯಾರು ಗಲಾಟ್ ಆಗಿರೋದು
R1
ಅಲ್ಲ ಯಾರು ಅಂತ
ಐಟಮ್ ನಂಬರ್ 2 ಸುಶೀಲಾ ಅವ್ರಿಗೆ ಆಗಿರೋದು
ಸುಶೀಲಾ ಅವ್ರ ಲಾಯರ್ ಯಾರು ಒಂದೇ
ಅವ್ರು ಬಂದಿಲ್ಲ
ಕೆಜಿ ಸದಾಶಿವಯ್ಯ R1
ಪ್ಲೀಸ್
R1 ಅವ್ರು ಬರೋದೇ ಇಲ್ಲ ಯಾವಾಗ್ಲೂ ಕೋರ್ಟ್ಗೆ
The previous occasion they had appeared, my lords, when
ಮತ್ತೆ ಸಚಿನ್ ಫಾರ್ R2 ನೀವು ನಿಮ್ದು ಐಟಮ್ ನಂಬರ್ 3 ನ
ಐಟಮ್ ನಂಬರ್ 1, my lords.
1 ಅಂದ್ರೆ ಅದೇ ಪಕ್ಕದಲ್ಲಿ ಇರೋದು
ನಾವು ನಮ್ ದಾರಿಲಿ ಜಾಗ ಮಾಡ್ಕೊಂಡು ಹೋಗಿದ್ದೇವೆ ಅದೇ 1 ನ್ಯಾರೋ ಲ್ಯಾಂಡ್ ಇದೆ ಅಲ್ಲ
1 ಆ ಕಡೆ ಇರೋದು
1 ಆ ಕಡೆ ಇರೋದು
ಅದು 1 ಚಿಕ್ಕದಿದೆ ನ್ಯಾರೋ ಪಕ್ಕದಲ್ಲಿ ಇದೆ ಅದು
ಈಗ ದಾರಿ ಬಿಟ್ಟಿರೋದು ಏನಿದೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲೇ ಅವ್ರ ಶಾಪ್ ಅನ್ನಿದೆ
ಆಯ್ತ್ರಿ ಇಲ್ಲಿ ಏನಾಗಿದೆ ಇವರೆಲ್ಲ ಮೇನ್ ರೋಡಿಗೆ ತಗೋಬಿಟ್ಟಿದ್ರಿ ನೀವು ಐಟಮ್ ನಂಬರ್ 3 ಐಟಮ್ ನಂಬರ್ 4
ಅಲ್ಲಿ
ಮನೆ ಇದೆ
ಮನೆಗಳಲ್ಲಿ
ಐಟಮ್ ನಂಬರ್
1 ಹಿಂಗಡೆ ಇದೆ
ಒಂದು ಒಳಗಡೆ ಹೋಗಿದೆ
ಡ್ವೆಲ್ಲಿಂಗ್ ಹೌಸ್ ಆಗಿದೆ
ಇವ್ರಿಗೆ ಐಟಮ್ ನಂಬರ್ 2 ನ ಕೊನೆಯಲ್ಲಿ ನಾನು ಲಾಸ್ಟ್ ಎಂಡ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಿ
ಅದು ಡ್ವೆಲ್ಲಿಂಗ್ ಹೌಸ್ ಇರೋದ್ರಿಂದ ಅವರಿಗೆ ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರಲ್ಲೇ ವಾಸ
ಐಟಮ್ ನಂಬರ್ 4 ಏನಿದೆ ದಟ್ ಇಸ್ ಮನೆ ಇದು ಹಳೆ ಮನೆ ಇದು ಐಟಮ್ ನಂಬರ್ 4 ಮುಂದೆ
ಹಳೆ ಮನೆ ಇದೆಯಾ
ಮನೆ ಇದೆ ಆ ಮನೆಯಲ್ಲಿ ಇವರೆಲ್ಲರೂ ಹುಟ್ಟಿ ಬೆಳೆದಂತ ಮನೆ ಹಳೆ ಮನೆ ಸೊ ಹಳೆ ಮನೆನ ಒಬ್ಬನೇ ಮಗ ಇರೋದ್ರಿಂದ ಮಗನ್ ಅಲಾಟ್ ಮಾಡಬಹುದಾಗಿದೆ ಅಲ್ಲೊಂದು ಹೆಣ್ಮಗಳಿದ್ದಾಳೆ ಅವ್ರು ನನಗ್ ಬೇಕು ಅಂತ ಅದನ್ನ ತಗೊಂಡಿದ್ದಾರೆ
ಅದು ಹೆಣ್ಮಕ್ಳಿಗೆ ಹೋಗಿದ್ಯಾ
ಅದು ಹೆಣ್ಮಕ್ಳಿಗೆ ಹೋಗಿದೆ ಇರೋದೊಬ್ಬ ಮಗ ಅಂತಂದಾಗ ಅವನಿಗೆ ಕೊಡ್ಬೋದಿತ್ತಲ್ಲ ಹೆಣ್ಮಕ್ಳೆಲ್ಲ ಸೇರಿ ನಾನು ಹೆಣ್ಮಕ್ಳಿಗೆ ಭಾಗ ಕೊಟ್ಟಿದ್ದಪ್ಪ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ ಐಮ್ ನಾಟ್ ಡಿನೈಯಿಂಗ್ ದ ರೈಟ್ ಆಫ್ ದ ಹೆಣ್ಮಕ್ಳು ಕೊಡ್ಲಿ ಗಂಡ್ಮಕ್ಳು
ಈ ಕಮಿಷನರ್ ಸ್ಪಾಟ್ ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದ್ರಲ್ಲ ಸ್ಕೆಚ್ ಡ್ರಾ ಮಾಡಿದ್ರಲ್ಲ ಅವಾಗ ನೀವು ಇದ್ರೆ
ಮಾಡ್ಲಿಲ್ಲ ಅವತ್ತು ಡ್ರಾ ಮಾಡ್ಲೇ ಇಲ್ಲ ಇದೆಲ್ಲ ಇದೆಲ್ಲದನ್ನು
ಇನ್ಸ್ಪೆಕ್ಷನ್ ಮಾಡಿದಾಗ ನೀವು ಮಾಜಾರಿ ಸೈನ್ ಮಾಡಿದಿರ ಇಲ್ಲ ಮಾಡಿದಿರಿ ಮತ್ತೆ
ಅವತ್ತು ಮಾಜರ್ ಇದು ಬರೀಲಿಲ್ಲ ಸ್ಕೆಚ್ ಬರೀಲಿಲ್ಲ
ಆಯ್ತು ಸ್ಕೆಚ್ ಕೋರ್ಟಿಗೆ ಹಾಕಿದ ತಕ್ಷಣ ನೀವು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡ್ಬೇಕಿತ್ತಲ್ವಾ
ಅದನ್ನ ಮಾಡಿದ್ದಾರೆ ಇದ್ರಲ್ಲಿ ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದಾರೆ
ಇದು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಆಗಿರೋದ
ಹೌದು ಅಪೆಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾಗ ಬಂದ
ಇದು
ಚಾಲೆಂಜ್ ಇರ್ತದೆ
ಆರ್ಎನ್ಎಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದೀವಿ
ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಿ ಬಟ್ ಅಲ್ಲಿ FDP ಕೋರ್ಟ್
FDP ನಲ್ಲಿ ಬಂದಿದ್ದು
FDP ನಲ್ಲಿ ತಕರಾರು ಮಾಡಿದೀರಾ ಅಂತ ಕೇಳಿ
ಇಲ್ಲ ದಿಸ್ ಇಸ್ ದ ಫಸ್ಟ್ ಟೈಮ್ ಇನ್ ದ ಕೋರ್ಟ್
ಅಲ್ಲೇ ಮಾಡ್ಬೇಕಿತ್ತಲ್ಲ
ಈ ಸರ್ವೆ ಮಾಡಿ ಅಲಾಟ್ ಮಾಡಿದ್ರು
R1 ಕೌನ್ಸಿಲ್ ಇಸ್ ಆಬ್ಸೆಂಟ್ ಮರ ಕಡ್ದಿರೋದೆಲ್ಲ ಯಾರಿಗೆ R1 R2 ನೀವಾ
ಇವರೇ ಕಡ್ದೆ
ನೀವೇನು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿಲ್ಲ ನಾವು ಆರ್ಡರ್ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ
Let them instructions status quo can.
ಏನು ಇಲ್ವಲ್ಲ ಸ್ಟೇಟಸ್ ಹೋಗಿ ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ ನೀವೇನು ಅರ್ಜಿ ಹಾಕೊಂಡಿಲ್ಲ. ಕಟ್ ಅಂಡ್ ಕೆಪ್ ದಿ ಟ್ರೀಸ್ ರೆಡಿ ಟು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ದಿ ಸೇಮ್ ಅಂತ ನಿಮ್ ಪ್ರಕಾರ ಫಾರೆಸ್ಟ್ ಆಫೀಸಿನಲ್ಲಿ ಪರ್ಮಿಷನ್ ತಗೊಂಡವ್ರು ಅವರು. ಮತ್ತೆ
ಒಂದು ಓರಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟರು ಮಾರಬಾರ್ದು ಅಟ್ ಲೀಸ್ಟ್.
List this matter to day after tomorrow. Since counsel for the R1 is absent.
That's on 23rd.
ಈಗ represent ಮಾಡ್ತಾ ಇರೋದು ಓನ್ಲಿ R1, R2, R20 to 23 ನಾ? 20 to 23 ಈಗ ಇನ್ಯಾರಿಗೂ ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ ರೈಟ್?
ಅವ್ರದೆಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ ಹತ್ರ.
ಯಾರು
ಉಳಿದ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ಅವ್ರ ಹತ್ರ ಇದೆ.
ಎಲ್ಲ ಅವ್ರ ಹತ್ರ ಇದೆ. ನೀವು ಐಟಮ್ ನಂಬರ್ 4 ಮಗಳು?
ಎಸ್ ಪ್ಲೀಸ್ ಮೇಡಮ್.
ಮನೆ ಹಳೆ ಮನೆ ನೀವೇ ತಗೊಂಡ್ರದ?
ನಾವೇ ಅದನ್ನ ರಿನೋವೇಟ್ ಮಾಡಿ ಎಲ್ಲ ಮಾಡಿ ನಾವೇ ಇದು ಮಾಡಿ ನಮಗೆ ಅಲಾಟ್ ಆಗಿದೆ.
ನೀವು ಫ್ರಂಟ್ ಇನ್ ಐಟಮ್ ನಂಬರ್ 2 1
ಸೈಡ್ ಅಲ್ಲಿ ಇರೋದು
2 ಅವ್ರದ್ದು
2 ಬರ್ಲಿಲ್ಲ. ಐಟಮ್ ನಂಬರ್ 2 ಅವ್ರು ಬರ್ಲಿಲ್ಲ. ಐಟಮ್ ನಂಬರ್ 2 ಅವ್ರು.
ಐಟಮ್ ನಂಬರ್ 2 ರ ಕೆಜಿ ಸದಾಶಿವನೇ ಅವರ?
ಐಟಮ್ ನಂಬರ್
2 ಅವರಿಗೆ
ಅಲ್ಲ ರೀ, ಆ ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಈಗ ಐಟಮ್ ನಂಬರ್ 2 ಅವ್ರದ್ದು.
ಐಟಮ್ ನಂಬರ್ 2 ಅವರಿಗೆ ಅಪ್ಲೇಟಿಗೆ.
ಐಟಮ್ ನಂಬರ್ 1 ಯಾರ್ದು?
ಐಟಮ್ ನಂಬರ್ 1 ನಮ್ದು.
ನಿಮ್ದು. 3 ಯಾರಿಗೆ? 4 ನಿಮಗೆ. 3 ಯಾರು? ಸದಾಶಿವ ಅವರೇನಾ? ತೋಳಿ counsel for R1 is absent, counsel for appellant counsel is present, and counsel for R1 is absent, and counsel for R2, and counsel for 20 to 23 is present. If R2 counsel doesn't appear in the next state of hearing, the matter will be heard in his absence.
Let's R2
for R1. List this R1 doesn't appear in the next state of hearing, in his absence matter will be heard. List this matter on day after tomorrow. ಏಕೆ ಏನು ಗುರುವಾರ ಶುಕ್ರವಾರ ಆಗುತ್ತಾ? ಶುಕ್ರವಾರ ಆಗುತ್ತಾ?
ಶುಕ್ರವಾರನೇ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
ಇವತ್ತು ಬುಧವಾರ ನಾಡಿದ್ದು
ಓಪನಿಂಗ್ ಡೇ 23rd.
ಆಯ್ತು ಮಂಡ್ಯಾಗ ಹಾಕಿ. ಮಂಡ್ಯ ಎಲ್ಲ ರಜಾ ಅಲ್ರಿ, ಆ ಮರ ತಗೊಂಡೋಗ್ಬಿಡ್ತಾರ ಅವ್ರದ್ದು ಆಮೇಲೆ ಅಷ್ಟೇ. ಇಲ್ಲ ನಾಳೆ ಟುಮಾರೋ.
ನಾಳೆ ಇಲ್ಲ ಮತ್ತೆ ಪಾಸ್ ಔಟ್ ಮಾಡಿದ್ರೆ ಈಗಲೇ ಹೇಳ್ತೀನಿ.
ಇಲ್ಲ ನಾಳೆ ಇಲ್ಲ ನಾಡಿದ್ದು ನಿಮ್ದೇ ಚಾಯ್ಸ್.
ಡೇ ಆಫ್ಟರ್
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ನಿಮ್ಗೆ. ಅವ್ರೇನ್ ನಾನು ಇರಲ್ಲ ಅಂತಾರ? ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್. ಆಮೇಲೆ ನೀವಿಲ್ಲ ಅಂತ ಮತ್ತೆ ಅರ್ಜೆಂಟ್ ಮಾಡಲ್ಲ ಆಗ್ಬೋದಾ? ಆಯ್ತು ಲಿಸ್ಟ್ ದಿಸ್ ಮಾಡಿ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ಅಲ್ಲ ಹಾಗೆ ಮಾಡಿ. in the meanwhile registry is directed to get the report of the mediation center of ಕುಂದಾಪುರ. ಕಾಲ್ ಮಾಡಿ ಕಲೆಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿ. ಅದೇನ್ ಮೀಡಿಯೇಷನ್ ರಿಪೋರ್ಟೇ ಬಂದಿಲ್ಲ.
Correspond with 4 and 5.
It's the plaintiff's appeal model. The divergence
for specific performance
findings model. Suit is for specific performance model. Total property is model. Land bearing survey number. That 54/42, the measuring 1 acre 13 gundas model. Situated at Devarali village. Chandravatthi Taluk and so on that, and this property belongs to one Rajama Malda. And on 22/9/2010 Malda.
ಆಯ್ತು ಅಗ್ರಿಮೆಂಟ್ ಎಲ್ಲ ಇದೆ ರೀ. ಅಪೀಲ್ ಅಲ್ಲಿ ಯಾಕೆ ರಿವರ್ಸ್ ಮಾಡಿದ್ರಿ? ರೀಸನ್ ಏನ್ ಹೇಳಿ?
Reason is that Malda, the defendants have taken contention that Malda, the suit schedule property was granted to Rajama, so it is clear violation of the section 3 and 4 of the PTCL Act. They have taken contention Malda. That defense was rejected by the trial court and declared my suit. So they have prepared an appeal before the lower appellate court. The appellate court has reversed the findings of the trial court and held that the agreement of sale is an wide avenue and it is a violation of that conditions of the PTCL Act. Now that against that reverse finding of the lower appellate court are present before this court. That the main contention, the legal issue is that whether the sale agreement or the property was granted to the Rajama, it is not granted by the government. She has purchased in the she is the action purchaser.
Action purchaser.
They have
not the granted land.
Not a granted land. So she has paid the amount 904 to the government. She has purchased in the auction. So when the vendor that.
ಆಕ್ಷನಲ್ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಿ ದಾಖಲೆ?
ಅಲ್ಲಿ ಸಾಗುವಳಿ ಚೀಟ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೆ.
ತಗೊಳ್ಳಿ ಚಿಟ್ಟೆ.
ಹೌದು, ಅದ್ಯಾಟ ವಿಶುದ್ಧಿ ಸಾಗುವಳಿ ಚೀಟ. ಅದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಕ್ರಯದ ಅಮೌಂಟ್ ಅನ್ನು.
If it is not a grant.
Not a grant.
If it is purchased in the action.
ಹೌದು.
How they issue the sagoli chit?
The government has issued that grant certificate ಮಾಡಿದೆ.
ಅದೇ grant certificate.
ಅದರಲ್ಲಿ ಇವರು ಅಚೀವ್ಮೆಂಟ್ ಕಂಡೀಷನ್ ಕ್ಲಿಯರ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿದೆ.
Registered sale agreement, legal.
ಫಾರ್ಮ್ ನಂಬರ್ 7 ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರಿಗೆ.
ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಎಕ್ಸಿಬಿಟ್ P10 ಇದೆಯಲ್ಲ ಅದೇನು?
ಹೌದು, ಅದೇ ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ಕೊಡುವ ಬಗೆಗಿನ ಪ್ರಮಾಣ ಪತ್ರ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಹ್ಯಾಸ್ ಬಿನ್ ಇಶ್ಯೂಡ್ ಮಾಡಿದೆ. ಅದರಲ್ಲಿ ಅಧಿಭೋಗದಲ್ಲಿ ಸರ್ಕಾರಿ ಭೂಮಿಯನ್ನು ಸಾಗುವಳಿಗಾಗಿ ವಿಲೆ ಮಾಡುವುದಕ್ಕೆ ಮತ್ತು ಅಧಿಭೋಗ ಹಕ್ಕುಗಳನ್ನು ಕೊಡುವುದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ನಿಯಮಗಳ ಮೇರೆಗೆ ಕೆಳಗಿನ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ ಭೂಮಿಯನ್ನು ಮಾರಾಟ ಮಾಡಲಾಗಿದೆ. ಅದನ್ನು ಬಹಿರಂಗ ಹರಾಜಿನಲ್ಲಿ ಅಥವಾ ನಿಗದಿ ಬೆಲೆಗೆ ಕೊಂಡುಕೊಂಡಿದ್ದಾರೆ. ದಿಸ್ ಇಸ್ ದ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಗಿವನ್ ಬೈ ದಿ ಗವರ್ಮೆಂಟ್ ಮದರ್. ಮತ್ತು ಅದನ್ನು ಕ್ರಮಬದ್ಧವಾಗಿ ಸ್ಥಿರೀಕರಿಸಲಾಗಿದೆ ಮತ್ತು ಖರೀದಿದಾರನೆಂದು ಘೋಷಿಸಲಾಗಿದೆ. ಸಿ ಇಸ್ ದ ಆಕ್ಷನ್ ಪರ್ಚೇಸರ್ ಮಾಡಿದ. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಫಾರ್ಮ್ ನಂಬರ್ 7 ಇಸ್ ದಟ್ ಮಾಡಿದ.
ಅಗ್ರಿಮೆಂಟ್ ಯಾವ ಇಯರ್?
ಅಗ್ರಿಮೆಂಟ್ ಇಯರ್ ಫಾರ್ ದಿ ಇಯರ್ ಆಫ್ 1999 ಮಾಡಿದ.
99.
ಹೌದು.
ಬಟ್ ಈ ಗ್ರಾಂಟ್ ಆಗಿರೋದೇ 1199.
ಹೌದು, ಅದನ್ನ ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಂಡು 111999 ಮಾಡಿದ.
ಸೇಮ್ ಇಯರ್ ಅಲ್ಲೇ ಅಗ್ರಿಮೆಂಟ್ ಅಗ್ರಿ ಮಾಡ್ಕೊಳ್ತಾರೆ.
ಹೌದು ಹೌದು. ಇಲ್ಲಿ ನಂಬರ್
ಪರಬಾರೆ ಮಾಡಬಾರದು ಅಂತ
15 ಇಯರ್ಸ್ ಅಂತ ಹೇಳಿ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ.
ಅದೇನೆ ಷರತ್ತು ಭೂಮಿಯನ್ನು ಸ್ವಾಧೀನಕ್ಕೆ ತೆಗೆದುಕೊಂಡ ದಿನಾಂಕ 1/1/99 15 ವರ್ಷಗಳ ಅವಧಿಯವರೆಗೆ ಪರಬಾರೆ ಮಾಡತಕ್ಕದ್ದಲ್ಲ
ಅಂತ ಹೇಳಿದ್ರು. ಬಟ್ ಮೈ ಕಂಟೆನ್ಷನ್ ಇಸ್ ದಟ್ ದಿಸ್ ನೇಚರ್ ಆಫ್ ಪ್ರಾಪರ್ಟಿ ಗ್ರಾಂಟೆಡ್ ಟು ದಿ ರಾಜಮ್ಮ ಇಸ್ ನಾಟ್ ಕಮ್ಸ್ ಅಂಡರ್ ದಿ ಪರ್ವ್ಯೂ ಆಫ್ ದಿ PTCL ಆಕ್ಟ್.
PTCL ಆಗದಲ್ಲೇ ಇದ್ರೂನುವೆ
that condition that cannot be condition. one PTCL ಬರೋದಿಲ್ಲ ಅಂದ್ರೆ that condition is not applicable to the PTCL ಆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಏಕೆ?
Because this is not a.
ನಿಮ್ಮ ಪ್ರಕಾರ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಅಲ್ಲ ಅಂತ.
ಹೌದು, ಗ್ರಾಂಟ್ ಆಗಿಲ್ಲ. ಗವರ್ಮೆಂಟ್ ಇಂದ ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ಕಮ್ಸ್ ಅಂಡರ್ ದಿ ಗ್ರಾಂಟ್ ಮಾಡಿದ. ಇಟ್ ಇಸ್ ನಾಟ್ ಕಮ್ಸ್ ಅಂಡರ್ PTCL.
Then why they have issued the sagoli chit if it is not a grant?
It is not a nature of sagoli chit ಮಾಡಿದ. It is issued ಫಾರ್ಮ್ ನಂಬರ್ 7 ಮಾಡಿದ. ಪ್ರಮಾಣ ಪತ್ರ ಈ
ಸಾಗುವಳಿ ಚೀಟಿಯನ್ನು ಕೊಡುವ ಬಗೆಗಿನ ಪ್ರಮಾಣ ಪತ್ರ.
ಇಟ್ ಇಸ್ ನಾಟ್ ಎ ನೇಚರ್ ಗ್ರಾಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಮಾಡಿದೆ. So, in the Honorable Apex Court, in so far as this finding is concerned, BK Munraja case is made applicable on that. Once the property is purchased in auction, that it cannot come under the purview of the PTCL Act.
Action ಅಲ್ಲಿ ಕೊಂಡ್ಕೊಂಡಿದ್ದೀರಾ ಅನ್ನಕ್ಕೆ ಏನ್ ದಾಖಲೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅವರೇ ಬರೀತಾರೆ. ಇದೇ ಫಾರಂ ನಂಬರ್ 7 ಅಲ್ಲೇ ಬರೆದಿದ್ದಾರೆ.
ಏನಂತ?
ಇವರು ಲಾರ್ಡ್ಶಿಪ್ ಅಧಿಭೋಗದಲ್ಲಿ ಸರ್ಕಾರಿ ಭೂಮಿಯನ್ನು ಸಾಗುವಳಿಗೆ ವಿಲೆ ಮಾಡುವುದಕ್ಕೆ ಮತ್ತು ಅಧಿಭೋಗದ ಹಕ್ಕುಗಳನ್ನು ಕೊಡುವುದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ನಿಯಮಗಳ ಮೇರೆಗೆ ಕೆಳಗಿನ ಅಧಿಸೂಚನೆ ನಿರ್ದಿಷ್ಟಪಡಿಸಿದ ಭೂಮಿಯನ್ನು ಮಾರಾಟ ಮಾಡಲಾಗಿದೆ ಮತ್ತು ಬಹಿರಂಗ ಹರಾಜಿನಲ್ಲಿ ಅಥವಾ ನಿಗದಿತ ಬೆಲೆಗೆ ಕೊಂಡುಕೊಂಡಿದ್ದಾರೆ. ಈಗ 904 ಅವರು ಅಮೌಂಟ್ ಕಟ್ಟಿದ್ದಾರೆ. ಇಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ 900 ಮೊಬಲಗನ್ನು ಖರೀದಿ ಹಣದ ಪೂರ್ತ ಮೊಬಲಗ 904 ರೂಪಾಯಿಗಳನ್ನು ಸರ್ಕಾರಿ ಖಜಾನೆಗೆ ಸೋ ಅಂಡ್ ಸೋ 24/12/98
PTCL ಗ್ರಾಂಟ್ ಅಂತ ತೋರಿಸಕ್ಕೆ
ಸಂದಾಯ ಮಾಡಿದ್ದಾರೆ.
PTCL grant ಅಂತ ತೋರ್ಸಕ್ ಗೆಲ್ಲಿದೆ ದಾಖಲೆ?
I know information regarding this. Senior will argue the matter.
Told. Order the appellant counsel and also the counsel appearing to the respondent. The second appeal is filed against the divergent finding. The trial court granted the relief of specific performance and the same is reversed in the appeal by the first appellate court. And hence the second appeal is filed. Having considered the material on record and there is a divergent finding, matter requires reconsideration. Admit. The following substantive question of law arises for the consideration of the second appeal. Whether the lower appellate court was justified in holding that exhibit P10 is a grant under PTCL Act ಅಂತ ಹೇಳಿದಾರಾ?
ಇಲ್ಲ, ಅವರೇನು ಹೇಳಿಲ್ಲ. ಇಟ್ ಇಸ್ ವೈಡ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ ವೈಲೇಷನ್ ಆಫ್ ದಿ ಆರ್ಡರ್ PTCL ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಪ್ಲೇಸ್ ಮಾಡಿ ಸೆಕ್ಷನ್ 4 ವೈಲೇಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. ನಾಟ್ ವ್ಯಾಲಿಡ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ 4.
ಬೇಡ. holding that the registered agreement of sale dated 22/9/2010 is void under section 4 of the PTCL Act, correct?
ಹೌದು.
Whether the first appellate court was justified in reversing the finding of the trial court in declining to grant the relief of specific performance in setting aside the judgment and decree of the trial court, and the same amounts to perversity. Only two
And I
substantive
sought for
question of
stay of the judgment mother because of that mother they have filed the execution petition. One more that suit for injunction ಹಾಕೊಂಡು they are not
ಏನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ರೀ ಇದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದಾರೆ
subsequent
ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ
ಅಲ್ಲ,
appeal ಅಲ್ಲಿ.
subsequent to that one Ganesh Kumar has filed the suit for injunction mother that came to be declared on that basis the filed the execution petition.
ಯಾವ ಸೂಟು
ಇದರಲ್ಲಿ that appellant respondent mother
ನೀವು ಅಲ್ಲೇನಾದ್ರು ಬೇರೆ ಡಿಗ್ರಿ ಇದ್ರೆ ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಕೋಬೇಕು ಇಲ್ಲಲ್ಲ
ಇಲ್ಲ ನಾನು
ಇದ್ರಲ್ಲಿ ಏನ್ ಮಾಡೋದು
ಇದರಲ್ಲಿ ನಾನು ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಸ್ಟೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ ದಟ್ ಆ ಥರ್ಡ್ ಪಾರ್ಟಿ ಕ್ರಿಯೇಟ್ ಮತ್ತೆ ಕ್ರಿಯೇಟ್ ಥರ್ಡ್ ಪಾರ್ಟಿ
ನೀವು ರಿಲೀಫ್ ಏನ್ ಕೇಳಿದಿರಿ
ಅಲ್ಲ ನಾನು ಲೋವರ್ ಕೋರ್ಟ್ ಅಪ್ಲೇಟ್ ಕೋರ್ಟ್ ಸ್ಟೇ ಕೇಳಿದ್ದೀನಿ.
ಆಯ್ತು ಹರ್ಡ್ ಆನ್ A number 1/25 wherein prayer is sought to stay the impugned
judgment and decree of the lower
judgment and decree of the first appellate court reversing the judgment of the trial court. ಅದ್ ಸ್ಟೇ ಆದ್ರೆ ಮತ್ ನೀವು ಇದ್ರ ಮೇಲೆ ಕೆಳಗಿನ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ನಂಗೆ ಸೇಲ್ ಡೀಡ್ ಕೊಡಿ ಅಂತ ಹೋಗ್ತೀರಿ.
ಯಾಕಂದ್ರೆ some appeal is pending mal that I have not sought for any mal that pendants of this appeal mal that whatever may be merits mat tirmana illa till then mal that stay mal.
If it is stayed then you will file an execution petition.
How can I during the pendants of this appeal mal.
ಆಯ್ತು ತೊಳೆ ಏನಾಯ್ತು ಮೇಡಮ್ reversing the judgment of the trial court.
RA number 5004 of 2015.
And this court having considered the grounds urged in the second appeal and also considering that there is a divergent finding, admitted the appeal and framed the substantive question of law, and matter requires reconsideration, and hence impugned judgment and decree of the first appellate court is stayed.
Please mal.
Records ಬಂದಿದೆಲ್ಲ records are received and no need of filing of paper book. List the matter for file and hearing on other date ಕೊಡಿ ಮೇಡಮ್ 11 ಬೇಡ ಇನ್ನೊಂದು ಆಚೆ ಕೊಡಿ 13/11
Please mal.
11 ಸುಮಾರು ಹಾಕಿದೆ
44.
44 ವಿಶ್ವಜಿತ್ ರೈ.
The respondents 1 to 4, my lord, filed OS number 651 of 2015, my lord, against R1 to R4, my lord. The said the suit was dismissed, my lord. Thereafter, an appeal was filed against that judgment which came to be decreed, my lord. So the fact remains that the prayer was granted for the relief of possession. The said judgment was sought to be executed, my lord.
By filing an execution petition.
Yes, when we came
wherein you have filed an application for obstruction.
Obstruction, yes. When we came to know about the filing of the execution petition or obstruction petition was filed, we contended, my lord, that we had purchased the property as per exhibits P1 to P3 in respect to the very same property where the door number was also mentioned in respect of the same property. The other side, my lord, they traced their title, that is respondents traced their title, my lord, to a document of the year 1894, my lord. That is exhibit R1.
ನೀವು ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು ಯಾವಾಗ?
92.
92.
Not 90, sorry, my lord. We purchased, my lord, 83, my lord. Their document was of the year 1893, my lord. Our
93.
Yes. Now, if your lordship may kindly see the said document, when I have the copy of the document, survey numbers were not mentioned, extent is not mentioned, nothing is mentioned. And the door number is also not mentioned. The second document which they have produced is P2, my lord.
From whom you have purchased the property?
I have purchased from the Mula Genidar.
Mula Genidar.
Yes.
Who is Mula Genidar?
Yes, exhibit P1 is the power of attorney, my lord, where his father executes a power of attorney in favor of his son to execute the sale deed. Exhibit P2 is the sale deed. Exhibit P3 is the purchase of the Muli rights, my lord. Yes, these are the three documents which I claim title, my lord. In respect of the very particular door number, my lord. The door number, my lord, which relevant, my lord, is 6-12-453. Now the document of the respondents, my lord, is one is P1, R1, my lord. That is the Moolageni. That Moolageni deed was executed by one Venkatraya in favor of the ancestors of the respondents. In the said document, my lord, there is no survey number, there is no extent. Thereafter, after 40 years, my lord, their ancestors mortgages the said property. Even in the mortgage deed, my lord, the door number is not mentioned. Thereafter, there was the redemption of mortgage in respect to the very same property. My submission, my lord, in all these documents, my lord, in the initial document, that is of the year 1894, my lord, survey number is not there. Extent is not mentioned. Even in the second document, that is the mortgage deed, extent is there, but the door number in respect of this particular house is not there. My submission is that, my lord, exhibit P1, my lord, that is the power of attorney executed by the Moolagenidar, my lord. It shows, my lord, the door number which is in existence.
Para 42, 43, 44, Odi.
Trial court. Yes.
Execution order.
The law on the Moolageni tenancy. The law on Moolageni tenancy transpires that Moolagenidar has the upper hand in respect of the Moolageni properties. The Moolagenidar will be in possession of the property holding Moolageni rights. He can induct the tenant and receive rent from him. Moolidar, on the other hand, is unable to do so. He can only invoke the forfeiture clause in the Moolageni deed and seek possession of the property. Therefore, even if it is considered that the father of the obstruction petitioner was the Moolidar of the property, he has no right or interest.
No title or right.
He has no right in terms of the possession of the property.
Next.
The discussion so far would lead to conclude that the decree holders have title to the property bearing number 843 TS number 1040 and the obstruction petitioner has title to the property in survey number 844 TS number 1041. An astonishing fact in exhibit P2 Mooli deed of the obstruction petitioner and in exhibit R6 Mooli deed is that the property consisting of door number 6-1243, the actual property sought to be delivered in the execution petition has been transferred in both the deeds. Since Mooli rights are only right to collect rents, in order to know the person who is entitled to the property bearing door number so and so, location and Moolageni rights belonging to door number have to be traced. It is pertinent to note that even after losing the previous battle, if the obstruction petitioner could make out that he is situated in survey number so and so of 1041, he would succeed. According to exhibit P3 Moolageni deed of the father of the obstruction petitioner, door number is also sold in his favor. However, it is the observation of the court in RA 87 that the vendor of the father of the obstruction petitioner had no right to sell such property. Thus, exhibit P3 would not help the obstruction petitioner. Exhibit R10 and 11, title deeds of the vendor of the father of the obstruction petitioner, do not depict the door number of the property acquired by them. Other than exhibit P2 and P3, there are no documents to show that door number so and so is situated in RS number 844, TS number 1041. On the other hand, exhibit R1, the Moolageni deed of the ancestors of exhibit R5, R5 and will and mortgage deed exhibit R13 do not make reference to door number so and so. Exhibit R6, the Mooley rights, is only the document of decree holder that mentions door number 6/12/453. The said deed is of no use to locate the location of the property or the title to the property, as there is a conflict between Exhibit P2 Mooley rights and Exhibit R6. Now, para 45, my lord. The only document indicating door number 6/12 in RS number 643 and TS number 1 is Exhibit P8 certificate issued by the village accountant. It says that the door number is situated in so and so of Kodial village. Though the said document does not make reference to its basis for certifying the location of the property, it is issued by a public officer, and therefore there are no grounds to suspect the document. It is also not seriously disputed by the other side. Now, your lordship, I have the Exhibit P8, my lord. If your lordship kindly peruse Exhibit P8, my lord, it shows that he has just given a certificate, my lord. Now, question is, in my documents, this particular door number is mentioned, my lord. In all the documents, in my case, door number is mentioned, whereas in their documents, door number is not mentioned. First time, my lord, Exhibit P8 comes into existence where the door number is mentioned. This is the first only document, my lord. Now, your lordship, kindly see Exhibit P8 for a moment, my lord. R8, my lord.
Records ಬಂದಿಲ್ಲ.
Kindly see R8, my lord.
Good. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ, ಕಾಪಿ ಇದೆಯಾ?
ಹೌದು, R8 ಇದು ಕಾಪಿ ಇದೆ.
ಕೊಡಿ.
It is nearly 100 years thereafter, my lord, this document has come into. Whereas in my document, the door number is given, my lord, everything is there. And
except this document, have you got any other document?
To show, my lord. P2, my lord.
ಏನದು Exhibit P2?
P2 is the sale deed, my sale deed.
Sale deed ಆಯ್ತು, but other than this, sale deed
This is their document.
Sale deed ಬರಕ್ಕಿಂತ
Allah, this is their document, my lord, not my document. This is the document produced by the contesting respondents herein.
ಅದೇ R8, that is discussion made in paragraph number 45.
Yes, my lord. And thereafter, my lord, even at para 46, my lord, the court must draw conclusions based on the document placed before it. There are no other unambiguous documents to prove the location of the property apart from Exhibit P8. Now, if your lordship may kindly see their title, my lord, that is of the year 1894. Door number is not there, survey number is not there, extent is not there. Even in thereafter, he mortgages the property, my lord. In that also, door number is not there. Even in the redemption, my lord, the door number is not there. Because the Mool again, Exhibit P2, my lord, Exhibit P2, the door number is clearly mentioned, my lord, in my document. Even, my lord, there were two other execution petition filed wherein some other persons have filed obstruction petition, my lord. Those petitions also came to be allowed actually, 171 and 172. Court says, my lord, curiously, my lord, the court says that para 55, my lord. Para 55 at page 49, my lord.
Para 55. Hey.
These I will
the
read.
Civil courts are courts of facts.
No, I will read 54, my lord. Your lordship will have a brief. It is contended by the Land Council for the obstruction petitioner that the obstruction petitioner had filed in a similar petition in so and so before the principal civil judge and JMFC Mangalore. The said court after trial dismissed the execution petition filed by the decree by allowing the application filed by the execution petitioner as per Exhibit P11. The court may incline towards the said decision and lean in favor of the obstruction petitioner. The civil courts are courts of facts and not courts of law. The decision of the coordinate court is a finding of fact, not law. The coordinate court would have acted upon the material and testimonies of the witnesses placed before it. In fact, it is the testimony of DW1 that she could place all the materials before other court. Thus, I have come to the conclusion, based upon the materials available to me, the decision of the coordinate court does not bind the other court. My submission is that the other two execution petitions filed, them obstruction petitions were allowed.
So issue notice, call for records.
Sought for stay, my lord.
ಏನ್ ಸ್ಟೇ ಕೇಳಿದಿರಿ?
Stay of the execution petition.
ಹಾಕಿದಾರ
ಹೌದು,
execution? execution.
ನಾಳೆಗಿದೆ.
Heard on I number 1 of 25. Wherein prayer is sought that the execution petition filed by the respondent, that is 253 of 2018 on the file of First Additional Civil Judge and JMFC Mangalore, if it is enforced, the second appeal filed by the appellant will become infructuous. And having considered the grounds which have been urged, particularly the reasoning given in paragraph number 54 of the executing court in execution case number 253 of 2018, when the similar petition was filed in execution number 172 of 2017, the said application was allowed and the execution petition was dismissed in terms of exhibit P11, and having taken note of the said fact into consideration, and also the observation made in paragraph number 45 of the order of the trial court, matter requires reconsideration and hence stay is granted as sought till next date of hearing.
Grateful.
List this matter on issue emergent notice on ಮಾಡಿ issue emergent notice old matter, list this matter on 411.
Lordship's kind permission. Serial number 55 of the 230 list, may withdrawing the petition.
55, yeah.
House.
Good.
Serial number 47, my lord. 6 short accommodation.
Thoroughly. Petitioner counsel files memo.
I produced the order, my lord. It was due.
Yeah,
Because, my lord, there was a earlier, my lord, by engaging other counsel, my lord, the Lordship has passed the order. Now, my lord, I have been misdirected and misled by not narrating that facts, my lord. That is why I produced the order for your.
Impression of
Yes, my
earlier
lord.
order.
ಹೌದು.
One more petition ಈಗ.
ಹೌದು, ನಾನು ಅದಕ್ಕೆ ಅರ್ಲಿಯರ್ ಕೌನ್ಸಿಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದು ನನಗೆ ವಿಷಯನೇ ಹೇಳಿದೆ. There was a group of persons, now my lord individually has come after 3 years.
Reject ಆಗಿದೆ.
Reject ಆಗಿದೆ. Same offense. My apologies, my lord.
ಆಯ್ತು. For the petitioner files memo stating that earlier criminal petition number 5361 of 2020 was rejected by the order dated 9th day of March 2021, and the same is not brought to the notice of this petitioner. And hence, press this court not going to press the petition and he may be permitted to withdraw, and hence permitted to withdraw in terms of the memo.
My lord, serial number 48, my lord. My lord,
48.
that 48.
ಏನಾಗ್ಬೋದು?
My lord, this matter was referred to Lok Adalat and we have already suggested a proposal, my lord. Kindly grant 2 weeks time to settle the
Other side
matter.
ಇದಾರಾ?
Other side is present.
Settlement ತಗೊಳ್ಳಿ. Both counsel submit that there is an element of settlement. And seeks time and hence list this matter on ಯಾವಾಗ ಬೇಕು?
After 2 weeks, my lord.
2 weeks ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್. 30/10.
Much obliged, my lord.
Serial number 47, my lord.
47.
My high.
ಏನಾಗಬೇಕು ಹೇಳಿ?
My lord, short accommodation, my lord.
Okay.
Senior is not there, my lord.
Not there ಅಂದ್ರೆ?
Due to some family emergency, my lord, he left.
ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
ಹೇಳ್ತೀನಿ ನಾನು.
ಹೇಳಿದಿರಾ ಅಂತ ಕೇಳಿದೆ. ಹೇಳಿದಿರಾ ಅಂತ ಕೇಳಿದೆ. ಹೇಳಿಲ್ಲ ಇನ್ನು.
ಇನ್ನು ಹೇಳಿದೆ.
ಹೇಳ್ಬಿಟ್ಟು ಮಧ್ಯಾಹ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ. 2:30. ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರಿದ್ದಾರೆ?
ನಾನು ಹೇಳ್ತೀನಿ. ಹೇಳ್ಬಿಟ್ಟು
ಅರುಣ್ ಪ್ರದೇಶ್ ಅಂತೇನೋ ಇದೆ. ಅರುಣ್ ಪ್ರದೇಶ ಇದೇನ್ರಿ ಇದು? ಹೊಸ ತರ ಹೆಸರು ಇದು.
ಅರುಣ್ ಪ್ರದೇಶ್.
ಹೇಳಿದಿರಾ?
I'll mention.
ಸದ್ಯ ಆಂಧ್ರ ಪ್ರದೇಶ ಅಲ್ವಲ್ಲ. ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಮೆನ್ಷನ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ.
53.
ಅದರ್ ಸೈಡ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಧ್ಯಾಹ್ನ ಯಾರು ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ.
I have informed the other side, my lord.
50?
53, my lord.
ಹೇಳಿ ಏನಾಗಬೇಕು?
Matter for final hearing, short accommodation, my lord.
ಅದರ್ ಸೈಡ್ ಇದಾರಾ?
Please, my lord.
ನೀವಾ? ನಿಮಗೂ ಟೈಮ್ ಬೇಕಾ? ಅವ್ರಿಗೆ ನೀವು ರೆಡಿ ಇದ್ದೀರಾ? ನೀವು ರೆಡಿ ಇದ್ದೀರೇನ್ರಿ? Appellant counsel seeks time and other side is also present and says no objection. List this matter on 3010.
Serial number 45.
45. ಏನಾಗಬೇಕು ಹೇಳಿ?
ನಾಳೆಗೆ ಹಾಕ್ಬಿಟ್ಟು.
ನಾಳೆಗೆಲ್ಲ ಡೇಟ್ ಕೊಡೋದಿಲ್ಲ, ಇವತ್ತಿದ್ದು ಕೊಟ್ಟವಲ್ಲ ಆಲ್ರೆಡಿ. ಕೊಟ್ಟಿದೀವಲ್ರಿ ಅದು ನಾಳೆಗೆ?
ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ನಾನು
ಹಾಕಿದೀವಲ್ಲ, ಬೆಳಗ್ಗೆ ಕೇಳಿದ್ವಿ.
ಹಾಕಿದ್ದಾರೆ.
ನಿನ್ನೆ ಪಾರ್ಟ್ ಔಟ್ ಮಾಡಿ ನಾಳೆಗೆ ಹಾಕಿದೀವಿ. ಆಯ್ತು.
Serial number 51, my lord.
51 ಏನಾಗಬೇಕು ಹೇಳಿ ಮೇಡಮ್?
Respondents 1 to 4, my lord.
ಹಾ?
And for respondents 1 to 4, my lord.
1 to 4 ಆಯ್ತು. ದೇಸಾಯಿ ರಾಜೇಂದ್ರ ಚಂದ್ರಶೇಖರ್ ಅವ್ರಿಗೆ ಇಂಟಿಮೇಟ್ ಮಾಡಿದೀರಾ?
My lord's one submission, my lord. They are not served copy to us because we have no documents.
ಏನ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ?
Memorandum of appeal copy.
ಮೇಡಮ್ ಅಡ್ಮಿಟ್ ಆಗಿ ಫೈನಲ್ ಇಯರ್ ಇರೋದು ಇದು. ಏನ್ರಿ ಕೊಟ್ಟಿಲ್ಲ ಅಂತಲ್ಲ, ಕೊಡ್ರಿ ನೀವು. ಅಕ್ಲೈನ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇದೆ my lord.
ಹಾ?
ಇದೆ my lord.
ಸರ್ವ್ ಮಾಡಿದಾರಂತಲ್ಲ?
No, my lords, we have no copies.
ಆಯ್ತು, ಮಧ್ಯಾಹ್ನ ನೋಡೋಣ 2:30 ಗೆ. ಅಕ್ಲೈನ್ಮೆಂಟ್ ಇದೆಯಾ ಎಲ್ಲ ನೋಡೋಣ. ಹಾ.
They make a mention for 2:30 matter. 2:30 matter. Final disposal ಗಿದೆ. Seniors my lords in Assam. The request is my lords short accommodation.
ನಾಳೆಗೆ ಇದೆಯಾ? ಯಾವ್ದು ಹೇಳ್ರಿ?
59 my lords. Final disposal ಗಿದೆ. The request is my lord seniors not in station is in Assam. I informed my friend.
ಅದರ್ ಸೈಡ್ ಹೇಳಿದಿರಾ?
ಹೇಳಿದೀನಿ ಸರ್.
ಹಾ, ಯಾವಾಗ ಬೇಕು?
Lords any date.
ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ.
ಅದೇ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಗೆ ಅಂತ ಇದೆ. Only request is my lord seniors not in station today. ಅದಕ್ಕೆ ಒಂದು ಶಾರ್ಟ್.
ಈಗ ಯಾರು ಶಂಕರಪ್ಪ ಅವ್ರಿಗೆ ಹೇಳಿದಿರಾ?
ಹಾ, ಹೇಳಿದೀನಿ ಸರ್. Yesterday also
respondent counsel seeks time and counsel also submit that already intimated the petitioner counsel. And hence list this matter ಯಾವಾಗ ಬೇಕು ಹೇಳಿ?
Lords any date my lords 23rd 24th my lords. 23rd
2510 ಆಯ್ತು.
25th grateful.
2510
grateful.
ಇದು ಯಾವ್ದು ಗಂಟೆಗಟ್ಟಲೆ ಮಾಡಿದ್ವಲ್ಲ ಅದಿರ್ಬೇಕು. ಅದ್ಯಾವ್ದು ರಾಮನಗರ?
ಹೌದು ಸರ್.
ಅವನ್ ಯಾರೋ ಪೊಲೀಸು ಐಒ
ಸೇಮ್ ಕೇಸ್
ಎಲ್ಲ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿರ್ಲಿಲ್ಲ. ಆಮೇಲೆ at the instance of the owners ಏನು ಅದೇನೋ ಅದಿರ್ಬೇಕು. ಕಿರ್ಲೋಸ್ಕರ ಯಾವ್ದೋ ಕಂಪನಿ?
ಟೊಯೋಟಾ
ಅದ್ರ ಮೇಲೆ ಏನೋ ಒಂದು ಆರ್ಡರ್ ಆಯ್ತು, ಅದ್ರ ಮೇಲೆ ಸುಪ್ರೀಂ
ಕೋರ್ಟ್ my lords granted us the right of audience. Yes. Correct.
ಇದರಲ್ಲಿ ಸ್ಟೇ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ರಿಲೀಸ್ ಏನು 48 and 53 ಅಲ್ವಾ ಲಾಸ್ಟ್ ಬರ್ತಾನೆ ಆಗಿತ್ತು.
48, 53,
53 ಇವಾಗ 53 and 50. ಓಕೆ ಹೇಳ್ತೀನಿ. 17 30 ನಿಮ್ದು 53 ಅದು 30
ಮೇಡಮ್ ಪಾಸ್
ಪಾಸ್ ಅವ್ರಿಗೆ ಅದೇ 2:30 ಆದ್ಮೇಲೆ ನೀವು ಅದೇನ್ ಮಾಡೇ ಇಲ್ಲ, ಮಾಡ್ಬೇಕಲ್ವಾ ಅದು ಕರೆಕ್ಷನ್ಸ್. IML ಆರ್ಡರ್ ಆಗಿದೆ. ಇಲ್ಲ IML ಆರ್ಡರ್ ಆಗಿದೆ. ಕರೆಕ್ಟ್ ಪರ್ಮಿಟೆಡ್ ಟು ಕರೆಕ್ಷನ್ ಕ್ಯಾರಿ ಔಟ್ ತೋರಿಸ್ತೀನಿ ನೋಡಿ. ಇದೆ ನೋಡಿ ಸರ್, ಇಲ್ಲ ಅಂತಂದ್ರೆ ಇದೆ ನೋಡಿ, ಆರ್ಡರ್ ಆಗಿದೆ. 13/7/22 ನಲ್ಲಿ ಸಬ್ಮಿಟ್ ದಟ್ ಅನದರ್ ಸೂಟ್. ಇರಿ ಹೇಳ್ತೀನಿ.
ಏನಿಲ್ಲ 32 ನಲ್ಲಿ ಇವಾಗ ಅವಾಗ ಹೇಳಿದ್ರು ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅಂತ ಹೇಳಿದ್ರು. ಇದು ಅಡ್ಮಿಷನ್ ಬರೋ ತರ ಹೇಳಿದ್ರು.
ಪರವಾಗಿಲ್ಲ, ಅದೇನೋ ಪಿಕಪ್ ಮಾಡೋ ಅಡ್ಮಿಷನ್ ಆಗುತ್ತೆ, ಇದು ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ
ಇವಾಗ ಏನಿದು ಕ್ಲಬ್ ಮಾಡ್ಬಾರ್ದಾ ಡೇಟ್
ಕ್ಲಬ್ ಮಾಡ್ಬೇಕು, ಕ್ಲಬ್ ಮಾಡ್ಬೇಕು.
ಅಲಾಂಗ್
ಏನು
ವಿತ್
ಆಗಲ್ಲ.
ಅಲ್ಲ ಹೌದಾ ಸುಮ್ಮನೆ ಅಲಾಂಗ್ ವಿತ್
ಆಗುತ್ತೆ ಆಗುತ್ತೆ ಅಂದ್ರೆ ಅದು ಅಡ್ಮಿಷನ್ ಬರುತ್ತೆ, ಅಡ್ಮಿಷನ್ಗೆ ಅದು ಯಾವ್ದು ಬರುತ್ತೋ ಅದು ಬರುತ್ತೆ. ಸರ್ ಒಂದು ನಿಮಿಷ ಸರ್, ಪರ್ಮಿಷನ್ ಎರಡು ಒಂದೇ ಅದು. Learned counsel will seek permission of this court to delete the schedule in IA2 of 21. He is permitted to delete the IA2 of 21. ಅಲ್ಲ ಅದು ಪರ್ಮಿಷನ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಐಏನೇ ಇರುತ್ತೆ, ಅದು ಇದ್ರಲ್ಲಿ ಇಲ್ಲ, ಅದು ಮೇನ್ ಅಲ್ಲೇ ಇರುತ್ತೆ. 2(8) ಅಲ್ಲ. ಸರ್ ಒಂದ್ಸತಿ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಹೆಂಗೆ IA2 of 21 ನೀವು ವಿತ್ಡ್ರಾ ಮಾಡ್ಕೊಂತೀರಾ ಸರ್? ಅದು ಬೇರೆ ಇರ್ಬೇಕು, ಅದೇನೋ ಇರ್ಬೇಕು. ಅಲ್ಲ ಸರ್, ಅದು ಆಕ್ಚುಲಿ ಆರ್ಡರ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ರಾಂಗ್.
ಲಾಸ್ಟ್ ಹೇಳ್ತಾರೆ. ಈ ದೋಷಾರೋಪಣಾ ಪತ್ರದ
ಹಿಂದಿನ ಏನು ದೋಷಾರೋಪಣಾ ಪತ್ರದ 12ರಲ್ಲಿ ಆರೋಪಿ ಶ್ರೀ ಚಂದ್ರ ಚನ್ನಗಿರಿ ಅವರು ವಿಲ್ ಮಾಡಿದ್ದ ವಿಲ್ ಪತ್ರವನ್ನು ಮರೆಮಾಚಿ ಅಥವಾ ನಾಶಪಡಿಸಿ ಮೂಲ ವಿಲ್ನ ಬದಲಾಗಿ ತಾನೇ ಒಂದು ನಕಲು ವಿಲ್ ತಯಾರು ಮಾಡಲು 22/9/91 ಹಿಂದಿನ ದಿನಗಳಲ್ಲಿ ತಾನೇ ಸಂಚು ರೂಪಿಸಿ ನಕಲಿ ವಿಲ್ ಅನ್ನು ಯಾವ ರೀತಿ ಮಾಡಬೇಕೆಂಬುದನ್ನು ಯೋಚಿಸಿ ನಂತರ ಸಾಕ್ಷಿ 3 ಹಾಗೂ ಲೇಟ್ ವಿಜಯ್ ಕುಮಾರ್ ಸಾಕ್ಷಿ 5 ಅವರಿಗೆ ಸೇರವಾದ
ಆಸ್ತಿಗಳನ್ನು ತಾನೊಬ್ಬನೇ ಅನುಭವಿಸಬೇಕೆಂದು ಒಳ ಸಂಚು
ಮಾಡಿ ಸದರಿ ವಿಲ್ಗೆ ಆರೋಪಿ 3 ಮತ್ತು 4 ರವರು
ಸಹಿ
ಮಾಡಿಸಿ ನಂತರ ಆರೋಪಿ 5 ರವರ ಬಳಿ ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಲೇಟ್ ವಿ ಚೆನ್ನಗಿರಪ್ಪರವರು ವಿಲ್
ತಮ್ಮಲ್ಲಿ ಅಟೆಸ್ಟೇಟ್ ಮಾಡಿಸಲು ಕಳಿಸಿರುವುದಾಗಿ ಹೇಳಿದ್ದು ಆರೋಪಿ 5 ರವರ ಸಹಿಯನ್ನು ಸಾಕ್ಷಿಯಾಗಿ ಸಹಿ ಮಾಡಿರುವ ಹಾಗೂ ಲೇಟ್ ಚೆನ್ನಗಿರಿ
ನೋಟ್ರಿ ಮುಂದೆ ಅಟೆಸ್ಟ್ ಆಗಿರೋದಾ
ಅಷ್ಟೇ ನೋಟ್ರಿ ಮುಂದೆ ಅಷ್ಟೇ.
ಮತ್ತೆ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ ಮಿಲಾಟ್ ಲಾಸ್ಟ್ ಇನ್ನೊಂದು ಪ್ಯಾರಾದಲ್ಲಿ ಸಾಕ್ಷಿ 3 ಮತ್ತು ಸಾಕ್ಷಿ 5 ರವರಿಗೆ ಮೋಸ ಮಾಡಿರುವುದು ಹಾಗೂ ಆರೋಪಿ 1 ರವರು ನಕಲು ವಿಲ್ ನಲ್ಲಿ ಆರೋಪಿ 3 ಮತ್ತು ಆರೋಪಿ 4 ರವರು ನೋಟರಿ ಕಚೇರಿಯ ಸಹಿ ಮಾಡದೆ ಬೇರೆ ಎಲ್ಲೋ ಜಾಗದಲ್ಲಿ ಆರೋಪಿ 1 ರವರ ಟೈಪ್ ಮಾಡಿಸಿರುವ ನಕಲು ಸಹಿಗೆ ವಿಲ್ಗೆ ಸಹಿ ಮಾಡಿ ಸಾಕ್ಷಿ 3 ಮತ್ತು ಸಾಕ್ಷಿ 5 ರವರಿಗೆ ಮೋಸ ಮಾಡಿರುವುದು.
ಆಯ್ತು, ಒಟ್ನಲ್ಲಿ ದೇ ಆರ್ ದಿ ಅಟೆಸ್ಟಿಂಗ್ ವಿಟ್ನೆಸ್.
attesting witness kindly see the page number
ಆರೋಪಿ 3 ಮತ್ತು 4 ರವರ ಮೇಲೆ 420 IPC
kindly see the page number
up to 7 years
set suit my lord kindly see the page number 142 the present suit filed by the plaintiff against the defendant for the relief of the
ಟ್ರಯಲ್ ಅಲ್ಲಿ my lord ಇವ್ರ ಮೇಲೆ ವಾರಂಟ್ ಇದೆ my lord ಟ್ರಯಲ್ ನಡೀತೈತೆ CC number 5997/2024 HPC ಇತ್ತು ಇವ್ರು ಬರ್ತಾ ಇಲ್ಲ my lord issue NBW2 A3 and A4 this petitioner my lord next date of hearing 17/11/2025 my lord
ಆ ಕೇಸಲ್ಲಿ ನೀವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಇದುವರೆಗೂ?
ಅಲ್ಲ ಇಲ್ಲ
ವಾರಂಟ್ ಇದೆ my lord
ಸಮನ್ಸ್ ಬಂದಿಲ್ಲ ಸಮನ್ಸ್ ಬಂದಿದೆ ಅಷ್ಟೇ
ಸಮನ್ಸ್ ಬಂದಾಗ ನಿಮ್ಗೆ ಸರ್ವ್ ಆಗಿದೆ ಇಲ್ಲ
ಸರ್ವ್ ಆಗಿದೆ ಇವ್ರು ಬಂದಿಲ್ಲ ವಾರಂಟ್ ಇಶ್ಯೂ ಆಗಿದೆ.
ಒನ್ ಸೆಕೆಂಡ್ my lord kindly see the
next hearing date 17 November ಇದೆ my lord CC number 5
issue summons to accused number 3
ಯಾವ ವರ್ಷ ಅಪಿಯರ್ ಆಗಿರೋದ್ರಿ?
CC 24
yes my lord
kindly see the order sheet accused number 1 and 1 present accused number 2 reissue summons to accused number 3 and 4 through commissioner of police return over 28/7
ಈ ಫೈಲ್ ಪಿಟಿಷನ್ ಮುಂಚೆನೇ ಹಾಕಿದಿರಾ?
ಹೌದು
ಆಯ್ತು, ಸಮನ್ಸ್ ಬಂದ ತಕ್ಷಣ ಈ ಕಡೆ ಬಂದಿದ್ದೀರಿ?
ಅಲ್ಲ I am the witness my lord in the set suit my lord I am the as a DW2 and DW3 my lord
ಸೂಟ್ ಅಲ್ಲಿ ಎಕ್ಸಾಮಿನ್ ಆಯ್ತಾ ನಿಮ್ಮದು?
ಎಕ್ಸಾಮಿನ್ ಆಗಿದೆ
OS 451 of 98 ಅಲ್ಲಿ ಏನಾಯ್ತು? ವಾಟ್ ಅಲ್ಟಿಮೇಟ್ಲಿ ವಾಟ್ ಇಸ್ ದ ರಿಸಲ್ಟ್?
my lord suit the present suit filed by the plaintiff against the defendant for the relief of declaration possession and means profit is hereby partly decreed. Accordingly the plaintiff is entitled to the recovery of maintenance at the rate of rupees 500 per month from the date of death of her husband V Chengirappa till filing the present suit and 1000 rupees from the date of the present suit till date of this judgment and rupees 3000 per month from the date of the judgment during her lifetime.
ವಿಲ್ಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಏನಾದ್ರು ಇಶ್ಯೂ ಇದೆಯೇನ್ರಿ ಇದರಲ್ಲಿ ಒರಿಜಿನಲ್ ಸೂಟ್ ಅಲ್ಲಿ?
ಒಂದ್ಸಲ
ವಿಲ್ಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಏನಾದ್ರು ಇಶ್ಯೂ ಇದೆಯಾ? Whether the plaintiff proves that possession of the scheduled property and also they got into the possession of the said scheduled property and also the document relating to this property.
Third issue, whether the plaintiff further prove that the alleged will dated 22/9/91 is got the document and does not bind on her the reason stated in para 6 of the plaint my lord.
ಏನಾಯ್ತು ಅದಕ್ಕೆ? ಏನು ಪೆಂಡಿಂಗ್ ಏನು?
issue number 3 negative ಅಂತ ಇದೆ.
ನೆಗೆಟಿವ್ ಆಗಿದೆ. ಮತ್ತೆ then why criminal case?
They have the complaint before this Rexman number 2 is arrayed as defend number 7 my lord.
The issue with regard to the forgery of will is not been proved in civil case. Why criminal case?
And Rexman number 2 challenged before the district court my lord. That RA is also dismissed and thereafter RSA before this RSA also disposed of my lord.
RA ಏನಂತ ಡಿಸ್ಪೋಸ್ ಆಯ್ತು?
RSA ಅದೇ ಇದು ರೆಸ್ಟಿಫಿಕೇಟ್ ಮೇಲೆ ನೀವು ಹಾಕೋ ಇದು
RSA ಕಾಪಿ ಇದೆಯಾ?
ಇದೆ ಸರ್ ಕೈಂಡ್ಲಿ ಪೇಜ್ ನಂಬರ್
ಅಪೀಲ್ ಕಾಪಿ ಇದೆಯಾ ಇದರಲ್ಲಿ?
159 ಮೇಲೆ
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಪೀಲ್ ಅಪೀಲೇಟ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದೆಯೇನ್ರಿ?
ಇದೆ ಸರ್. The appeal is dismissed as not maintainable.
ನಾಟ್ ಮೇಂಟೈನಬಲ್ ಹೆಂಗ್ರಿ ಆಗ್ತದೆ? ಒರಿಜಿನಲ್ ಸೂಟ್ ಮೇಲೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಡಿಸ್ಮಿಸಲ್ ಆಗಿರ್ಬೇಕು ನೋಡಿ.
ಅಲ್ಲ ಸರ್, ಆರ್ಡರ್ ನಾನ್ ಮೇಂಟೈನಬಿಲಿಟಿ. ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
Considered view that the appeal would be disposed of, confirming the dismissal of the first appeal RA number 72, clarifying that the finding of the trial court on the will dated 29/5/1978 claimed by the appellant would not operate as res judicata if there were to be any further dispute on the
execution of the
will.
will. There is two will is there.
Will ಯಾವ ವರ್ಷದ್ದು ಇದು? ಈ will ಯಾವುದು? Forgery will.
1991.
With subsequent ಈ will ಗೆ ಸಂಬಂಧಪಟ್ಟಂತಿಲ್ಲ. ಏನ್ರಿ?
Notice I will take the instruction.
Instruction sir. ಸುಮ್ಮನೆ ಇದೀರಿ ಇದುವರೆಗೂ? ತಗೊಳ್ಳಿ. ಫಸ್ಟ್ ಟೈಮ್ ಇದು ಮೇಡಮ್?
Yes, my lord.
ನೀವೇನು HCGP ನ ಏನು ನೀವು?
SCGP.
HCGP is directed to take notice and HCGP seeks 2 weeks time to get the instructions and hence list this matter on ಇವತ್ತಿಗೆ 15 ದಿವಸ ಕೊಡಿ ಮೇಡಮ್.
Stay my lord.
Again stay.
ಅಲ್ಲ ಇವರೇನೋ ವಾರೆಂಟ್ ಆಗಿದೆ. Stay of further proceedings.
30/10 ಅವತ್ತೇ ಡಿಸ್ಪೋಸಲ್.
ಅಲ್ಲ meanwhile stay.
ಯಾರು ನೋಟಿಸ್ ಯಾರಿಗೆ ಮೇಡಮ್?
R2.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ನಾ?
Is a complaint.
ವಿ ಚಂದ್ರ ಅವರೇ ಕಂಪ್ಲೇನೆಂಟಾ?
ಹೌದು.
Complainant ಅವರೇನಾ?
Defend number 7 in the set suit.
Issue notice against respond number 2 and the IO and HCGP is directed to serve the notice on the respond number 2 through IO. PF ಕೊಡಿ.
ಕೊಡ್ತೀನಿ.
ಅವರು ಮಾಡ್ಲಿ, ಸರ್ವ್ ಮಾಡ್ಲಿ.
ಅಲ್ಲ ಇದು ಬೆಂಗಳೂರು ಅಡ್ರೆಸ್ ಮೇಲೆ
ಏನ್ ಬೆಂಗಳೂರು ಅಡ್ರೆಸ್?
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಇದೆ ಬೆಂಗಳೂರು ಅಡ್ರೆಸ್.
ಬೆಂಗಳೂರಲ್ಲೇ ಇರೋದು. ಕೊಡಿ. PF ಕೊಡಿ ನೀವು ಇಮಿಡಿಯೇಟ್ ಆಗಿ. 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್
56 SG Bhagwan.
The proceedings were initiated by the second respondent, who is none other than
first time.
Yes, my lord.
HCGP is directed to take notice and issue notice against respond number 2.
Yes, my lord.
And HCGP is also directed to serve the copy of this petition on the respond number 2 through IO. Appellant counsel is directed to, petitioner counsel is directed to furnish one more copy to the
I will do it.
HCGP to serve the copy on the R2. ಹಿಂದಿನ ಕೇಸಲ್ಲಿ ಹಂಗೆ ಮಾಡಿ ಮೇಡಮ್. ಹಿಂದವ್ರನ್ನು PF ಕೊಡ್ಬೇಕು, ಒಂದು ಕಾಪೀಸ್ ಮಾಡಿ. List this matter on 3010.
3010.
Hearing on IA 57. Geeta Devi MP.
Next week we were senior the Judicial Academy mediation training. Next week or 23rd.
There modification of order dated 8/4/22 na.
Please my lord. ತಮ್ಮ ಮುಂದೆ ಇದು ಡಿಸ್ಪೋಸ್ ಆಗಿತ್ತು. IA for change of circumstance ಆಗಿರೋದ್ರಿಂದ IA for modification in 22 ಅಲ್ಲಿ
increase of
two IAs, my lord. One that they have asked for reduction of maintenance and I have filed an IA for increase of maintenance.
2022 IA filed an IA my lord for modification.
ನಿಮ್ಮ IA modification ಅದು ಕಾಪಿ ಶುರು ಮಾಡಿದಿರಾ? ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರಾ?
ಹಾಕಿದ್ದಾರೆ.
I filed your.
ಆಯ್ತು.
I filed one objections on the last date, my lords. I have not received the copy. Objections on IA 1 ಅಂತ ಇಲ್ಲ, ಅದು ಕಾಪಿ ನಾನು
ಅದು ಕೈಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರಾ ನೀವು?
ಹಾಕಿದೀವಿ.
ಅದು ಕಾಪೀಸ್ ಕೊಡಿ ಅವರಿಗೆ.
ಕೊಟ್ಟಿದ್ದೀರಾ? I'll serve my lord. Once again I'll serve the copy.
One IA by you, another IA by you. ಹೌದಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಕೊಡಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಾಪಿ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ.
Nearly 18,75,000 arrears in
No,
this Swami. Previous, they have not paid the maintenance amount. I have 2 small daughters whom I have to take care.
Lord, date may be fixed.
Maintenance ಕೊಟ್ಟಿಲ್ಲ
ಕೊಡ್ತಿದ್ದೀವಿ ಸ್ವಾಮಿ.
Maintenance
already
is over.
Earlier order ಏನು?
Earlier order 10,000 for ಇಬ್ರು ಮಕ್ಕಳಿಗೆ, ಇಬ್ರು ಮಕ್ಕಳಿದ್ದಾರೆ, and then 10,000 for rent accommodation ಅಂತ in case if she is not coming 10,000 rent accommodation ಅಂತ ಇರೋದು ಸ್ವಾಮಿ ಆರ್ಡರ್ ಆಗಿರೋದು.
ಮಾಡಿಫಿಕೇಶನ್ ಏನು ಕೇಳಿದಿರಿ?
For the ಇದು ಮೇಂಟೆನೆನ್ಸ್ ಸ್ವಲ್ಪ ಮತ್ತೆ ರಿಡಕ್ಷನ್ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್
ಜಾಸ್ತಿ ಆಗಿದೆ, ಕಡಿಮೆ ಮಾಡಿ ಅಂತನಾ?
ಚೇಂಜ್ ಆಫ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಆಗಿದೆ. I lost my job and earlier my salary was around 1.5 lakhs my lord.
ಸರಿ, ಜಾಬ್ ಹೋದ್ರನ್ನ ಅವರೇನು ಊಟ ಮಾಡಿದ ಹಂಗೆ ಇರಬೇಕಾ?
That is not my
ಮಕ್ಕಳು ಹೆಂಡತಿ ಮಕ್ಕಳು.
But ಇವಾಗಲೂ ನಾನು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, but the change of circumstances I'll explain
to show that he has started his own construction company, start ಮಾಡಿರೋದಕ್ಕೆ documents furnish ಮಾಡಿದ್ದೀನಿ.
I have filed my objection to that mail.
ಆಯ್ತು. ನೀವು ಇದಕ್ಕೆ IA 1/25 ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರಾ? ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ.
ಇನ್ನೊಂದ್ಸಲ ಕೊಡ್ತೀನಿ.
Petitioner counsel. ನೀವು ನಮ್ಮಲ್ಲಿ ಇದು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ರಲ್ಲ ಏನ್ರಿ ಬರ್ತೀರಿ, ನೀವೇನಾದ್ರು ಅಗ್ರಿ ಇದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು ಮೇಲೆ. ಯಾರು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂಡು ನೀವು ಏನಾರು ಜಾಸ್ತಿ ಬೇಕು ಅಂದ್ರೆ ನೀವು ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಹಾಕೋಬೇಕು. ಇದ್ರಲ್ಲೇ ಕ್ರಿಮಿನಲ್ ಆರ್ ಪಿ ನಲ್ಲೇ ನೀವು ಬರಕ್ಕಾಗಲ್ಲ.
ಸ್ವಾಮಿ ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಫೈಲ್ ಮಾಡಿದ್ರು ಅಂತ ನೀವೊಂದು ಅರ್ಜಿ ಹಾಕಿದ್ರಾ?
ಸ್ವಾಮಿ ಅದು ಕ್ಲಬ್ ಆಗಿ ಇಬ್ಬರು ಪೆಟಿಷನ್ಸ್ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿರೋದು ಸ್ವಾಮಿ.
Madam, this court has decided the matter on merits. ಹೌದಾ? If anyone is agreed by the order, they have to challenge that order. ಒಂದು. ಎರಡನೇ ನೀವು ಎನಾನ್ಸ್ಮೆಂಟ್ ಬೇಕು ಅಂತಂದ್ರೆ you have to file a petition, fresh petition before the appropriate court. Get it enhanced the same, not by this court. ಏನು ಒಂದ್ ಕೇಸ್ ಇದ್ರೆ ಅದ್ರಲ್ಲಿ ಹಾಕೊಂಡು ಇರ್ಬೋದು ಅಂತಾನ ನೀವಿಬ್ರು ಏನು ಇದು ಕನ್ಸಿಡರೇಷನ್ ಬರಲ್ಲ, ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ ವಿತ್ ಎಕ್ಸಾಂಪ್ಲರಿ ಕಾಸ್ಟ್ ಇಬ್ರದನ್ನು. ಮತ್ತೆ ಕೋರ್ಟ್ ಟೈಮ್ ಕೆಲಸ ಇಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ರೆ ಕೋರ್ಟ್ಗೆ.
ಚೇಂಜ್ ಆಫ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್ ಆಗಿರೋದು. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ 23rd or 24th.
Counsel for the petitioner submit that he has already filed objections to A number 1 of 2025. ನೀವು ಮೊದಲಿಂದ ಹಾಕಿದ್ರಾ?
ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ,
ನೀವು
ಅಬ್ಜೆಕ್ಷನ್ಸ್
ಹಾಕಿದ್ರಿ,
ಫೈಲ್ ಮಾಡಿ.
ಆಯ್ತು. And hence furnish the copy of the objections on the counsel who appears on behalf of the respondent. Forthwith list this matter next week, next Wednesday ಕೊಡಿ ಮೇಡಮ್. ರಜಾ 30
ಪ್ಲೀಸ್.
29 ಆಗುತ್ತಾ? 29
ಪ್ಲೀಸ್.
ಮತ್ ನಾವ್ಯಾಕೆ ವೆಡ್ನೆಸ್ಡೇ 30 ಕೊಟ್ವಲ್ರಿ ಅವಾಗ ನೀವು? ನಾನೇ ನಿಮ್ ಕೇಳ್ದಲ್ಲ, ಇವತ್ತಿಗೆ 15 ದಿವಸ ಕೊಡಿ ಹಿಂದೆ. ನೋಟಿಸ್ ಹೋಗೋದಲ್ಲ ಮೇಡಮ್, ವೆಡ್ನೆಸ್ಡೇ ಮಾತ್ರ ಕ್ರಿಮಿನಲ್ ಹಾಕಿ ನಾ ಹೇಳಿದ್ದೀನಲ್ವಾ. ಹಿಂದಿನ 29 ಕೊಡಿ. ನಿಮ್ಮನ್ನ ಕೇಳಿದೆ ನಾನು, ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೆಡ್ನೆಸ್ಡೇ ಕೊಡಿ, ಅದ್ರ 15 ದಿವಸಕ್ಕೆ ಅಂತ. ಎಲ್ಲಾದ್ರೂ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಮಾಡ್ತಾ ಕೂತ್ಕೊಳಕ್ಕಲ್ಲ RSA ಇದ್ದಾಗ. ನೆಕ್ಸ್ಟ್ withdrawal of amount filed by counsel for the respondent. Modification of the order dated 17/2/25. ಏನ್ರಿ ಇದು modification?
The fine amount was 16 lakhs, Miller. I don't know how they came to the conclusion, the other side submitted. So basing on that submission, they are so pleased to
heard the learned counsel for the
direct for deposition of 50%. But the trial court order is 16
check
lakhs.
amount is rupees 12 lakh and the trial court order to pay 16 lakh, having considered the same allowed subject to depositing of 50% of the amount of rupees 13 lakh, deducting the amount already been paid before the trial court within 4 weeks from today.
Fine amount was 16 lakhs, Miller, not 13 lakhs. Not 13 lakhs, Miller. Fine amount was 16 lakhs.
Check amount ಎಷ್ಟು ಮೇಡಮ್?
Check amount 12 lakhs, Miller.
ಮತ್ತೆ ಇದೇನ 13 ಲಕ್ಷ ಏನಕ್ಕೆ ಬಂತು?
13 ಲಕ್ಷ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. As on the date of passing of that order,
appearing for whom, madam?
The counsel was there. The Petitioner counsel made some submission, I don't know. But so far, Miller, trial court, she took time before the trial court that she would deposit the fine amount.
This is only an entry matter ಅಲ್ವಾ ಮೇಡಮ್?
Entry matter.
ನಮ್ಮ ಮುಂದೆ ಯಾಕೆ ಬಂತು matter?
I don't know.
Modification. ಏನ್ modification ಕೇಳಿದ್ರು?
ಅದು 16 lakhs, 16 lakh, 50% of 16 lakhs ಆಗ್ಬೇಕು ಸ್ವಾಮಿ.
You are appearing for whom, madam?
I'm for the respondent. Respondent complainant, sir.
ಕಾಪಿ ಶುರು ಮಾಡಿದಿರ ಅದರ ಸೈಡ್ ಗೆ?
ಮಾಡಿದೆ ಸರ್, ಮಾಡಿದೆ.
ಕೊಡಿ ಮೇಡಮ್ ಅಪ್ಲಿಕೇಶನ್ ಇದು. ಕದು ಕಾಪಿ ಶುರು ಮಾಡಿರೋದು. In spite of service of the application A number 3, ಹರೀಶ್ ಅಂತಿದೆ ಇಲ್ಲೇನೋ ಸೈನ್ ನೋಡಿ.
ಹರೀಶ್ ಯೋಗಾನಂದ
ಯೋಗಾನಂದ
petitioner ಅದೇ.
ಯೋಗಾನಂದ ಅಂತಿದೆ, ಇಲ್ಲ ಯಾರು ಬೇರೆ ತಗೊಂಡಂಗಿದೆ.
Same office, that was the
ಆಯ್ತು
address for this.
On 3/10/2025, counsel for the petitioner not appears before the court. If counsel doesn't appear in the next date of hearing, IA 3/25 will be considered in the absence of counsel appearing for the petitioner. List this matter on 29.
IA number 3 is Milan.
IA number 3 ನೇ, IA number 3/25 ನೇ.
That's why they have
withdrawal ಗೆ ನೀವು ತಗೋಬಹುದು. ಯಾರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ನೀವೇನಾ?
ಹೌದು ಸರ್. I mean
ಅದು ಕಾಪಿ ಶುರು ಮಾಡಿದಿರಾ?
ಮಾಡಿದೆ ಸ್ವಾಮಿ, ಎರಡೂ ಮಾಡಿ.
ಹಾಗಾದ್ರೆ IA number 2 and 3 ಎರಡೂನುವೆ 2 and 3 29/10 ಎರಡು ಅವತ್ತೇ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀನಿ.
59 urgent, 60. Anita H.
This case, my lord, last earlier bench, my lord, was directed to appear before the court, my lord. Party,
Feasibility of amicable settlement.
there is no settlement, my lord.
Other side are
Appellant,
SV Prakash.
ನಮ್ಮವರಿಗೇನೋ ಸ್ವಲ್ಪ ಈ ವಾರದಲ್ಲಿ ಆಗಲ್ಲ, ನೆಕ್ಸ್ಟ್ ವೀಕಲ್ಲಿ ಬರ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಏನೇನಿದೆ?
ಇವ್ರಿಗೆ ಎಲ್ಲಿಂದ ಬಂದಿದ್ದಾರೆ?
Bangalore.
ಬೆಂಗಳೂರೇನಾ?
Bangalore.
ನಮ್ಮವ್ರು ಶಿವಮೊಗ್ಗದಲ್ಲಿದ್ದಾರೆ ಅವರು. 29th or 30ಗೆ ಬರ್ತೀವಿ.
ಇದೇನ್ ಪಾರ್ಟ್ರೆಡ್ ಮ್ಯಾಟರ್ ಮೇಡಮ್?
ಸೆಟ್ಲ್ಮೆಂಟ್ಗೆ ಅಂತ.
ಸೆಟ್ಲ್ಮೆಂಟ್. Appellant time period.
Actually, it was completely heard, my lord, about to pass the order. After that, my lord, the respondent counsel seeks time to settle the matter, my lord. But from the appellant side, my lord, there is no settlement, my lords. Ready to argue the matter, my lord. And last 13th, my lord, the respondent counsel.
Parties are directed to be present on the set date.
Yes, my lord.
To find out the feasibility of amicable settlement, if any, at request of both relist on 15/10/25 anta ide.
Please, my lord. But there is no settlement from the appellant side, my lords. Appellant daughter is present before the court, my lord.
Daughter ಹೆಂಗ್ ಬರಕಾಗುತ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ ಮೇಡಮ್?
She is bedridden, my lord. She can't walk.
ಏನ್ ಕೇಸ್ ಏನು? What is this case?
That is, my lord, the appellant is the owner of the site, my lord. Along with there is a site, my lord. In that site, the respondent has put up construction, my lord, and he is unauthorizedly residing, my lord. Suit has been decreed, my lord. Against that order, the respondent filed the appeal, my lord. In the appeal, my lord, reversed, my lord. On the ground, my lord, the appellant has not released any document to saying that she is the wife of one Nagaraj, my lord. And that is my against that order I filed the appeal, my lords.
My lord, I am for the my lord, I am for the respondent.
Yes.
Party will be present after Deepavali, my lord. ನಿನ್ನೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ದಾನೆ.
Your party is not present when the matter was urgent with a direction to be present before the court.
ಹೌದಾ, ಅವತ್ತು ಬರ್ಲಿಲ್ಲ my lord. ನಿನ್ನೆ ಫೋನ್ ಮಾಡಿದ್ದೆ, ಅವನು ಹುಷಾರಿಲ್ಲ ಅಂತೆ, ಅದಕ್ಕೆ.
ಅವತ್ತಲ್ರಿ, ಇವತ್ತಿಗಿರೋದು ಡೈರೆಕ್ಷನ್.
ಅಲ್ಲಿ ಇವತ್ತು ಬರ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ
ಹುಷಾರಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಅದಕ್ಕೆ
ಅದೇ ಏನೊಂದ ರೀಸನ್
ಅದು ಟು ರಿಪೋರ್ಟ್ ದಿ ಸೆಟಲ್ಮೆಂಟ್ ಮೇಲೆ ಅದಕ್ಕೆ 29th or 30th
directed to be present on this to find out the feasibility of amicable settlement if any ಅಂತ ಬರ್ದವ್ರೆ ಆರ್ಡರ್ ನಲ್ಲಿ.
ಹೌದು ಮೇಲೆ.
Why your party is not present ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
ಹುಷಾರಿಲ್ಲ ಅಂತೆ ಅವನಿಗೆ, ಹಾಗಾಗಿ he could not travel today.
ಮೇಡಮ್ ಒಂದೊಂದ್ಸರಿ ವಾಯ್ಸ್ ಬರೋದಿಲ್ಲ, ಒಂದೊಂದ್ಸರಿ ವಾಯ್ಸ್ ಬರುತ್ತೆ, ಏನ್ ಪ್ರಾಬ್ಲಮ್? ಏನ್ ಮಾಡ್ತಾರೆ ನಮ್ ಕಂಪ್ಯೂಟರ್ ಬ್ರಾಂಚ್ನವರು? ಮತ್ತೆಲ್ಲ ಪೇಪರ್ಲೆಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಓಡಾಡ್ತಾರ. ವಿಸಿನೇ ನೆಟ್ಗಿರಲ್ಲ.
ಕೈಲಿ 29th or 30th ಮೇಲೆ
ಏನ್ ಮಾಡ್ತಾರ ಕಂಪ್ಯೂಟರ್ ಬ್ರಾಂಚ್ನವ್ರು? ಮತ್ತೆ ನೆನೆನೂ ಇದೇ ಪ್ರಾಬ್ಲಮ್. ಪೇಪರ್ಲೆಸ್ ಹೋಗಿ ವಿಸಿನೇ ನೆಟ್ಗಿರಲ್ಲ, ಇನ್ ಪೇಪರ್ಲೆಸ್ ಏನ್ ಮಾಡೋದು? ಪೇಪರ್ಲೆಸ್ ಕೋರ್ಟ್ ಯಾವತ್ ಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತೀರ ಹೇಳಿ?
29th or 30th ಮೇಲೆ
ನೋಡಿ ಹೋಯ್ತು. ಮಾತಾಡಿ 2 ನಿಮಿಷದ ಮೇಲೆ ವಾಯ್ಸ್ ಕೇಳುತ್ತೆ. 25th
ಅಲ್ಲ 29th.
ನೋಡಿ, appellant counsel submits that there is no any element of settlement ನಿಮ್ ಪ್ರಕಾರ. ಅಲ್ಲಿವರೆಗೂ ಕೊಡೋದಿಲ್ಲ ಡೇಟು. 25ಕ್ಕೆ ಇಟ್ಟಿರ್ತೀನಿ, ಕರ್ಸಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಅವತ್ತು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ಅದರ್ ಸೈಡ್ ಮೇಕಿಂಗ್ ಸಬ್ಮಿಷನ್ ದಟ್ ನೋ ಸೆಟಲ್ಮೆಂಟ್ ಅಟ್ ಆಲ್.
29th ಮೇಲೆ
I'm ready to argue the matter.
29th either of the way.
Today itself is ready to argue.
29th either of the way, either
25th
settlement or argument.
ನೋಡಿ and element of settlement and counsel for the respondent submits that could not able to keep the respondent present before the court and seeks time and hence list this matter on 25.
My lord,
If
29th my lord.
respondent counsel fails to keep the respondent before the court, argue the matter on merits. That's all.
On 29th, my lord.
No 29th, 25th only.
Passed on matter seal number 2. GS Balkangadar.
ಏನಕ್ಕೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು ಇದು?
2.1 ನಲ್ಲಿ application
Postal Shara.
Please. 2.1 ನಲ್ಲಿ minor. Delete the
ಏನೋ
item.
ಕನೆಕ್ಟೆಡ್ ಅಲ್ಲಿ ಏನೋ ಮಾಡಿಲ್ಲ ಅಂತ.
I number 2 ಅದನ್ನ withdraw ಮಾಡಿದೀನಿ ನಾವೇನೆ.
Non deletion the schedule in I number 2 of 21 as per order dated 21/7 ಮಾಡಿದ್ರೆ ಈಗ amendment
I ಏನ withdraw ಮಾಡಿದೀನಿ ನಾನು. 2/8/2023 ನಲ್ಲಿ withdraw ಮಾಡಿದೀನಿ ಸರ್.
Once already there was an order, how can you withdraw that?
ಆ ಟೈಮ್ ಕೊರೋನಾ ಟೈಮಲ್ಲಿ ಪಾರ್ಟಿ ಬಂದಿರಲಿಲ್ಲ, ಆಗ withdraw ಮಾಡಿ ಫ್ರೆಶ್ ಲಿಬರ್ಟಿ ತಗೊಂಡಿದ್ದೀನಿ.
Learned counsel for appellant seeks permission of this court to delete schedule A number 2 of 21. He is permitted to delete the schedule ಅಂತ ಮಾಡಿದ್ರು. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಏನಾಗಿತ್ತು ಮೇಡಮ್?
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಸ್ ಬಂದಿತ್ತು ಸರ್.
ಮತ್ತೆ ಇನ್ನೊಂದು ಮೇಲೆ ಆರ್ಡರ್ ಡಿಲೀಷನ್ ಆದ್ಮೇಲೆ
2/8 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ ಸರ್. ನಾನು withdraw ಮಾಡಿದ್ದೆ ಏನ 2/8/23 ನಲ್ಲಿ.
ಅದಂಗ್ರೆ ಆಗ್ತದೆ. ಒಂದ್ಸರಿ there was an order, ಡಿಲೀಷನ್ ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಆಗಿದೆ, ಮತ್ತೆ ಹೆಂಗ್ ವಿಡ್ರಾ ಮಾಡ್ತೀರಿ?
withdraw ಮಾಡಿ ಲಿಬರ್ಟಿ
seeks permission of this court to withdraw A number 2 of 21 in RSA number 21 and permitted to withdraw. ನೀವು ಈ ಕೋರ್ಟಿಗೆ ಗಮನಕ್ಕೆ ತಂದೆ ಅಲ್ಲ ಈ ಆರ್ಡರ್ ನ ವಿಡ್ರಾ ಮಾಡ್ಕೋಬೇಕಾರೆ ಅರ್ಲಿಯರ್ ಅಲೋ ಆಗಿದೆ ಅಂತ, ಹೌದಾ?
ಕೊರೋನಾ ಟೈಮಲ್ಲಿ
ಕೊರೋನಾ ಏನಿಲ್ಲ ರೀ 23 ಅಲ್ಲಿ ಏನ್ ಕೊರೋನಾ ಇರ್ತದೆ 23 ಅಲ್ಲಿ
21/7 ನಲ್ಲಿ.
Secure the records of trial court and also the first appellate court in both these appeals. ಅಯ್ಯ ಆಲ್ರೆಡಿ ಅಲೋ ಆದ್ಮೇಲೆ permitted to delete, ಅಯ್ಯ permission of the court to delete schedule A number 2 of 21 permitted to delete, ಅಯ್ಯ ಅಲೋ ಆಗ್ಬಿಟ್ಟಿದೆ, ಪರ್ಮಿಟ್ ಮಾಡಿ ಡಿಲೀಟ್ ಮಾಡಿ ಮತ್ತೆ ಅದೇ ಏನ್ ಹೆಂಗ್ ಮತ್ತೆ ವಿಡ್ರಾ ಮಾಡ್ತೀರಿ? ಡಿಲೀಟ್ ಮಾಡಿ ಅದಷ್ಟೇ ಆರ್ಡರ್ನ. ಮತ್ತೆ ನಾನ್ ಡಿಲೀಷನ್ ಆಫ್ ದಿ ಶೆಡ್ಯೂಲ್ 2 of 21 ಇದೆಯಲ್ಲ, ಡಿಲೀಟ್ ಮಾಡ್ಕೋಬೇಕಷ್ಟೇ.
ಪ್ಲೀಸ್ ಮೇಡಮ್, ಐ ಆಲ್ರೆಡಿ withdraw ಮಾಡಿದೀನಿ, ನನ್ನ ನೆಸೆಸರಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ತೀನಿ ಸರ್.
ಅಯ್ಯ ಅಲೋ ಆಗಿ you are been permitted to delete, ಹೌದಲ್ಲ? Then how can once again you file an application and withdraw the IA number 2 of 21? That IA was already considered and order was passed. How can now you withdraw that order? ಎಲ್ಲ ಯಾರು ಕೆಲಸ ಮಾಡ್ತೀರಿ? ಕೋರ್ಟ್ ಗಮನಕ್ಕೂ ತರೋದಿಲ್ಲ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಐ ಎ ಮೇಲೆ ಅಂತ. ನಾವು ನೀವೇನೋ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀರಿ, ಅಲೋ ಮಾಡ್ತೀವಿ. ಈಗ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ?
ಅಲ್ಲ ನಾನು ಅದು ಶೆಡ್ಯೂಲ್ ಡಿಲೀಟ್ ಮಾಡ್ತೀನಿ ಸರ್. ಆಯ್ತು
ಮಾಡ್ತೀರಾ? ತೊಗೊಳ್ಳಿ. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ seeks 1 week time to delete the schedule in terms of IA number 2 of 21. And answer 1 week time granted. List this matter on 1 week ಆದ್ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್. 25/10.
Seal number 12.
Hearing interlocutory application. ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಅದು?
Recalling.
ಹಾ, ಅವ್ರು ಬರ್ತಾನೆ ಇಲ್ವೇನ್ರಿ ಈಗ?
ಬರ್ತಾ ಇಲ್ಲ ಅವರು. They filed one complaint before the bar council.
ಯಾರು?
The party. Appellant. ಅದ್ರಲ್ಲಿ signatures lordship can compare.
ಮೇಲೆ ತೊಗೊಳ್ಳಿ. This matter is called twice. And counsel for the ಇದ್ರ ರೆಸ್ಪಾಂಡೆಂಟ್ ನೀವು ಇದೀರಾ ಇದ್ರಲ್ಲಿ? ನಿಮ್ಮ ಹೆಸರು?
I am not for respondent. ಮುಂಚೆ petitioner ಗಿದ್ದೆ.
ಮುಂಚಿನ ಅಡ್ವೊಕೇಟಾ ನೀವು?
ಹೌದು.
ಶಶಿಕುಮಾರ್.
ಹೌದು.
ತೊಗೊಳ್ಳಿ. And counsel earlier advocate R. Shashikumar is present before the court in both the occasion, in the early morning and also in the afternoon. But the present advocate PM Narayana Swami is absent in the early morning and also in the afternoon. And concerned and also the appellant is absent before the court. However, one more opportunity is given to the appellant and also the present counsel to submit argument on IA number 2 of 24 and assist the court in view of the subsequent development. And list this matter on ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಅದು ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಆರ್ಡರ್ಸ್. 29/10.
Okay. 29. Till number 29.
Here for the appellate.
ಹೇಳಿ.
A week's time may be granted, Swami.
ಕೌನ್ಸಿಲ್ ಬೆಳಗಿನ ಹೇಳಿದ್ದೀನಿ, ಹೇಳಿ. ಡಿಸ್ಮಿಸ್ ಟು ಕನ್ಫರ್ಮ್ಡ್. ಓದ್ಕೊಂಡು ನೀವೇ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ ಅಂತ ಹೇಳಿದ್ದ ಅವರಿಗೆ.
ಸರಿ.
ನಿಮ್ಮನ್ನ ಕರ್ಕೊಂಡ್ಬಂದು ನಿಲ್ಸಿದಾರೆ, ಹೇಳಿ.
ಇದರಲ್ಲಿ appreciate this is the suit of 2004, my lord.
ಹೌದು.
Suit was filed on 8/12/2004. That is much earlier to the Amendment Act of 2004, my lord, that is Central Act.
ಹೌದು.
So as on the date of initiation of the suit, my lord, the law prevailing was, my lord, State Amendment Act 1990. Therefore, my lord, that act is if the act is applicable, my lord, she is entitled for share, my lord. ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಸೈಟೇಷನ್ಸ್ ಎಲ್ಲ ಕೊಡ್ತೀನಿ.
ಅದು ಅಪ್ಲೈ ಮಾಡ್ಕೊಳ್ಳೋಕ್ಕಿಂತ ಮುಂಚೆ ನಿಮ್ಮ ಇಶ್ಯೂ ನಂಬರ್ 1 ನೀವು ಪ್ರೂವ್ ಮಾಡಿದ್ದೀರಾ? Plaintiff proved that suit shall properties are the joint family properties of plaintiff and defendants. That was answered as negative. ಹೌದಾ?
Actually, that is not correct, my lord. That is ancestral property.
Not correct.
Ancestral property, sir. Father has acquired the ancestral property, and during his lifetime, it has been sold, and she is not a party to the sale deed, my lord.
ಯಾರು?
This plaintiff, there is not the party to the supplier.
Who acquired the property?
Father. It is an ancestral property. Father has acquired the property, my lord, through his law of inheritance, my lord.
ಹೇಗೆ?
ಹೌದು, ಪಾರ್ಟಿಷನ್ ಅಲ್ಲೇ ಬಂದಿದೆ ಅಂತಾನೆ. ದಟ್ ಇಸ್ ದ ಕೇಸ್.
ಯಾರಿಗೆ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಬಂದಿದೆ?
ಹೌದು ಸರ್.
ಯಾರಿಗೆ ಪಾರ್ಟಿಷನ್?
ಫಾದರ್ಗೆ, ಪುಟ್ಟಬಸಪ್ಪ.
ಫಾದರ್ಗೆ.
ಹೌದು ಸರ್.
ಬರೀ ಪಾರ್ಟಿಷನ್ ಅಲ್ಲಿ ಬಂದ್ರೆ ಆಗೋದಿಲ್ಲ. To show that it is an ancestral property. Otherwise, it becomes a separate property. Who had sold the property?
Puttbasappa himself.
Father himself had sold.
Father and brothers.
ಮತ್ತೆ? And also sale was made in the year 93.
Yes, madam.
ಮತ್ತೆ ನೀವು ನಿಮ್ಮ ಅಮೆಂಡ್ಮೆಂಟ್ ಇರೋದು 94 ನಿಮ್ಮ ಪ್ರಕಾರ, ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್.
Yes, madam.
And then how the suit is maintainable?
Within 12, she is married during 93, my lord. She started to
ಮದುವೆ ಮಾಡಕ್ಕೆ ಅಂತಲೇ ಮಾರಾಟ ಮಾಡಿರ್ತಾರೆ ಪ್ರಾಪರ್ಟಿನ.
ಒಂದು ವರ್ಷ ಮುಂಚೆಗೆ
ಸೇಲ್ ಡೀಡ್ ಮಾರಾಟ ಮಾಡ್ಕೊಟ್ಬಿಟ್ಟು ನಿಮ್ಮ ಅಪ್ಪ ನಿಮ್ಮ ಅಣ್ಣದಿರು ಸೇಲ್ ಡೀಡ್ ಮಾಡ್ಕೊಟ್ಟವ್ರೆ 93 ನಲ್ಲಿ, ಮದುವೆ ಮಾಡವ್ರೆ. ಈಗ ನೀವು ಅದೇ ಪ್ರಾಪರ್ಟಿ ಮೇಲೆ ಮತ್ತೆ ನಂಗೆ ರೈಟ್ ಬೇಕು ಅಂತ.
ಇಲ್ಲ ಸರ್.
ಏನ್ರಿ ಇದು?
ಒಂದು ವಾರ ಟೈಮ್ ಕೊಡಿ.
ಏನ್ ವಾರ ಟೈಮ್ ಕೊಡ್ಬೇಕು ಹೇಳಿ?
ಪ್ರಿಪೋಸಿಷನ್ ಬಗ್ಗೆ
ಏನು ಇಲ್ಲ.
ತಂದು ಕೊಡ್ತೀನಿ.
ಕೇಸಲ್ಲಿ ಏನು ಇಲ್ಲ.
ಇಲ್ಲ, ಅದಕ್ಕೆ
ಈಗ ನಾವು ಯು ಆರ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ದಟ್ ಪ್ರಾಪರ್ಟಿ ಅಮೆಂಡ್ಮೆಂಟ್ ವಾಸ್ ಮೇಡ್ ಇನ್ ದ ಇಯರ್ 94.
ಎಸ್ ಮೇಡಮ್.
94 ಅಷ್ಟೊತ್ತಿಗೆ ಆಕೆಯ ಮದುವೆನೂ ಆಗೋಗಿದೆ.
90 ಅಲ್ಲ, ಪ್ರಪೋಸಲ್ ವಾಸ್ ಮೇಡ್ ಡ್ಯೂರಿಂಗ್ 1990. 1990 Karnataka Amendment Act, but it is came into force during 94.
ನೋಡ್ರಿ,
ಅಲ್ಲ 94 ಅಲ್ಲೇ ಬಂದಿರ.
Maybe it was 1990 proposal.
Yes, madam.
Came into effect only on 39.
Yes,
1994.
ಇಲ್ಲ ಅಂತ ಹೇಳದ ಸರ್. I am not
why you are making such submission before the court?
ಅದಕ್ಕೆ ಒಂದು ವಾರ
ಕೇಸಲ್ಲಿ
ಅಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು 10 days ಟೈಮ್ ಕೊಡಿ ಸರ್.
2004 ಪಾರ್ಟಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2004 ರಿಂದ 25ರವರೆಗೂ ಪಾರ್ಟಿನ ನಿಮ್ ಜೊತೆ ಇಟ್ಕೊಂಡಿದ್ದೀರಿ. ಹಾ,
10 days.
ಮತ್ತೆ ಕರಿಯ ಹಸು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ.
Interim order was granted.
Some reason. You are an officer of the court. How can
it is true
they get the right? ಯಾಕೆ ಮದುವೆ ಮಾಡಕ್ಕೆ ಅಪ್ಪನೂ ಅಣ್ಣ ತಮ್ಮದಿರು ಸೇರ್ಕೊಂಡು ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿ ಮದುವೆ ಮಾಡಿದ್ರು. ಈಗ ಮದುವೆ ಆದ್ಮೇಲೆ 93 ಮದುವೆ ಆದ್ಮೇಲೆ ನಂಗೆ ರೈಟ್ ಇದೆ 94 ಮಾಡೋರೆ ಅಂತ ಹೆಂಗ್ ಬರುತ್ತೆ ರೈಟ್? ಆಲ್ರೆಡಿ ಶಿ ವಾಸ್ ಮ್ಯಾರಿಡ್, ಪ್ರಾಪರ್ಟಿ ವಾಸ್ ಸೋಲ್ಡ್. ಇವ್ನು ಕೊಂಡ್ಕೊಂಡ ಮೇಲೆ ಸವಾರಿ 2004 ರಿಂದ 21 ವರ್ಷದಿಂದ ಸವಾರಿ ನಿಮ್ದು. ಹೇಳಿ, ಎಷ್ಟು ಹಾಕಿ ಕಾಸ್ಟ್ ಹಾಕಿ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು?
ಅಲ್ಲ, ಒಂದು 10 days ಟೈಮ್.
ನೋ ಟೈಮ್.
ಅದೆಲ್ಲ ಸೈಟೇಷನ್ಸ್ ಎಲ್ಲ ತಂದು ಕೊಡ್ತೀನಿ.
ನಥಿಂಗ್. ತೊಗೊಳ್ಳಿ
ದಯವಿಟ್ಟು ಸರ್. ಪ್ರಾರಂಭ ಕೈಂಡ್ಲಿ ಒಂದು 10 days ಟೈಮ್ ಕೊಡಿ ಸರ್.
ಕೇಳಿದ್ದು ಕರಿಯಾಸು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಿ ಅಂತ. ಬರೀ ಕೋರ್ಟ್ ಒಂದು ದಾಳ ಮಾಡ್ಕೊಂಡು ಇಂಥದೇ ಮಾಡೋದು ಬರೀ. You should advise the client properly. When the client comes to you, 7 ಲ್ಯಾಂಪ್ಸ್ ಆಫ್ ಅಡ್ವೊಕೇಸಿನಲ್ಲಿ ಒಂದಿದೆ ಗೊತ್ತಾ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ ಅದನ್ನ ನೀವು ಹೇಳ್ಬೇಕು ಪಾರ್ಟಿಗೆ. CL lead 93, challenge in the year 2004.
House.
Majority in the year 1993, during which her father has sold the property of different number 3. If she has not attained the majority on the date of sale transaction, then she ought to have filed the suit within 3 years. Detailed order was passed.
But the date of knowledge also, my lord. I will convince this lordship, my lord.
Even marriage was also on 21/6/1994.
House.
ಮತ್ತೆ ಎಲ್ಲ prior to the even amendment also.
ಅಲ್ಲ ಇಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಓನ್ಲಿ ಅಪ್ಲೈಯಿಂಗ್ ದಿ ಪುಲವತಿ ಕೇಸ್ ಮೆಲಾಡ್ ಮಚರ್ಲಿ
ಎಲ್ಲ ಓದುವ ಈಗ
ಅಲ್ಲ ಅದನ್ನ ಮಾಡಿ ಇಟ್ ವಾಸ್ ಡಿಸ್ಮಿಸ್ ಮೆಲಾಡ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ಮೆಲಾಡ್ ಈವನ್ ಫಸ್ಟ್ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಆ ಇಶ್ಯೂ ಇರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಮ್ಯಾರೇಜ್ ಬಗ್ಗೆ ದೇರ್ ವಾಸ್ ನೋ ಇಶ್ಯೂ ಬಿಫೋರ್ ದಿ ಫಸ್ಟ್ ಕೋರ್ಟ್ ಮೆಲಾಡ್ ದಟ್ ಈಸ್ ಇನ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅದನ್ನ ಇದು ಮಾಡಿದ್ದಾರೆ ನಾನು ಐ ವಿಲ್ ಪ್ಲೇಸ್ ದಿ ಜಡ್ಜ್ಮೆಂಟ್
ಅದಕ್ಕೂ ಬರ್ದಿದ್ದಾರೆ ನೋಡಿ ನೀವು ಈಗೇನ ಹೇಳಕ್ ಕೊಡ್ರಲ್ಲ ಪ್ಯಾರಾ 27 ಅಲ್ಲಿ not entitled to claim any share in the suit property which are already sold on 15/12 in view of the proviso clause of section 6 of the Hindu Succession Act. As per said proviso, any disposition or alienation including any partition or testamentary disposition of property which are taken place 12 will not be invalidated. ಇಂಥ ಕೇಸ್ಗಳೆಲ್ಲ ತಗೋಬರ್ತೀರಿ ಪಾರ್ಟಿಗಳಿಗೆ ಸುಮ್ಮನೆ ತೊಡ್ This matter is listed for admission.
10 days time ಕೊಡಿ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು.
ಟೈಮ್ ಕೊಡೋದಿಲ್ಲ ಏನಿಲ್ಲ ನಾನು ಓದಿದ್ದೀನಿ ಅದಕ್ಕೆ ನಾನು
ಅಲ್ಲ ಸ್ವಾಮಿ ದಯವಿಟ್ಟು ಅಲ್ಲ ಒಂದು 10 days ಕೊಡಿ ಸ್ವಾಮಿ ಅದಕ್ಕೆ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಲಾ ಬಗ್ಗೆ ಒಂದು ಸ್ವಲ್ಪ
ಯಾವ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಲಾನು ಇಲ್ಲ ರೀ ಇಟ್ ಇಸ್ ಅಪರೆಂಟ್ ಆನ್ ರೆಕಾರ್ಡ್
ದಯವಿಟ್ಟು ಅಲ್ಲ ಒಂದು 10 days ಕೊಡಿ ಸ್ವಾಮಿ
is listed for admission and I heard the appellant counsel.
ಅಲ್ಲ ಒಂದು 10 days ಕೊಡಿ ಸ್ವಾಮಿ.
This second appeal is filed against the concurrent finding of the trial court and appellate court. The suit is filed by the daughter against brothers mela
brothers after the death of father.
Suit is filed against the brothers seeking the relief of partition, declaration and permanent injunction, contending that suitable property is the joint family properties of the plaintiff and defendant, and sale deed dated 15/12/1993 executed by the father and brothers in favor of ಯಾರ ಪರವಾಗಿ ಬರ್ದಿ ಬರ್ಕೊಟ್ಟಿರೋದು
ಅದು ಇನ್ ಫೇವರ್ ಆಫ್ D3 ಸ್ವಾಮಿ ಪ್ರೆಸ್ಟೀಜ್
defendant number 3
ಪ್ರೆಸ್ಟೀಜ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್
is not binding on her share. Our D3 contest
ಮಾಡಿದಾರೆ sir. He is only contested.
Number 3 appeared and contested the matter, filing the written statement, and the trial court having considered the evidence of PW1 answered all the issues as negative and dismissed the suit. And also taken note of the fact that the property was sold in the year 93 itself and her marriage was solemnized in the year 1994. And the same is also even prior to the Karnataka amendment and subsequent amendment also made in 2004. The suit was filed in the year 2004, and at the time of even selling the property, she was attained majority and not filed the suit within 3 years from the date of sale of the property. and also attaining the majority and dismiss the same. Being agreed by the same, an appeal is filed RA number 163 of 2018 and the appellate court, considering the grounds urged in the appeal memo, framed the point for consideration whether the trial court is justified in holding that sale deed dated 15/12/1993 executed in favor of defendant number 3 is binding on the plaintiff and whether it requires interference of this court. And hence the trial court comes to appellate court also having reassessed both oral and documentary evidence available on record, particularly taken note of exhibit B1, the marriage invitation card which discloses that her marriage was performed on 21/6/1994. And also taken note of exhibit P3 and P4 are the RTC extracts relating to suit item number 1 and 2, which discloses that name of Putta Siddhappa is shown as owner occupier of these properties for the year 1993-94. The subsequent entries are in the RTC extract have been converted into non-agriculture purpose. And so also taken note of, if the father of the plaintiff has sold the ancestral joint family properties against the interest of the plaintiff, then she has to challenge the sale deed within 3 years as per Article 59 of the Limitation Act. The plaintiff has filed the suit in the year 2004 by showing her age as 29 years, which discloses that she was born in the year 1975 itself, and thereby she was major, and she has attained the majority in the year 1993 itself, during which her father has sold the properties to defendant number 3. If she has not attained the age of majority on the date of sale of transaction, then she ought to have challenged the alienation made through exhibit P8 to exhibit P16 documents within 3 years from the date of attaining majority as per Article 60 within bracket A of the Limitation Act. The plaintiff has instituted the suit in the year 2004 showing her age. Next para. The exhibit D 11 to 13 are the sale deeds executed by defendant number 3 in favor of subsequent purchasers effected in the year 2001 and 2003, and taken note of even subsequent to the sale made in favor of D3, and D3 also in turn sold the property prior to the filing of the suit, and properties are also exchanged between some of the persons, and the same also not remained as an agriculture land and converted for the non-agriculture lands. And these are the aspects were also taken note of. And also sale was made in the year 93, and even counsel appearing to the appellant would contend that amendment was brought in the year 1984 in respect of the unmarried daughters is concerned, they would get the right. But in the case on hand, even she was married prior to the said amendment also. And when such being the case, both the trial court as well as the appellate court taken note of the material available on record and reason also assigned, and the very contention of the appellant counsel that both the courts have committed an error in not considering the material available on record and not justified in holding that appellant is not entitled for share, though the living daughter of a living co-partner is entitled for a share in the social property, and the said theory cannot be accepted, and transaction was taken place in the year 1993 itself, and question of daughter become the co-partner also doesn't arise, and hence I do not find any ground to admit and frame any substantive question of law considering the factual aspects of the case, and hence no merit. You have the discussions made up, I pass the following order. Second appeal is dismissed.
Oblige.
7. KV Narasimhan, Prasanna VR, 37.
ಏನು ಬೆಳಗಲಿರಲಿಲ್ಲ ಅವರು ನೋಡಿ. This matter is called twice, in the early morning and also in the afternoon, and no representation by the appellant counsel, and counsel for the respondent present in both the occasion, and hence if appellant counsel doesn't appear in the next date of hearing, appeal will be dismissed. List this matter on 29/10.
38. Kalimullah Sharif.
Short pass over, senior is engaged in another court, madam. Can you short pass over?
ಬೆಳಗ್ಗೆ ಫೈಲ್ ಇಲ್ಲ, ಫೈಲ್ ತರ್ತೀನಿ.
ಇನ್ನೊಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ madam.
ಹಾ, ಮತ್ತೆ ಪಾಸ್ ಓವರ್ ಆಯ್ತು.
ಸಂತೋಷ್ ಆರ್ ನೆಲ್ಕುದ್ರಿ.
ನೋ ಟೈಮ್ ಹೇಳಿ. 21 ಮ್ಯಾಟರ್ ಹೇಳಿ.
My lord,
ಹಾ,
may I make one humble request?
ಹೇಳಿ ಏನು?
My wife is to be taken to the hospital for knee operation, and I want an appointment. Kindly give some upon this personal thing, my lord. Knee operation is to be suggested, that is why.
ರೋಗಿ ಬಯಸಿದ್ದು ಹಾಲು ಅನ್ನ, ವೈದ್ಯ ಹೇಳಿದ್ದು ಹಾಲು ಅನ್ನ.
ಬೇಕಾದ್ರೆ ನಾಡದ್ದು ಹಾಕಿದ್ರೆ
ಬೇಕಾದ್ರೆ ನಂಗೆ ಬೇಕಾಗಿಲ್ಲ, ನಿಮಗೆ
ನಾನು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ನಲ್ಲಿ ಆ ಡೇಟ್
ಏನ್ ಸಬ್ಮಿಷನ್ಸ್ ಮಾಡ್ತೀರಿ ಅಡ್ವೊಕೇಟ್ಸ್? ಈ ಬೇಕಾದ್ರೆ ನಾವು ವರ್ಡನ್ನ ನಿಮ್ಮ ಇದರಿಂದ ತೆಗೆದಾಕ್ಬಿಡ್ಬೇಕು.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿದ್ರೆ
ಬೇಕಾಗಿರೋದು ನಮ್ಗಲ್ಲ, ನಿಮಗ್ ಬೇಕಾಗಿರೋದು. ನೀವು ಬಂದಿರೋದು ಕೋರ್ಟ್ಗೆ.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿದ್ರು
ತೋಳಿ ಅಪಲೆಂಟ್ ಏನಕ್ಕೆ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದೀರಿ ನೀವು?
ಸ್ವಲ್ಪ ಪ್ರಿಪರೇಷನ್ಸ್ ಅಂದ್ರೆ ದಿಸ್ ಇಸ್ ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ಸ್ ಆನ್ ಸೂಟ್ ಫಾರ್ ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಡಿಕ್ರೀಡ್ ಕನ್ಫರ್ಮ್ಸ್ ಆನ್ substantial question of in respect of that plaintiff has not performed his part.
Appellant counsel seeks time on the ground that not fully prepared, and counsel for the respondent seeks time on the ground that he has to take his wife to the hospital for surgery, and hence list this matter. ಎಷ್ಟು ದಿವಸ ಬೇಕು? 2 ವಾರ ಬಿಟ್ಟು ಕೊಡ್ಲಾ? ಸರ್ಜರಿ ಎಲ್ಲ ಮಾಡಿಸ್ಕೊಂಡು ಬನ್ನಿ.
First week of
ಆಯ್ತು ಕೊಡ್ರಿ. 4/11
47
ಎಂಟ್ರಿ ಮಾಡಿ
4ನೇ ತಾರೀಕು 4/11
ಎಂಟ್ರಿ ಮಾಡ್ರಿ.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರು?
ಅದು ಎಕ್ಸಿಕ್ಯೂಟಿಬಲ್ ಡಿಕ್ರೇಷನ್
ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ನೋ ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಆರ್ಡರ್. ಎಂಟ್ರಿ ಮಾಡ್ರ್ ವಿಲ್ ನಾಟ್ ಬಿ ಎಕ್ಸ್ಟೆಂಡೆಡ್.
ನಾನು ಬೇಕಾದ್ರೆ ಮಾಡ್ಸ್, ಅವ್ರಿಗೆ ಏನೋ ಪರ್ಸನಲ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಳಿದ್ರು.
ಎಂಟ್ರಿ ಮಾಡ್ರ್ ಗ್ರಾಂಟೆಡ್ ಅರ್ಲಿಯರ್ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಹೇಳಿ.
47
ಔಟ್ ಅಕೊಮಡೇಷನ್ ಮೈ ಲಾರ್ಡ್.
ನೋ ಕೌನ್ಸಿಲ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದ್ದಾಗೆಲ್ಲ ಡೇಟ್ಸ್ ಇಲ್ಲ.
ಅದರ್ ಸೈಡ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ.
ಯಾರಿಗೆ?
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ ಮೈ ಲಾರ್ಡ್. 2 weeks
ಏನು ಕೇಳ್ರಿ? ರೀಸನ್ ಏನು ಹೇಳಿ?
ಸೀನಿಯರ್ ಇಸ್ ನಾಟ್ ದೇರ್ ಮೈ ಲಾರ್ಡ್.
ಸೀನಿಯರ್
ಇಸ್ ನಾಟ್ ದೇರ್.
ನಾಟ್
ದೇರ್.
ನಾಟ್ ದೇರ್.
He's
that is not a ground.
ಮೈ ಲಾರ್ಡ್ ಫ್ಯಾಮಿಲಿ ಎಮರ್ಜೆನ್ಸಿ ಸ್ವಲ್ಪ ಮಾರ್ನಿಂಗ್ ಬೇಗ ಹೋಗಿ.
ಏನು ಫ್ಯಾಮಿಲಿ ಎಮರ್ಜೆನ್ಸಿ? ನೀವು ಅಪಲೆಂಟ್ ಗಾ?
ನಾವು ಅಪಲೆಂಟ್.
ಹಾ,
ಮಾರ್ನಿಂಗ್ ಇವ್ರಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀವಿ.
whether in light of section 2E Air Prevention and Control of Pollution Act 1991 deals with damages caused by vibrations, whether bar under section 46 of the Air Prevention suit instituted against neighbor for an injunction against causing vibrations and noise pollution.
Lords, this whole dispute is within a very narrow compass. What has happened, Lords, is this: I filed a suit for injunction, saying that my neighbor, who is also Lords another industry, he is causing sound and vibration because of which my buildings are breaking up. So I filed this injunction suit. There was a 7 Rule 11 application that came to be filed, saying under 46 of the Air Pollution Prevention Act, there is a bar to the jurisdiction of the civil court. Both the trial court as well as Lords the first appellate court, on examining 46, held Lords that bar exists, and Lords the suit and allowed the application under 7 Rule 11. Now it's my contention before my lords that as far as 46 is concerned, the very language of 46, my lords, is such that it does not bar, my lords, my suit. What it bars is, my lords, actions which the Pollution Control Board takes. If I have to challenge that, I can't file a suit. I have to go either before the appellate authority or I have to come before this honorable court. But the bar is that. Not, my lords, a bar to a
bar is against the pollution control authority ಅಂತ ನಿಮ್ಮ
our order implement ಮಾಡೋದು ಅಥವಾ our order challenge ಮಾಡೋದಕ್ಕೆ ಮಾತ್ರ ಬಾರ್ ಇರೋದು. Now I have, my lords, not challenged their order. I have, my lords, simply said, look, this person is causing this inconvenience, therefore injunct him. So that, my lords, is the sum and substance. In fact,
third question
may be taken next week.
ಕಾಸ್ಟ್ ಆಗ್ತೀನಿ ಮತ್ತೆ ಏನ್ ಮಾಡ್ಬೇಕು ಕೇಳಿ. ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಈಗ ಬಂದಾಗೆಲ್ಲ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ರಿ ನೀವು.
ಮಾರ್ನಿಂಗ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀವಿ. ಮಾರ್ನಿಂಗ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದೀವಿ.
ಮಾರ್ನಿಂಗ್ ಮೆನ್ಷನ್ ಮಾಡಿರ್ಬೋದು. ನಿಮ್ಗೆ ಸೀನಿಯರ್ ಇಸ್ ನಾಟ್ ದೇರ್ ಅಂತ ನಿಮ್ಮ ದಟ್ ಕೆನಾಟ್ ಬಿ ಎ ಗ್ರೌಂಡ್.
It may be taken next week.
Totally, respondent counsel seeks time on the ground that senior counsel is not in station. ಹೌದಾ? ಇಲ್ವಾ, ಊರಲ್ಲಿ ಇಲ್ವಾ?
ಅವ್ರನ್ನ ಫ್ಯಾಮಿಲಿ ಎಮರ್ಜೆನ್ಸಿ ಬಂತು ಅಂತ ಹೊರಟು.
ಹಾ. And due to family emergency and counsel for the appellant submits that he is ready. And in view of submission of R1 counsel, ಯಾವತ್ ಬರ್ತಾರೆ ಹೇಳಿ?
Next week, my lord. After.
List this matter on 25/10.
Right.
48 urgent, 49 Deepashri, DP Mahesh.
23 ಮತ್ತೊಂದು ಕೇಸು ಯಾವ್ದು ಮಾಡ್ತಾ ಇಲ್ಲ. ಹಾ. 48 ಅರ್ಜೆಂಡಾ? Yes, declaration and injunction. Whether finding of trial court and first appellate court that plaintiff succeeded in establishing title under two successive wills, namely Exhibit P1 and P2, in respect of social properties is contrary to Section 70 of Indian Succession Act. And consequently, impugned judgment and decree would call for interference by restricting plaintiff's claim only under later will Exhibit P2 and not entire social properties. First appellate court erred in deciding validity of Exhibit P1 and P2 without holding proper inquiry as per provisions of Section 75 of Indian Succession Act. Whether both trial court and first appellate court erred in holding registered gift deed executed by plaintiff as invalid without considering that it was 30-year-old document and entitled for presumption under provisions of Indian Evidence Act. Yes, madam, ಹೇಳಿ. Other side are ilva?
DP Mahesh.
ಇದ್ರ ಮಾರ್ನಿಂಗ್ ಇದ್ರ?
ಬೆಳಗ್ಗೆ ಇದ್ರು.
ಪಾಸ್ ಓವರ್ ಮಾಡ್ಲಾ ಏನು?
ಮಾಡಿ ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
ಶಿವಶಂಕರ್ ಕೆ ಅಮರ್ ಗೌಡ
ಜೂನಿಯರ್ ಬಂದಿದ್ರು. ಜೂನಿಯರ್ ಬಂದಿದ್ರು. ಜೂನಿಯರ್ ಬಂದಿದ್ರು ಬೆಳಗ್ಗೆ.
ಇಲ್ಲ ಒಂದು ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀನಿ ನೋಡೋಣ. ತೊಗೊಳ್ಳಿ.
ಯಾವ್ದು ದಿನ ಕಮ್ಮಿ ಇದೆಯೋ ಅವತ್ತಿನ ಕೊಟ್ಬಿಡಿ. ಯಾಕಂದ್ರೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ರೆಡಿ ಇದ್ದೀನಿ.
ಆಯ್ತು. ಅಪಲೆಂಟ್ ಕೌನ್ಸಿಲ್ is present and counsel for respondent is absent. If respondent counsel doesn't appear in the next date of hearing, the matter will be heard in the absence of the respondent counsel. List this matter on. ಕೊಡಿ ಮೇಡಮ್. ಎಲ್ಲ ಅಡ್ಮಿಷನ್ಸ್ ಇರುತ್ತೆ, ಕಡಿಮೆ ಅಂತ ಇರೋದಿಲ್ಲ.
25th ಶನಿವಾರ
30/10.
25
ಆಗ್ಬೋದಾ?
ಶನಿವಾರ ಐ ಆಮ್ ರೆಡಿ.
ಆಯ್ತು. 25
ಜಾಸ್ತಿ ಇರಲ್ಲ ಅಂತ ಅನ್ಕೊಂಡಿದ್ದೀನಿ.
50 ಶಿವಶಂಕರ್ ಕೆ ಅಮರ್ ಗೌಡ.
That's defendant second appeal. Suit for declaration and injunction.
ಇದು ಅಷ್ಟೇನಾ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್?
ಅವ್ರದ್ದೇನಿಲ್ಲ. ಲೆಟ್ಸ್ ಎನಿಯೋ ಐ ವಿಲ್ ಅಡ್ರೆಸ್ ದಿ ಆರ್ಗ್ಯುಮೆಂಟ್. ನಾನು ಮಾಡ್ತೀನಿ.
ಅಲ್ಲ ನೀವು ಮಾಡ್ತೀರಿ, ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಬೇಕಲ್ಲ.
ಅವ್ರು ಫೋನ್ ಮಾಡಿದ್ದೆ, ಕೊಲೀಗ್ ಇದಾರಂತೆ, ಬರ್ತಾರಂತೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಅಬ್ಸೆಂಟ್.
ಸುಮಾರು ಬರ್ತಾನೆ ಇಲ್ಲ.
ಹರ್ಡ್ ಸಿ ಕೇಸ್ ಕರ್ದಿ ಅಪಲೆಂಟ್ ಅಲ್ಲ ರೀ, ಇವ್ರು ಹರ್ಡ್ ಅಂತ ಮಾಡಿದ್ಮೇಲೆ ಪಾರ್ಟ್ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ? ಟು ಹಿಯರ್ ಸಿ ಕೇಸ್ ಅಮರಗೌಡ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದಿ ರೆಸ್ಪಾನ್ಸ್. ಹಿಂದಿನ ಬೆಂಚ್ ಮುಂದೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದೀರಾ ನೀವು?
ಮಾಡಿದ್ವಿ. ಬರ್ಲಿಲ್ಲ.
ಸೆಪ್ಟೆಂಬರ್ 25 ಅಂತ ಬರೀತಾರೆ. ಪಾರ್ಟ್ ಮಾಡ್ಕೊಡ್ಬೇಕಾಗ ಹರ್ಡ್ ಅಂದ್ರೆ
ಪೂರ್ತಿ ಕೇಳಲಿಲ್ಲ, ಸ್ವಲ್ಪ ಕೇಳಿದ್ರೆ ಆಯ್ತು.
ಫಾರ್ ವಾಂಟ್ ಆಫ್ ಟೈಮ್ ನಾವೇನೋ ಅರ್ಜೆಂಟ್ ಮಾಡಿದ್ವಿ ಅರ್ಲಿಯರ್. ನನ್ನ ಅಪಿಯರ್ಸ್ ಫಾರ್ ದಿ ಅಪಲೆಂಟ್ ಅರ್ಲಿಯರ್.
ಅದಕ್ಕೆ ಮುಂಚೆನೂ ನಾಟ್ ಅಪಿಯರ್ಡ್.
ಏನು ಇಶ್ಯೂ ಏನು?
ಇಶ್ಯೂ ಲೆಟ್ಸ್ 20 ಗುಂಟಾಸ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್.
ನೀವು ಮಾಡಿದ್ರೆ ಅವರು ಮಾಡಿದ್ರೆ ಕೇಳ್ಬೋದು ನಾವು. ಸುಮ್ಮನೆ ಈಗ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಇದಾಗ್ತದೆ.
ಏನಿಲ್ಲ, ಸಿಂಪಲ್ ಕ್ವಶನ್. ಲೆಟ್ಸ್ 20 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ 2004 ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ. ನಮಗೆ 59/16 ನಲ್ಲಿ ನಮಗೆ ಗ್ರಾಂಟ್ ಆಗಿದೆ 2 acres ಆಫ್ ಲ್ಯಾಂಡ್. ಈ 20 ನಲ್ಲಿ ಲೆಟ್ಸ್ ಇನ್ ಇಯರ್ 2004 ಅಲ್ಲಿ ನಮಗೆ ಏನ್ 2 acres ಗ್ರಾಂಟ್ ಆಗಿತ್ತು ಅದರಲ್ಲೇ 20 ಗುಂಟಾಸ್ ಅನ್ನ ಫ್ರಾಡ್ ಮಾಡಿ ಗ್ರಾಂಟ್ ಮಾಡಿದ್ರು. Subsequent ಆಗಿ ಅವ್ರು ಇಂಟರ್ಫಿಯರ್ ಆದಾಗ suit came to be filed. The respondent filed the suit for declaration and injunction on the basis of the fabricated and created grant records. Trial court ನವರು dismiss ಮಾಡಿದ್ರು. The suit came to be decreed. The finding given by the trial court is suppose in order to find out the property of 20 ಗುಂಟಾಸ್ and 2 ಅದ್ರ ಒಳಗಡೆನೆ 2 ಎಕರೆ ಬರುತ್ತೆ ಅನ್ನೋದಕ್ಕೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಫ್ ಕಮಿಷನರ್ ನ ಏನು ಮಾಡಲಿಲ್ಲ. Defendants have failed to establish that 20 guntals of land which comes within 2 acres of land anta that is the finding, and suit came to be declared our grant records mele. Appeal allu ಒಂದು application ಹಾಕಿದ್ವಿ immediately minutes and the appeal has been filed. filed an application for appointment of commissioner, whether 20 guntas comes within 2 acres of land anta. But ಅವರು ಅಪ್ಲಿಕೇಶನ್ ನೋಡ್ಲಿಲ್ಲ, ಅಪ್ಲಿಕೇಶನ್ ನೋಡಿದ್ರೆ ಡಿಪೆಂಡೆಂಟ್ಸ್ once again failed to establish that with regard to identity of the property ಅಂತ ಹೇಳಿ appellate court ನಲ್ಲೂ ಕೂಡ the appeal has been dismissed.
Concurrent finding.
Concurrent findings. Earlier, as on the date of filing of the suit, immediately we have questioned the grant before the assistant commissioner. It's a fraudulent grant because there is no 20 guntas of land ಅಂತ DC the assistant commissioner ಮತ್ತೆ cancellation of grant ಗೆ ಒಂದು appeal ಹಾಕಿದ್ವಿ. ಅದು ರೀಸೆಂಟ್ ಆಗಿ ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಈ ಅಪೀಲ್ ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾದ್ರೆ ಅದು ಅಡಿಷನಲ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದೀನಿ. ಅಲ್ಲೇನ್ ಮಾಡಿದ್ದಾರೆ, ಫ್ರಾಡ್ ಮಾಡಿ ನಮ್ಮ ಸ್ಕೆಚ್ ನ ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ಎರಡು
ಏನಾಯ್ತು ನಿಮ್ಮ ಅಪೀಲ್?
ಅಲ್ಲಿ ಅಲೌಡ್, ಅಪೀಲ್ ಹಸ್ ಬಿನ್ ಅಲೌಡ್ ಅಂಡ್ ದಿ ಅಸಿಸ್ಟೆಂಟ್
ಗ್ರಾಂಟ್ ಕ್ಯಾನ್ಸಲ್ ಆಯ್ತು,
ಗ್ರಾಂಟ್ ಹಸ್ ಬಿನ್ ಕ್ಯಾನ್ಸಲ್ಡ್. ಅಲ್ಲೇನ್ ಹೇಳೋದು, ಅಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಈ ನಮ್ಮ ಸ್ಕೆಚ್ ನ ಎರಡನ್ನೂ ಸೇರಿ ಫೋಟೋಗಳೊಂದು ಫೋಟೋ ಕೂಡ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. ಸ್ಕ್ಯಾನ್ ಮಾಡಿಬಿಟ್ಟು ಒಂದು ಫ್ರಾಡ್ ಮಾಡಿ ಆ 20 ಗುಂಟಾಸ್ ಇಲ್ಲೇ ನಮ್ಮದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಅಂತ ಒಂದು ಸ್ಕೆಚ್ ಎಲ್ಲ ತೋರಿಸಿ fraud grant ಮಾಡಿದ್ದಾರೆ. Therefore, Your Honor, that the grant has been cancelled. Assistant Commissioner has cancelled the grant. No, there is no property at all.
Cancellation ಮೇಲೆ ಅವರನ್ನು ಅಪೀಲ್ ಹೋದ್ರ?
ಅದು ಸದ್ಯಕ್ಕೆ ಇನ್ನೂ ಹೋಗಿಲ್ಲ. ಅದು ಆರ್ಡರ್ ಆಗಿದ್ದು 21/8/24 ಸ್ಟಿಲ್ ನೋ ಅಪೀಲ್. 21/8/24
ಇದುವರೆಗೂ ಹಾಕಿಲ್ಲ,
ಇದುವರೆಗೂ ಅಪೀಲ್ ಹಾಕಿಲ್ಲ DC ಮುಂದೆ.
ಬಟ್ ಅವ್ರ ಕ್ಯಾನ್ಸಲೇಷನ್ ಗಿಂತ ಮುಂಚೆ ಅವರು ಅಪಿಯರ್ ಆಗಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
ಅಪಿಯರ್ ಆಫ್ಟರ್ ಕಂಟೆಸ್ಟ್. ಆಫ್ಟರ್ ಕಂಟೆಸ್ಟ್ ದಿ ಆರ್ಡರ್ ಕೇಮ್ ಟು ಬಿ ಪಾಸ್ಡ್ ಬೈ ದಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್. ಎರಡು ಫೋಟೋನು ಹಾಕಿದ್ದಾರೆ, ಸ್ಕ್ಯಾನ್ ಮಾಡಿ ಹೆಂಗೆ ಅಫಿಕ್ಸ್ ಮಾಡಿ ಸ್ಕೆಚ್ ಮಾಡಿ ಗ್ರಾಂಟ್ ಮಾಡಿ.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಕಮ್ಸ್ ಟು ದ ಕನ್ಕ್ಲೂಷನ್ ದಟ್ ಆ ಏರಿಯಾದೊಳಗೆ ಬರುತ್ತೆ ಅಂತ.
ನಮ್ 2 acres ಅಲ್ಲೇ ಬರುತ್ತೆ, 20 ಗುಂಟಾಸ್ ಆಫ್ ಲ್ಯಾಂಡ್ ಇಲ್ಲ ಅಂತ.
ಲ್ಯಾಂಡ್ ಇಸ್ ನಾಟ್ ಇನ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್.
ನಾಟ್ ಇನ್ ಎಕ್ಸಿಸ್ಟೆನ್ಸ್ 20 ಗುಂಟಾಸ್. So in view of the findings, the assistant commissioner as well as the both the courts have
ಅಷ್ಟೇ ಇಶ್ಯೂ
ಅಷ್ಟೇ
heard of the appellant counsel, heard in part ಅಂತ ಮಾಡಿ. Respondent counsel is absent and hence an opportunity is given to the respondent counsel, and if respondent counsel doesn't appear, matter will be disposed of in his absence. The records also discloses that the respondent counsel was absent on 10/9/25 also. List this matter day after tomorrow. 17/10.
Desai Rajendra Chandrasekhar, Umashankar.
Please, Madam. I'm appealing for the respondents, Madam.
Yes, counsel.
In the morning, Madam, it was mentioned that no copy of the appeal was heard on us, Madam. So they were advised to verify whether any copy is served on the respondents or not, Madam. They were asked to produce acknowledgement, Madam.
Sir, you are appearing for whom?
I'm appealing for the respondents, Madam.
For appellants, my lords, they are for respondents.
They are respondents.
Yes, my lords. My lords, copy ಕೊಟ್ಟಿಲ್ಲ ಅಂತ.
ನೀವೇನ ಕಾಪಿ ಬೆಳಗ್ಗೆನ ಯಾರು ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಕೇಳಿದ್ರಾ?
ಅವರು ಕೇಳಿದ್ರು, ರೆಸ್ಪಾಂಡೆಂಟ್ ಕೇಳಿದ್ರು, my lords. Now will serve the copy, my lords. It was served. Acknowledgement ಇಲ್ಲ, my lords. It was served in the year 2022, my lords.
22 ಆದ್ರೂನು ಆಯ್ತು, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ.
Acknowledgement ಇಲ್ಲ, my lords, not available. ನಾನು ಇನ್ನೊಂದು ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ತೀನಿ, my lords. Along paper book ಸರ್ವ್ ಮಾಡ್ತೀನಿ.
Third, respondent counsel submits that copy of the appeal memo is not served, and so also the paper book, and counsel for the appellant would submit that going to serve the copy of the appeal memo and also the paper book forthwith. List this matter on 30/10.
Please,
ಮತ್ತೆ ಅವತ್ತು ಇದೆ ಅದೇ ಗ್ರೌಂಡ್ ಮೇಲೆ ಕೇಳಂಗಿಲ್ಲ.
Please, Madam.
ಕೇಳಂಗಿಲ್ಲ ಮತ್ತೆ ಇಬ್ರುನು.
We won't seek any adjournment, Madam. Obliged, Madam. Much obliged.
Yes. Yeshu Baba or Bishra.
Your Lordship, I appear for the appellant.
ಹೇಳಿ.
Your Lordship, senior had to leave due to a personal inconvenience, my Lord. I have informed the opposite party. If my Lords may kindly have it tomorrow or day after
Counsel,
tomorrow.
you cannot inform without the permission of the court to other side.
Immediately.
ಇರೋದೇ ಇದೊಂದು ಕೇಸ್ ಈಗ ಹಿಯರ್ ಮಾಡಕ್ಕೆ.
Immediately after a senior left, we.
Here is your senior now.
Due to personal inconvenience.
What is that personal inconvenience?
The senior had to leave, my Lords. He was in the.
What is that personal inconvenience, counsel?
I am unaware of the inconvenience.
Then
I was informed.
I am going to dismiss this RSA. That's all. Even 3:30 also, your counsel is not ready to argue the matter.
If my Lords may kindly have it tomorrow, my Lords, or day after tomorrow, my Lords.
Request of both relist on 23/9/25 earlier also. But time ಕೇಳೋದ್ ಬಿಟ್ರೆ ಇನ್ನೇನೇ ಇಲ್ಲ, ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಅದು ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಗಳಲ್ಲಿ. Yeshubaba Mishra seeks time on the ground of 11th on 29/7/25.
He was present on the day. He was present before the court on the day.
ಯಾವಾಗ 11th ಮೇಲೆ ಜುಲೈ ನಲ್ಲಿ ಟೈಮ್ ಕೇಳಿದಿರಿ, ಆಮೇಲೆ 28/25 4/9/25
Senior.
I am for the respondent.
ಹಾ ನೀವು ರೆಡಿ ಇದೀರಾ ಇವತ್ತು?
ಇಲ್ಲ ಸರ್, ಅವರು ಅದೇನೋ ಮಾರ್ನಿಂಗ್ ಹೇಳಿದ್ರು ಸೊ
ಏನಂತ?
ಅದಕ್ಕನ ಅಡ್ಜರ್ಮೆಂಟ್ ಅಂತ ಹೇಳಿ.
ನೀವು ರೆಡಿ ಇದೀರಾ?
ರೆಡಿ.
ನಿಮ್ಮನ್ನ ಕೇಳ್ತೀನಿ ಬರಿತೀನಿ ಅಷ್ಟೇ. ಅವ್ರು ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ನಾವೇನ್ ಮಾಡೋಣ? Otherwise I have to rise at 3:30. ನೋ ಕೇಸ್, ಈಗ ಲಾಸ್ಟ್ ಕೇಸ್ ಉಳಿದಿರೋದು ಅಷ್ಟೇ ಅಲ್ಲ ಮೇಡಮ್? ಇನ್ನೊಂದು ಯಾವ್ದಿದೆ ಪಾಸ್ ಅವರು? 38 ಕಲಿಮುಲ್ಲಾ ಶರೀಫ್. ಅವರು ಬರಲ್ಲ, ಅವ್ರು ಬೆಳಗ್ಗೆ ಟೈಮ್ ಕೇಳಿರು ಬಂದಾರಲ್ಲ. ಹಾ, ಅದು ಓನ್ಲಿ ಅಡ್ಮಿಷನ್. ಅಡ್ಮಿಷನ್ ವಿಲ್ ಟೇಕ್ 10-15 minutes. ಹಾ ಹಾ
23rd.
ಅಲ್ಲ ರೀ, 10 ಮ್ಯಾಟ್ರ್ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಲಿಸ್ಟ್ ಮಾಡಿದ್ರೆ ಒಂದ್ ಕೇಸಲ್ಲೂ ಲಾಯರ್ಸ್ ಗಳು ಅಸಿಸ್ಟ್ ಮಾಡಲ್ಲ. ಏನ್ ಮಾಡ್ಬೇಕು?
ಅಸಿಸ್ಟ್ ಮಾಡಿ. ಸಾರಿ ಅವರು ಮಾರ್ನಿಂಗ್ ವರ್ಗೂ ಇಲ್ಲೇ ಇದೆ ಅವರು.
Senior was here in the morning, my lords. He had to leave in the afternoon, so I immediately informed that senior is also.
Senior ಡೆಸಿಗ್ನೇಟೆಡ್ ಅಪಿಯರ್ ಆಗಿದ್ರು. ಇವರು ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಳ್ತೀನಿ ಅಂದಾಗ ನಾನು
My lords, on the last occasion.
Have it on 23rd.
Third, appellant counsel seeks time on the ground that due to inconvenience on the senior counsel, he left the
Senior
premises. ಅದೇ senior ಹೇಳ್ತಾ ಇರೋದು. Senior premises. ಏನು court premises. And counsel for the respondent is present. List this matter. No adjournment will be given in the next date of hearing. List this matter on 25/10.
Grateful, my lords.
25/10 August Saturday. Is very come.
ಕಲಿಮುಲ್ಲಾ ಶರೀಫ್ ಬಂದ್ರಾ? ಕರೀರಿ. ಏನ್ರಿ ಅದು ಅಡ್ಮಿಷನ್ಗೆ ಸೀರಿ ನಂಬರ್ ಎಷ್ಟು ಮೇಡಮ್? 38. ಹಾ ಹೇಳಿ ಏನ್?
Concurrent pending, the plaintiff's appeal, my lord. The land in question, my lord, it is granted land to the grandfather of the petitioner, appellant, my lord. The proprietor of the land, he has got 3 sons, my lord, namely Hanuma Bhavi, Dodda Timma Bhavi, and Sanna Timma Bhavi. Sanna Timma Bhavi is the father of the appellant hearing, my lord.
ನಿಮ್ ಕೇಸು ಸೇಲ್ ಡೀಡ್ ಡೇಟೆಡ್ 8/12/2010 executed by defendant number 1 in favor of defendant number 2 is null and void.
Null and void
and not binding on the plaintiff.
Yes, madam.
ಹೌದಾ?
ಹೌದು.
ಹಾ.
Because my lord,
defendant number 2 proves that the suitable property belong to Sanna Timma Bhavi, and for legal necessity and for the benefit of family he sold the suit property to the defendant number 3 through registered seal dated 21/5/1973.
My case is
defendant number 3 sold the scheduled property to defendant number 1, and in turn the defendant number 1 sold the scheduled property to defendant number 2 through a registered sale deed dated 8/12/2010. 1973 ಇಂದಲ್ಲ ಸೇಲ್ ಟ್ರಾನ್ಸಾಕ್ಷನ್ಸ್ ಆಗಿದೆ ಅಲ್ರಿ?
73 ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆ.
ಹಾ, ಮತ್ತೆ
again I am not a party.
Defendant number 2 proves that he is the bona fide purchaser of the suitable property, whether plaintiff is entitled for relief of declaration and also the relief of possession of the suitable property from defendant number 2.
But as on the date of my sale, he was a minor, my lord, age of 7 years. It is an ancestral property that belongs to his grandfather. He was not a, it was not by the benefit of the family, it was sold, my lord.
ಯಾವಾಗ ಸೇಲ್ ಆಗಿದ್ದು?
73 first sale.
73. What was his age?
Pardon, my lord?
What was his age?
Date 21/5/73.
Alla 21/5/73. What was the age of the plaintiff?
7 years.
7 years. When he attains the majority?
Date of his majority.
73 ಅಂದ್ರೆ ಅವಾಗ 7.
73.
ನೆಕ್ಸ್ಟ್ 11 ವರ್ಷ.
11 ವರ್ಷ.
ಅಲ್ಲಿಗೆ
84
ಗೆ
85.
Then why he has not questioned the sale deed?
But he was
after attaining the majority.
But he was not in the village, but he was at Bangalore, but he was not aware.
Filed in 2013.
He was not aware of these proceedings, my lord. Immediately when he came to know and the change of entries, my lord, he filed a petition before the assistant commissioner. Assistant commissioner rejected the on the ground that the sale deed cannot be set aside by the revenue courts.
ನಾಲ್ಕು ಜನಕ್ಕೆ ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲ ಎಕ್ಸ್ಚೇಂಜ್ ಆಗಿದೆ.
3 ಜನಕ್ಕೆ ಎಕ್ಸ್ಚೇಂಜ್ ಆಗಿದೆ.
ಮತ್ತೆ
ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಥರ್ಡ್.
ಫಸ್ಟ್ ಸೇಲ್ ಡೀಡ್ ಆಗಿದ್ದು 73,
ಸೆಕೆಂಡ್
ಆಮೇಲೆ 3 ಸೇಲ್ ಡೀಡ್ ಆಯ್ತು.
ಸೆಕೆಂಡ್ 2011-75 ಅಲ್ಲಿ ಆಗಿದೆ. ಆಮೇಲೆ ಥರ್ಡ್ 18/8/12/20 2010.
The original sale deed is also marked as exhibit P2. Further, ನೋಡಿ ನಿಮ್ಮವನು ಬಹಳ ಬುದ್ಧಿವಂತಿಕೆಯಲ್ಲಿ ಮಾಡವನೆ. In the cross examination 19, he has categorically admitted the pendency of OS number 280-38 of 13, which was filed by him against his cousin brothers for partition and separate possession. Further admitted that in that suit, the present suit property is not been included.
ಅದು ಇನ್ಕ್ಲೂಡ್ ಮಾಡಿಲ್ಲ ಅದನ್ನ.
ಮಾಡಿಲ್ಲ.
ಅದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ if that suit property is joint family property of plaintiff, then why he has not included the present suit property in that suit not explained. Admittedly, OS number 213 is earlier. The present suit, hence the has to explain as to why he has not. Order 2 Rule 2 also discussed. Age of the plaintiff, this court already concluded that at the time of sale transaction, the age of the minor, ಬರ್ಬಿಟ್ಟಾರ ನೋಡ್ರಿ para 18 ಅಲ್ಲಿ. Situation and his family the same on the sale transaction, the said fact has not explained by plaintiff. Further, plaintiff has not made another vendor of defendant number 3, that is Venkata Bovi, as party to the suit. He is the proper person to explain about the situation of the family. The first place sale transaction was taken place between themselves and the third defendant. Further, PW 2 and 3 are also pleaded ignorance in the cross examination about the family affairs of the plaintiff in the year 1973. Therefore, the contents of exhibit D14 as well as D4 makes important role to consider the legal necessity and family necessity of the Sanna Timma Bovi. The recital of exhibit D4 is clear that to repay the hand loan of father of plaintiff, the suit property was sold. The cross examination of DW1 is clearly goes to show that his family was not in well position at that time. Plaintiff has not produced any document to show that at the time of their joint family has got sufficient income. Hence answered the issue is negative. ಏನಿಲ್ಲ. Even a first appellate court also in paragraph number 17, 18 in detail discussed. ಇಬ್ರು ಅಪ್ಲೈ ಮಾಡಿದಾರೆ ಮೈಂಡ್.
The only thing is, he has not obtained any permission or order from the court to with regard to the property of the minor malad under
even if it is not
Hindu Minority and Guardianship Act.
ಆಯ್ತು ತಗೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು? ನೀವೇ ಮಾಡ್ಬೇಕು, ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಸೂಟ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಮಾಡ್ಲಿಲ್ಲ.
ಅದು ಸೇಲ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಾಗಿರ್ಲಿಲ್ಲ, ಆಮೇಲೆ ಗೊತ್ತಾಗಿ ಎಲ್ಲ ಕಮೆಂಟ್ಸ್ ಮಾಡಿದ್ದು.
ನೋಡ್ರಿ, ಪ್ರಾಪರ್ಟಿ ಕೈತಪ್ಪ ಹೋಗಿದೆ ಅಂದ್ರೆ ಫ್ಯಾಮಿಲಿ ಆ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತಂದ್ರೆ that itself is a notice to the whole world. If they are in possession, then your argument can be considered. Once the possession is parted with, that argument cannot be accepted. Third, this matter is listed for admission and I heard the counsel appearing for the appellant. This second appeal is filed against the concurrent finding. The factual matrix of case of the plaintiff in OS number 239 of 13, while seeking the relief of The possession and also the sale deed dated 8/12/2010 is not binding on the plaintiff. It is pleaded that propositor of one Hanumanta Bovi was having 3 children by name Hanumanta Bovi, Dodda Timma Bovi, and father of the plaintiff by name Sanna Timma Bovi. There was no division in the family of said Hanumanta Bovi, and the 3 sons of said Hanumanta Bovi were died long back. Full stop. The Venkata Bovi who is the son of Hanumanta Bovi. Hanumanta Bovi ಯಾರು ಇಲ್ಲ ಅಲ್ರಿ ವೆಂಕಟ ಬೋವಿ ಅಂತ.
ಹನುಮಂತ ಬೋವಿ ಫಸ್ಟ್ ಸನ್ ಆಫ್ ದಿ ಇವ್ರದ್ದು ಅವ್ರಿಗೆ ಅವ್ರ ಫಸ್ಟ್ ಸನ್.
ಅದು ಹನುಮಂತ ಬೋವಿ ವಾಸ್ ಹ್ಯಾವಿಂಗ್ 3
ಅಲ್ಲ
children.
ಹನುಮಂತ ಬೋವಿ ಅವರ ಮಗನ ಹೆಸರು ಹನುಮಂತ ಬೋವಿನೇ.
ಬೋವಿನೇ
ಹೌದು.
ಮತ್ತೆ ವೆಂಕಟ ಬೋವಿ ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ಲಿ?
ವೆಂಕಟ ಬೋವಿ ಹನುಮಂತ ಬೋವಿ ಮಗ. ಹಾಗಾದ್ರೆ ಪ್ರಪೋಸಿಟರ್ಸ್ ಮೊಮ್ಮಗ.
ಮೊಮ್ಮಗ.
ಹೌದು.
ನಂಗೆ ಹೇಳಿ ಏನಾಯ್ತು ಹೇಳಿ. ವೆಂಕಟ ಬೋವಿ ಹೂ ಇಸ್ ದಿ
ಸನ್ ಆಫ್
ಹನುಮಂತ ಬೋವಿ, ಸನ್ ಆಫ್ ಹನುಮಂತ ಬೋವಿ.
ಅವ್ರ ತಂದೆ ಹೆಸರು
father of the plaintiff had sold the suit property in the year 1973, that is on 21/5/73, without any legal necessity. In turn, the third defendant in favor of third defendant banta madam. Third. In turn, the third defendant had sold the suit shell property to the father of the first defendant on ಮತ್ತೆ ಅದೇ ಅಂಗ್ರಿ ಆಗುತ್ತೆ ಮತ್ತೊಂದ್ ಸರಿ ಅದೇ ಸೇಮ್ ಡೇಟ್
8/12 ಆಗುತ್ತೆ. ಇಲ್ಲ ಅದೇ ಡೇಟ್ ರಾಂಗ್ ಹಾಕಿದೆ ಅದು.
ಸೇಮ್ ಡೇಟ್ ಅಲ್ಲ?
ಹೌದು.
ಬೇರೆ ಡೇಟ್ ಇಲ್ಲಿದೆಯಲ್ಲ. D3 sold the property to the defendant number 1 and defendant number
21/11/75.
defendant number 1 sold the suit property to the second defendant through registered sale deed dated 8/12/2010.
ಅದಕ್ಕೆ ಮುಂಚೆ ಸೆಕೆಂಡ್ ಸೈಡ್ 21/11/75 D5.
ಅದೇ D5 21/11. ಅದೇ D3 sold the property in favor of D1 on
21/11/75.
As per exhibit
D5.
The D1 sold the property in favor of D2 on 8/2/2010. It is the contention of the plaintiff in the suit that he was a minor at the time of first sale and he was aged about 7 years. And subsequently, when he came to know about the subsequent sale deed in favor of D1 in favor of D2 on 8/12/2010, comes to know about the same. The defendant number 2 in his.
I'm sorry for it. It is a granted land matter to SC/ST. There was a prohibition matter for sale. That aspect has not been.
ನಿಮ್ ಪ್ಲೀಡಿಂಗ್ ಅಲ್ವೇ ಇಲ್ವಲ್ಲ ಪ್ಲೀಡಿಂಗ್ ಏನು ಇಲ್ಲ ಪ್ಲೀಡಿಂಗ್ ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ.
But I have taken in my appeal memo.
ಸೆಕೆಂಡ್ ಅಪೀಲ್ ಅಲ್ಲಿ ತಗೊಂಡ್ರೆ ಏನು ಉಪಯೋಗ? ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನು ಇಲ್ಲ. The second defendant took the defense in the written statement that he has purchased the property from D1 and is a bona fide purchaser of the suit property, and also contended that the property was sold in favor of D3 long back in the year 1973. And they said earlier, and the earlier sale deed was not challenged. And only afterthought, the present suit is filed in the year 2013. And hence, not entitled for the relief of declaration and possession. The plaintiff, in order to prove his case, examined himself as PW1 and got marked document exhibit P1 to 17 and got examined 2 witnesses as PW2 and 3. On the other hand, the defendant number 2 himself examined as DW1 and produced exhibit D1 to 11. The trial court, having considered the material available on record, both oral and documentary evidence, comes to the conclusion that The sale was taken place long back in the year 1973. And subsequent sale deed is challenged, which was taken place in 2010. And in between, one more sale deed in the year 1975. And the sale transactions are exchanged between different number 1 to 3 respectively. The trial court also taken note of that at the time of first sale, the plaintiff was aged about 7 years. And he did not challenge immediately after attaining the majority. And also taken note of that the original purchaser, defendant number 3, was not made as party. And who is the person to explain about the situation of the family when the first sale transaction was taken place between themselves and the third defendant. The trial court also taken note of PW 2 and 3 are also pleaded ignorance in the cross examination about the family affairs of the plaintiff in the year 1973. The trial court also taken note of exhibit D4, D14 as well as exhibit D4 with regard to the legal necessity and family benefit of late Sanna Timma Bovi. The recital of exhibit D4 is clear that to repay the hand loan of father of the plaintiff, the suit scheduled property was sold. The cross examination of PW1 is clearly goes to show that his family was not in well position at the time of sale in the year 1973, and also not produced any document to show that at the time of the sale, family was having sufficient income. Apart from that, taken note of the fact that when the plaintiff had filed one more suit against his cousins in OS number 238 of 2013, has not included the present suit scheduled property. And also the said suit was earlier to the present suit. And taken note of order to rule 2 also. And answered the issue number 1 as negative. And also with regard to the additional issue is concerned, same is also answered as negative. Regarding limitation to file the suit by the plaintiff. After framing of this additional issue also, the learned counsel for the plaintiff has submitted no evidence on additional issue. But the DW1 filed is additional examination in chief by way of affidavit. And content that plaintiff is having knowledge about the sale deed 21/5/1973 but not taken any steps within the limitation period. The other issue is with regard to specific defense of the defendant number 2 that he is the bona fide purchaser. Admittedly, the suit property was sold by father of plaintiff and Venka Bovi in favor of father of the plaintiff Venka Bovi in favor of third defendant. And also taken note of
the father of the plaintiff and Venka Bovi.
Father of the plaintiff and Venka Bovi in favor of third defendant. And in turn, sale taken place between defendant number 1 and 2. And having considered all the material, comes to the conclusion that the plaintiff has not made out any case and dismissed the suit. Being agreed by the said order, said judgment and decree of dismissal of the suit, an appeal is filed in RA number 19 of 2020. And appellate court also Having considered the grounds urged in the appeal memo, formulated the point whether the trial court has justified in dismissing the suit and any ground to interfere with findings. And first point for consideration is answered as affirmative that trial court is justified in dismissing the suit. The first appellate court also taken note of the fact that suit is filed after a lapse of 40 years. And also taken note of property was exchanged between the defendant number 1, defendant number 2 and defendant number 3 during this period. And also taken note of the fact that plaintiff was aged about 7 years at the time of the sale, and in detail discussed the evidence of the plaintiff as well as DW1 while reappreciating the material available on record from paragraph number 15 to 17. And also PW1 categorically admitted that their family was under financial crisis. And PW2 and 3 have deposed ignorance for the said suggest to the financial capacity, financial condition of the family of the plaintiff. And appellate court also taken note of the discussion made by the trial court with regard to the earlier suit filed by the plaintiff against his cousins and not included the social property. Even appellate court also in detail discussed with regard to the plaintiff is residing at Bangalore in paragraph number 18. And both oral and documentary evidence available on record was considered by the appellate court and dismissed this first appeal. Being agreed by, the concurrent finding present second appeal is filed and counsel appearing for the appellant would vehemently contend that both the courts were not justified in dismissing the suit as well as the appeal. And without noticing that the suit scheduled land is a granted land under Darkas with a condition of permanent non-alienation, committed an error. Having heard the appellant counsel and also the reasoning assigned by the trial court, and when the suit is filed for the relief of sale deed is null and void, executed in favor of defendant number 2 by defendant number 1 and sought for possession, and the material available on record, it is very clear that first sale was made in the year 1973. The present suit is filed after lapse of 40 years. And in the meanwhile, from 1973 to 2012, 2 sales are taken place between the parties, that is in favor of D3, and D3 in turn sold the property in favor of defendant number 1 in the year 1975 itself. And also the D1 sold the property in favor of defendant number 2 in the year 2010, having enjoyed the property for more than 35 years. It is very clear that property is not with the possession of the family from 1973. And also it is emerged during the course of evidence that at the time of first sale in the year 1973, he was aged about 7 years. But immediately after attaining the majority, he did not question the sale deed of 1973 as well as 1975 when he attained the majority in the year 1984 itself. But he kept quiet till taking of the subsequent sale deed in favor of defendant number 2 by the defendant number 1. And suddenly he filed a suit to declare the subsequent sale deed as null and void and not binding on him. And both the trial court as well as appellate court taken note of wherein he has categorically admitted that his father was having very difficulty for his food and cloth. And the same is taken note of by the trial court in paragraph number 14. And also the financial condition was admitted. When such being the case, when sale was made long back, and trial court also in detail discussed not only with regard to his age and not challenging the sale deed immediately, and also admission on the part of PW1 that family was under financial constraints. That is his father in the year 1973. And also when the suit was filed by him in OS number 238 of 2013, not included the present social property, but only afterthought, after filing of the said suit, the present suit is filed. And in detail, trial court as well as first appellate court considered both oral and documentary evidence available on record. And even appellate court also in detail discussed the both oral and documentary evidence available on record from paragraph number 15 to 20. And this court did not find any, this court do not find any perversity in the finding of the trial court as well as appellate court on the question of fact and also on the question of law regarding limitation also. And when such being the case, I do not find
no pleading we got to grant in the
the counsel during the course of argument also would contend that family property is a granted property. And to that effect also there was no any pleadings and also not placed any documentary proof before this court to substantiate his contention and the same is raised at the first instance before the second appeal. And hence the same also involves factual finding. And hence question of invoking section 100 of CPC doesn't arise. In view of the discussion made up, I pass the file. And hence no ground is made out to admit and frame substantive question of law. In view of the discussions made up, I pass the file. Second appeal is dismissed.
ಕೊಟ್ಬಿಡ್ತಾರೆ ನಾನು ಬೇಕು ಸ್ಟಡಿ ಆಗ್ಬೇಕಲ್ವಾ ಅಲ್ಲ ಬೇಗ ಹೋಗ್ಬಿಟ್ರೆ ಇಲ್ಲ ನಮ್ಮ ಮುಂದೆ ಕಡಿಮೆನೆ